Good morning, everyone. We're going to go ahead and get started. Okay. Good morning. Thank you all for being here. My name is Ben Scott. I'm currently the Special Features Editor for Volume 114 of the Kentucky Law Journal. And it is my pleasure to welcome you all to the 2025 Fall Symposium, Immigration Law in Kentucky and the United States, a current discussion on immigrants' legal landscape. I'm extremely proud to stand here today and introduce an immigration-themed symposium. This is a practice area in need of more attorneys, especially in Kentucky. Thousands of people are affected by the immigration system's current state of flux, which creates uncertainty for a lot of people and families nationwide. That's why discussions like the ones that you all will hear today are essential. Not everyone speaking today initially planned to work in immigration law, but they've all come to realize its value to the residents of our country, both citizens and non-citizens alike. I guarantee you will see the passion for this field through each of our panelists' work and research that will be presented today. And my hope is that you will all leave today with the realization that advocating in this field is good for everyone. I have more thank yous than I can possibly give in the amount of time that I have remaining this morning, but I am going to give it my best. First, to our panelists, thank you all, both in person and virtual, for taking the time to make this symposium a priority. Each of you are working long hours in your own practices, but still agreed to participate today. Even the smaller tasks, like taking additional time to meet with our moderators, it shows that you care. And we greatly appreciate that. And I know that we will all benefit greatly from your insight and experience as a result. Next, I want to thank the UK Rosenberg faculty and staff. Our law school's front office is run by a phenomenal team on many fronts. Every detail of today, from coordinating parking all the way to travel arrangements, none of it would have been possible without their help. So thank you all. I also want to thank Professor Matthew Bowes, who you all will have the pleasure of hearing as a panelist here momentarily. He agreed back in February to be our faculty liaison for this event. And I definitely can't thank him enough for all of his guidance and support in terms of the key decisions that he helped decide on, and just all the general life support he's given, life advice he's given as well. And then finally, thank you to my KLJ editorial board members, specifically Josh Wetzel, Matt Cheney, Ben Watley, and Casey Parker Bell. You all have been an amazing team, and it has been an incredible time working with you all. Lastly, my committee, thank you all for all of your help. This has been such a fun experience, and all of your efforts today have made today possible and will be a great success. So without further ado, thank you to everyone again for being here, and I would like to introduce Rosenberg Law's Dean, Mr. James Duff. Thank you.
Thank you, Ben. Sir, this is yours.
Yep.
Thank you very much, Ben, and welcome everyone to this very inspired and important symposium on immigration law in Kentucky and the United States. Every school day morning at about exactly this time, from 1959 to 1965, I began the day with my classmates reciting the Pledge of Allegiance to the flag of the United States of America. And perhaps you did too in your grade school years. And as you recall, our pledge ends with the phrase that in America, we're one nation with liberty and justice for all. For all includes, perhaps especially includes, immigrants. I've worked in our legal system now for 50 years, and two of my very closest friends in the law were Bob Katzman, who became the Chief Judge of the Second Circuit in New York, and Bob Jusium, who is a partner at Fried Frank, also from New York, who's one of America's greatest lawyers. When Bob Katzman was appointed to the Second Circuit in 1999, I inherited his constitutional law class at that time at Georgetown. And when Bob began serving on the Second Circuit Court of Appeals, he inherited a very minuscule immigration docket. By 2006, however, the Second Circuit's caseload was almost 40% immigration cases. And in a short period of time, between 2006 and 2013, Bob Katzman delivered, and when he delivered a lecture in 2013 at Fordham Law School in New York, much like today's lecture here, the Second Circuit had adjudicated over 16,000 immigration cases in that short period of time. Bob took note at that time, and has been alluded to, about the importance of this symposium here in Kentucky. But Bob took note at that time at how poor the representation of immigrants was at the time in New York. And he, coupled with Bob Jusium, went to work on that. They did something about it. They established first a study group on immigration representation, and out of that group grew one of the very best organized and effective networks of pro bono representation through the Federal Bar Council, the New York City Bar, the New York State Bar, the New York Lawyers County Association, and the American Immigration Lawyers Association, to address the unmet legal needs in non-citizen communities in our country. My point is simply this: symposia such as this one today are not mere academic exercises. They can and they have done enormous good in very practical ways and have had an important impact on the lives in our communities. I commend greatly Professor Matt Bowes for this symposium and our Kentucky Law Journal for taking on this very important issue. And I think you'll learn a lot today by sitting in these sessions. And I want to welcome all of you to it. Thanks very much for being here. Thank you, Ben.
Okay, well, with that, I want to go ahead and introduce our first panelists, Professor Hiroshi Motomura and Professor Matthew Bowes, and they will be moderated by Will Cox. So we will begin with their panel shortly.
Sorry, had to get the mic going. So as Ben said, my name is Will Cox. I'm a second-year law student here at the University of Kentucky, and thank you all for joining us this morning. We hope today's panel will provide an overview for all of our discussions here today. But before we jump into it first, I will introduce Professor Matthew Bowes, who is an assistant professor of law here at the University of Kentucky. Professor Bowes teaches torts, immigration law, and a seminar on crimmigration. Before joining UK, he was a professor of practice at Washington and Lee and acting director of their Immigrants' Rights Clinic. Before academia, he spent his career advocating for immigrants' rights, representing non-citizens facing detention and deportation before immigration courts, litigating occasionally in U.S. district courts. Professor Bowes earned his JD from Georgetown University Law Center with a certificate in refugees and humanitarian emergencies, and his BA in political science from TCU. His scholarship focuses on the intersection of immigration and criminal law and has been published in the Georgetown Immigration Law Journal, North Carolina Law Review, and the Tennessee Law Review. He brings both litigation experience and deep expertise to today's conversation. We are also deeply honored to welcome Professor Hiroshi Matamura, who joins us today from California. Professor Matamura is currently the Susan Westerberg Prager Distinguished Professor and Faculty Co-Director at the Center for Immigration at UCLA School of Law. A graduate of Yale and UC Berkeley School of Law, he's one of the nation's most influential voices in immigration and citizenship law. Professor Matamura is the award-winning author of Americans in Waiting, Immigration Outside the Law, and, most recently, Borders and Belonging, Toward a Fair Immigration Policy, which is the guidepost for today's conversation. Beyond academia, Professor Matamura has testified before Congress, advised the Obama-Biden transition team on immigration policy, served as co-counsel and consultant in appellate cases, co-founded the Rocky Mountain Immigrant Advocacy Network, and served on the board of the National Immigration Law Center and on the ABA's Commission on Immigration. His scholarship has contributed to how policymakers and people alike understand immigration law at the border and within communities across the country. Relatedly, he is also a host of a podcast called Unsettled: Immigration in Turbulent Times, a podcast that addresses immigration law and policy under the Trump administration. The most recent episode of the podcast focuses on immigration enforcement against Venezuelans, including the assertions of broad membership in Tren de Aragua, a Venezuelan gang, and the invocation of the Alien Enemies Act to send several hundred Venezuelan men from the U.S. to a maximum security prison in El Salvador. But today's conversation will use his book, Borders and Belonging, as a foundation to examine how immigration law operates at the local, state, and federal level, and how questions of humanity and belonging can shape the way we understand and approach immigration policy. Please join me in welcoming Professors Hiroshi Matamura and Matthew Bowes. So today, this panel will focus on 4 key themes drawn from the book: federal, state, and local roles in immigration policy; 2, litigation and legal narratives; 3, birthright citizenship and legalization; and 4, crimmigration, the intersection of criminal enforcement and immigration law. But that's enough of hearing me talk. Professor Matamura, to set the stage, could you share what inspired you to write Borders and Belonging and the audience that you had in mind when writing it?
Yeah, thanks. Is this is not on, or is it on? It's on?
I think it's on.
Okay. Okay. Thanks so much for having me, and really, I really appreciate the opportunity to speak. And it's great to be in this building. I mean, I've been, the last time I was in Lexington, I spoke in the older building, or the old building, or whatever you call it. So anyway, it's really great to see. You know, why did I write the book, right? And the audiences. So as long as, you know, I've been writing about and speaking and, you know, being involved in a lot of activities regarding immigration for many years. And I've always felt that everything I published and everything I said didn't really get at the heart of the matter. It's a confession here that I wrote a book and then immediately said, no, that didn't cover something else that was really important. And the book I wrote before this one ends with a chapter that says, thank you for reading the book, but I haven't talked about what really matters. That's going to be another book, and that is this book. It's a collection. It's not, well, collection makes it sound like it's more scattered than I hope that it is. It's an attempt to address a lot of issues that, frankly, I had to learn about. Because, I mean, just to give you an example, a lot of people talk about addressing the root causes of migration. A lot of people say that, but they don't really talk about what that actually means. And I think it's because immigration involves so many different issues. I've noticed over the years that everyone's in a silo. There's a silo that the lawyers don't talk to sociologists, and the sociologists don't talk to the international development economists, and the academics don't necessarily talk to the activists or the affected communities of all types. And I also find that people don't talk, you know, internationally. Much of the way I wrote the book has to do with different audiences around the world, because I think migration is a huge issue in various forms around the world. And so it's really an attempt to reach out. This gets the audience's question, reach out and say that that we all need to learn to look at this question from another person's perspective. And it could be a different academic discipline. It could be to get out of a political silo or a US-centric silo. And that, so the audiences are, I mean, this is intended to be a book that reaches broadly. I'm not sure you're ever going to find this at an airport bookstore. But I do think that I had a nice thing, student say something nice to me about the book a while, not that long ago, which is that this is a book I would give my grandparents so they can understand the issue. I don't know what that says about grandparents, but or about the book, but it was actually nice to see see that. And so in a cliched sense, I feel like this is the book that I've been writing my whole life. I guess that's a cliche, but that's, I should explain that this cover, that's me in the lower left-hand corner. This was the moment, literally like 2 minutes probably. I mean, I don't remember this thing at all, but it was probably 2 minutes before my mother and I, this is my mother and I saying goodbye to her parents on the boat as just before we literally got on the boat. My father preceded us to America. I was 3 years old, and he basically bought a boat ticket for us to join him. And so in that sense, that's the journey, both personally, but it's also an academic journey as well. And I hope it's a useful frame, because I really appreciate the opportunity for the Law Journal to use this book, because I think it does say it does lay a foundation for a lot of today's. And I think a lot of what we're going to talk about here is going to be to lay the foundation for all the panels.
And if I can just comment on the topic of audience here. So first of all, I want to thank Will for moderating today. Will is also my RA, so we've been working together on immigration law and how it might be affecting the lives of attorneys and others for some time now. So I'm glad to hear, or I was glad to see that he was moderating our panel. I also want to thank Ben for putting together this symposium. I know it's a lot of work, and Casey and others, but Ben is the person that I worked with most, who was a student of mine last year in both of my immigration classes. I do also really quickly want to thank my wife and my 2 kids who are there in the back. I told them that I would identify them, and I'm thrilled that they are here to support me. But I'm most interested in how this book addresses different audiences. So a couple of things to note as background is that this book was actually the book that we used for a new initiative, which was a first-year reading group for our law students. So we had over 30 students sign up who were interested in reading and having this discussion, and many of my first-year students who are here from my towards class actually participated in that. And it led to some really, really fascinating conversations. So it's good that we're having a broader conversation, but it's also a little bit deeper than that. I also, to Professor Montemura's point, want to acknowledge the cross or sort of trans area practitioners versus subject matter area. So we have a lot of people here from other colleges, from social work, my colleagues in geography, history. So I'm really grateful for you all joining us today. I know there's a lot of interest across the university where we're trying to prevent ourselves from being so siloed. And then the final thing I wanted to offer here was, I've been in this position now for a little bit over a year, but previous to that, I taught in a clinical setting, which was essentially teaching students how to represent individuals in legal proceedings. And to that end, I got my training, coincidentally, through the program that Tim Duff mentioned at the top of this lecture, which was something known as the Immigrant Justice Corps. That was at the time in its second year, that was started by the late Judge Katzman. So I wanted to acknowledge, I find that participating in representation is just an incredibly foundational part of the way that I understand this topic. My representation was rooted in people who are in immigration detention, and we're going to be able to talk about that at the end. But I also wanted to acknowledge that even though Professor Montemura has been an academic for many years, that his work has also been grounded in that representation. The Rocky Mountain Immigrant Advocacy Network is just an incredibly foundational group in Colorado, providing representation to those who need it, who would otherwise be unable to afford it. And you'll hear later today from Katie Taylor, who is the lawyer for a nonprofit here in Lexington that is essentially the only operational nonprofit that's providing pro bono services to immigrants. So I'm excited about how this is going to lay the foundation. I just wanted to connect some threads and thank everybody who made this possible.
So to get, for our first topic, what local communities can do in the immigration field. So across Kentucky, local governments have taken different approaches to immigration, some prioritizing what the book describes as inclusionary policies, while others have aligned with more of an enforcement. What are the differences? Because the book lays down sort of the invasion view and the community building view. Could you define that? And then how does that distinction impact local government's immigration policy?
Sure. No, I appreciate the question, and I should explain also that the book went to press around Election Day of last year, and so there are a lot of. I mean, I think the book, has I hope a long shelf life. It was, I knew what the issues were, and regardless of how things have played out in 2025, I think that some of the things have come up in sharper relief in 2025. But I think this is something that I address in chapter 1 of the book, and that is that if we think about the way immigration policy has developed over the last generation, loosely speaking, there's a couple of different views of it that have emerged, and I think that they're really driving, or there's a way to understand politics today. And I think what happened is that we had migration patterns change quite a bit in the world, actually, especially in the 2010s. I mean, loosely speaking, so even 15 years ago, migration's always been, part of human experience. But I think that there's more migration, and I think a lot of people went to countries that really had where people were funneled into asylum as the only way they could seek protection, and I'm going to go through this quickly, but I mean, I could talk more about any of these stages. But the asylum, there became kind of an asylum crisis, and the asylum crisis, you can only get asylum if you apply to inside the United States, and so the asylum crisis became a border crisis. And I think the border crisis and the image of borders being out of control is very much driving the news cycle, say, especially in the year 2015 or so, and on through really the last year to the present day, practically. And so what you had there is that I think you had a real divergence of American opinion here about what exactly immigration policy was about. I think that the view, that pretty much drives what's going on in federal administration right now is what I'm calling the invasion view. And the reason I'm using the word invasion is if you look at all the executive orders that have been issued in 2025, that's the word that keeps being repeated. That immigration represents a form of invasion. I contrast that to a different, and I think that the invasion view really privileges people who are in the country and who feel that they're the ones being protected from invasion. But of course, there are a lot of people in the country who have close ties to newcomers or potential newcomers. And some of those ties are familial, but some of them are because of work and employers. But many of them actually are higher education. I mean, one of the things that's going on right now is one of the big issues is really access of international students to American colleges and universities. Okay, so the two views here, the opposite of what I'm calling the invasion view is more the community building view, and the community building view really puts a lot more decision making in state and local governments, in state and local economies. And it's a very different way of looking at it. It does not necessarily lead to more immigration or to less immigration. It just changes the terms of the conversation, where there's not a big thumb on the scale against, thinking that immigrants are invaders, but instead saying, we're all part of these communities, and let's talk more to each other in a way that doesn't privilege some voices and amplify those voices and silences others. A lot of the book, by the way, is driven by a sense of you can come out to a different outcome, and we're going to disagree about outcome maybe, In fact, I'm sure we will. I think there'll be a robust debate about it, but to try to level the playing field for the conversation, and if nothing else, to have a vocabulary for disagreement, as opposed to the polarization that we have now.
Speaking of amplifying voices, can you all hear my voice?
Doesn't
Not at
cue
all.
up for this.
Is this better? You can hear me? You cannot hear him.
Okay.
Okay, I just want to make sure
repeat,
we
I
get
can
too
repeat
deep.
everything.
Okay, yeah, so we're just going to repeat the last 20 minutes. No, I'm just kidding.
Yeah.
Well,
Next time we're gonna re-record this and lip sync everything.
there we go. Yes, exactly. So we can roll with the punches here. So I do want to comment on what Professor Motomura said about this idea of invasion and the sort of stranglehold that has over two things. One, which is the legal application of immigration law. So right now there are so many different cases that are in litigation that are actually seeking to define whether an invasion has occurred, and because of that, whether a specific executive enforcement action can be taken. So we're going to talk about that in just a moment. But the other aspect of that is this narrative, right? I've heard the Secretary of Homeland Security say every individual here who does not have status is a criminal. And that is the verbiage that's being used. It's invasion, it's criminality, it's this binary of either you're in the community or you're not, when in actuality, many people can exist along a spectrum. And as we've seen, people who were in large categories of lawful status, such as those who had temporary protected status, those who entered on parole, are being subjected or pushed into an illegalized form of status or non-status. So I think it's really important to identify that this idea of invasion actually has specific legal meaning, and that's being used to either permit or not permit executive actions. But beyond that, there is this broad conversation about whether somebody is part of an invasion or whether somebody is a criminal. That's a narrative, and that narrative is, I think, driving perhaps a misunderstanding about who is present, how long they've been here, when, for example, that we know that the average undocumented person has been present in the United States for more than 10 years, right? Or that there's more than 1 million American citizens who are married to people who are undocumented, that there's 10 million US citizens who live with somebody who's undocumented. So I think it's really important to try to have that information when we think about the narrative and whether the narrative is actually doing the work of what we think the facts should be doing on the ground.
And that's the relevance of, the topic in the panel of immigration in Kentucky, because people look different if their statistics inside the Washington D.C. Beltway. That's really quite different from when they're living in the same cities and working.
And on the point of narratives, that brings us right to our second topic for this panel, and it's how those narratives that the book often describes, how that can play out in litigation and influence immigration law and policy. The book frames immigrant rights as a civil rights issue, or at least that's an avenue. How does the civil rights lens affect the way courts, advocates, and the public understand how immigration law should operate going forward? And then what are the shortcomings of that lens?
So there's a chapter 3 really discusses what I loosely call, what Will's question poses, is the civil rights view of immigrants' rights, and it also discusses its shortcomings. So this is a bit of, I suppose, the history of the institutions and history of people who've aligned themselves with support for immigrants. A lot of what I'd loosely call the immigrants' rights movement emerged in the 1970s. And of course, it's been 50 years since then. And a lot of it was really framing the position of not just undocumented people, but also lawful permanent residents in the country as a question of we belong to. We belong also. And then, the whole idea really is that to take some of the vocabulary from a struggle for African Americans for equality in this country and apply it. It could be due process. It could be, contesting things that were thought to be discriminatory. And I think a lot of the ways that the movement developed was we belong to. Because we belong to, often based on the understanding of the history, especially labor policy in this country, there's a sense that the vocabulary of the civil rights movement would emerge and become important. And that's the argument you see, and that's also very resonant in American courts to say that it's equal protection violation, it's a violation of due process, things of that nature. And but let me go back to what I was saying about how a lot of the news cycle shifted from undocumented laborers in Home Depot parking lots in the year 2000 or 2005, and really shifted to people coming in so-called caravans from Central America to the border. I think the civil rights, this goes to your question about the weaknesses. I think the civil rights framing worked a lot better in both in courts and in the public eye for undocumented people who were long-term residents. I think it lost traction when the news cycle shifted to people who were seeking humanitarian protection in this country. And so that's the big shortcoming. I contrast this, by the way, to a lot of what we've seen in Europe and in other parts of the world, where it is not so much a civil rights framing, but really more of a human rights framing, where the politics was driven much more by people seeking humanitarian protection, right? And so this is chapters 2 and 3 in the book, which is that I guess what I loosely call it a human rights framing or a civil rights framing, but I actually deliberately don't call it that because I think that you know, if you use the word human rights, you suggest or refers to a lot of academic debates about what are human rights. It isn't even speaking about rights, very much a certain way of thinking about law. And so I actually call them humanity claims and belonging claims. And humanity claims are claims that I'm enduring something no human being should endure, and belonging claims are claims rooted in some sense that you have some sense of belonging in society. And I use those terms because they're actually much more, I think, universally resonant. I wrote a lot of this book while I was living in Europe, and I think that influenced the way I think about it.
So I think this thread of the humanity claims versus the belonging claims are, you know, two different lenses through which to view this issue that are, at some points intersect, but at others are addressing different audiences or different concerns. I think are really important because what we're seeing right now with litigation is a really interesting strategy, which is this idea of belonging, having access to the law. And I've had conversations with many students about who is protected by the US Constitution and in what capacity. And what we see is, in general, you know, immigrants, like anybody present in the United States, have access to the constitutional rights for people who are present here. And yet, immigration is the one place where those constitutional rights can erode, especially the closer you get to the border and entry into the United States. I think there is some concern about the overlap between perceptions of who belongs and how those legal rights operate. For example, the recent Supreme Court decision is sort of a generous term, but order in the Vasquez-Perdomo case, which basically permitted stops to occur in Los Angeles based on one's language that they were speaking, the place in which they were standing, the perception of their race. You know, that all that information was provided in a concurrence. So it's not, you know, the law as we would understand the law to be, but it provides some insight into how at least one person who's at the highest level of power in the judiciary believes that the Constitution should operate and whom it should protect. I think one really interesting facet of many of these cases that are being brought is that they're being brought on behalf of US citizens. So they're being brought on behalf of people who were targeted, arrested, and detained in immigration raids, but they themselves are US citizens. And so this idea of belonging, you know, it asks some really difficult questions. And what I really like about the book is that it doesn't say, you know, this side is wrong or this side is right, but it asks us to engage in good faith in these questions. Who actually does belong? How do we draw those lines? Is it a legal status? Is it a period of time? Is it how we look? Is it the language that we speak? I think that some organizations have offered what their perspective is on these answers. The litigation is engaging with these questions, but for now they remain unresolved questions. One really interesting aspect of immigration enforcement that I have observed is that there is this narrative coming from DC about, right, who it is that's being targeted, that it's criminals, that it's bad people. In reality, though, what we're seeing in individual places in Los Angeles, in Chicago, in DC, is community members trying to intervene on behalf of their neighbors, on behalf of the teachers of their school, on behalf of the nurses who are working in the hospital, right? Actively trying to stop what is happening. And there seems to be a disconnect, right, between what's happening at the higher level echelons and then what's actually happening on the ground. So I think it's worth keeping those two things in mind, that we have the legal operation and we have the narrative that's present. And then we also have our broad national policy and then what's actually happening in people's daily lives. And there seems to be a significant amount of resistance to the way that this is being applied. And whether that's the belonging claim, I think that's probably the stronger version, or it's the humanitarian claim, both give us access to consider those ideas.
To follow up on Professor Bose's point, the community members, people's perspective changes depending on what viewpoint you're looking at. So as you zoom out, there are limited constitutional challenges you can have in the immigration field. Does that make these narratives, humanity claims, belonging claims, closer to the source in local communities, more impactful in state and local courts? Does it make a difference? Is there anything, because the book takes the longer term realistic utopian approach. So for advocates, for lawyers, what would be the most effective practice in court?
Yeah. Very good. Okay. Yeah, and that's a really important question, because I think it really connects. I hope this is the intent of the question, is really connect up sort of these ideas and concepts and framing with, what's actually going on and how we can think about concrete situations as people involved in this in some way. I mean, I do think, we do have something in immigration law, or in the constitutional aspects of immigration law, called the plenary power doctrine, which basically suggests or requires that courts not take as seriously, not take constitutional challenges as seriously as they might in entirely domestic cases, right? And so that's a constraint. But the fact is that a lot of this gets back to what Professor Bose was saying. A lot of it is about narrative, about how we see these things, and that plays out not just in the constitutional sphere, where you're deciding things are unconstitutional or constitutional, but instead how these things are argued, and that has a lot of influence on how statutes are interpreted. It has a lot of influence on how the public perceives executive actions. And so what happens is that I think this calls for a lot of intentionality, actually, in the part of anyone involved in the situation, is to say, well, what exactly is the claim here? Is it that someone is being treated in an inhumane, cruel way, or is their right to belong, or is their place in society being diminished in some improper way? And so I think that this is largely a call for thinking carefully. For example, an example from some time ago is that there are a lot of concerns raised a while back about, or maybe constantly, about healthcare benefits for lawful permanent residents and other non-citizens in this country. And a lot of the challenges to those constrictions, those limits on healthcare, a lot of the challenges were based on the language of there's a human right to healthcare. Well, yeah, I mean, I think that's a very strong argument, and we can contest that or agree with it, but that's not the point I'm trying to make. The point I'm trying to make is that why are you making an argument that's human right to healthcare when you live in the country, and pay taxes for 30 years? It's not a humanity claim. It is a humanity claim, but it's a stronger belonging claim, and I think that it's something to sort of be intentional about. By the way, this ties up, this is going back another thing to what you were just saying a second ago, which is that in this Vasquez-Perdomo case that sort of let stand the ICE policy of relying on appearance and accent and workplace language to enforce, Justice Kavanaugh, in his concurrence, relied heavily on a case called Brignone-Ponce. Now, the striking thing about that is that Brignone-Ponce is a case that addresses what the federal government may do at the border. but it was being applied to a situation in downtown Los Angeles. So that tells you something about the adoption of, I think, an invasion view, but it's also one that, as you were suggesting, is what's trying to fight that is the sense of the plaintiffs in these cases saying, well, wait a minute, why are you applying a border case to, a situation of enforcement? So these are the kinds of things, this book, I suppose, is a plea partly for terms of disagreement and debate, but it's also kind of a plea to intentionality and thinking about the different sources of how you think about the position of I suppose anyone in this country, but with a focus on non-citizens. By the way, when I did this thing about the humanity claims and belonging claims, and sort of made up those terms because I didn't like the ones that existed in the language before. I thought I was saying something really obvious, but it's sort of interesting that it's gotten this sort of resonance. But it made me realize that most of my career, all I've been doing is saying things that are obvious, but that no one necessarily thought of before. And so that's kind of a maybe half snarky comment about publishing, but that is my ambition, actually, is to point out obvious things that no one thought of before, and that may be one of them.
So I think, one of the things that this book addresses is the deep dissatisfaction across pretty much all ideological beliefs and adherence about the way the immigration system functions, that there's pretty much nobody who is happy with the way that the system is functioning. So I just wanted to loop back to this idea of plenary power is also connected to this idea that the federal government, right? It's the federal, it's the executive power, but Congress who makes the rules, and then it's up to the president to enforce them. But that states have no say, essentially, in how immigration law operates or to whom it should apply. And that has not always been the case. But since there has been Supreme Court jurisprudence on this, and Congress has basically not acted for the last 29 years?
You're testing my memory?
Yeah, I'm sorry.
Or my math?
Yeah, okay, yeah. I'm
Okay.
testing both for me. Yes, so 3 decades essentially of inaction. It's left it then to the executive, right, to try to apply and interpret the law based on limited resources and what's made available to them. So what we've seen essentially is this vacillation, right, almost like a pendulum swinging rapidly back and forth, which I think tends to aggravate not only those who are in the system and trying to navigate it, but also those who are experiencing and observing it, right? It feels a little bit chaotic because we're trying to plug all of these different holes that are escaping out of a dam that is infrastructure from many decades ago and should have been updated, to use maybe a poor metaphor. And so the question then is essentially, well, how do we respond to that? Well, we've seen actually states have operated in wildly different ways. The state of Texas, for example, tried to pass laws criminalizing the entry, and when those were found to be unconstitutional because states cannot intervene or enforce immigration law, except when they've been specifically delegated to by the United States in specific enforcement, they decided to prosecute people for trespassing under state law. And they did so successfully. I mean, there's a whole court system that's built up in South Texas around prosecuting people for trespassing, but everybody understands that they're trying to prosecute people for undocumented entry into the United States. Iowa, Florida, not California, Oklahoma, my home state, have all passed similar laws trying to enforce it. At the same time, you have these sanctuary jurisdictions, right, which are trying to limit their enforcement of immigration law. And I think it brings up sort of this, we have limited avenues to identify how we're going to resolve this issue. And what I like about this book is it's asking us not for a quick fix. It's asking us for maybe a more challenging one, which is a looking generations ahead, right? I think you use the phrase, I want to think about the immigration system for my grandchildren. That's what I'm trying to solve. I'm not trying to solve for the next electoral cycle because it is such a complex system. But the questions that are being asked are telling us we don't need to align with a specific partisan ideology that's, a la mode for that specific election cycle, but we should be thinking more broadly about how it's affecting those who have been present in the United States for a long time, and even those who disagree with the way that immigration system in a way that we don't agree with, right? That we want to bring in all comers to have this good faith conversation.
And then on to sort of the legalization, executive power, constitutional challenges. birthright citizenship. It sits sort of at this intersection of inclusion, national identity. I think the book frames it as legalization for the next generation. What do current challenges to birthright citizenship reveal about the public debate that's ongoing? Do current challenges reveal broader tension in how society defines who belongs?
Yeah, I mean, this is a very fundamental question that I suppose at one time might have been thought of as academic or theoretical or conceptual, but in fact, we have an executive order that's in the courts right now, which redefines citizenship based on birth in the United States. So the 14th Amendment has long been understood to confer U.S. citizenship based on birth on U.S. soil to virtually everyone born on U.S. soil, with the exception of children of diplomats of a certain rank. Not everyone works in an embassy, but of a certain rank, and that's been the received understanding for over 100 years. And so the executive order, Section 2. Well, basically, let me start with Section 1. Section 1 redefines citizenship. It says essentially that you have to, even if you're born on U.S. soil, you have to have one parent who's a citizen or a lawful permanent resident. This would exclude many people who were born in the United States when their parents were working here. It would exclude a lot of people who were born when their parents were studying here, sometimes for many years, even if they later were to become, those parents later would become citizens. Section 2 of the executive order says that this is not going to apply except into the future. But what's interesting is that if the executive order is upheld in court, then that would actually redefine citizenship, and it would be up to the executive whether or not to apply it retrospectively or only prospectively. So there's a lot at stake here, and I think that what's happened is that there's a contest really about who belongs, and so the book takes the position, and I hope I back it up with a lot of history. It takes the position that belonging should not be based on legal status, but really on people's ties to the United States. So that is actually in a different chapter, an argument for legalization. But at the same time, I think that we've seen the question of belonging shift or expand, not just to people who are in the country and have some role in communities in this country, and a certain length of residence, but we've also seen now the battleground shift into the zone of, who really belongs as a citizen, and I think that's very much what's at stake here. It's very much the idea that things we thought were settled are not. I mean, maybe that's one of the themes of 2025. And I think that the birthright citizenship, I'm really glad we're going to have some attention to this today, because it either undergirds or overarches everything that's going on.
I wanted just to, highlight that part of what is unresolved about this is how it would operate, right? And that was one of the major questions that was posited to the administration. We haven't talked about this, and I don't know if we'll have time to talk about it, but that implicates this idea of enforcement. And one of the key concerns of this book is what humanitarian abuses or concerns are obscured because they're held under the umbrella of enforcement, right? We're just enforcing the law as is. Right now, we have hundreds of thousands of people who previously had status who are having that status stripped away. I mentioned through something called temporary protected status and loss of parole. So I think we're getting some insight into what that looks like. And what it looks like is summary removal from the United States with little protection. And it's not random people, right? It's people who have connections to the community. The way that the parole program functioned, for example, was that you had to have a sponsor, somebody who could support you indefinitely for your entry to come into the country. Typically, those were family members who had status in the United States. So I think there's not to harp on this too much, but there's this idea sort of theoretically about to whom this would apply. And in practical, in reality, it's going to be applying to people that we know, right? People who are in our community. And I think that's why in 2015 when DACA? No, 2012.
2012.
2012.
DACA's 2012.
Yeah, so over a decade ago, President Obama essentially said the opposite, right? Was we have people who actually have these belonging claims. They've been present in the United States, sometimes as much as a few days. They're they were born, entered the United States a few days later, or months, or maybe a couple of years. And then when they came in here, there was no pathway to status for them. So part of the conversation that we'll get into here is legalization, what options actually exist. And so the idea was, well, these people do have belonging claims, right? They're going to high school. They've lived their essentially entire sentient lives within the United States. So what options are available for them? So there was a creation of DACA, which essentially was 2-year periods, option to renew. You could get a work permit, you could get a driver's license. There was no possibility of gaining citizenship, but you at least had the opportunity to remain in the United States for the moment, right? As sort of a pause on enforcement. What we've seen, though, is that DACA has essentially ended, that there are, at this point, no individuals who will be eligible for DACA who are going to be entering college going forward because of the time limit and the specifications of that executive action. So we're almost left where we were 13 years ago, except now the pendulum has swung the other way, right? Where people are being stripped of that status, even though they might have those belonging claims.
To follow up on that point, Professor Bose and Professor Matamora, where is the common ground? What can change? Because with the executive power, if immigration law hasn't changed in 30 years, Congress has been sitting back, it's all executive enforcement. How can your book be applied to see that fundamental permanent change?
Well, a couple of answers to that. And one is well, I'll give you two different kinds of answers. They're not in tension with each other. They're very different ways of answering the question. One is that is something I said earlier about polarization. I think that a lot of the polarization is partisan, and I think a lot of it's federal. I sort of long for the days when Republicans would disagree with Republicans about this issue and Democrats would disagree with Democrats about this issue. But now it's become a question of how do I win the next party primary? So I think one of the ways to do that is to have more local voice here, not just because people become neighbors instead of for employees or employers as opposed to statistics. But I also think it has an opportunity for Republican mayors and Democratic city council members to have some common ground on how to for example, revitalize cities where that's an issue. So that's one way to do it, is to really have a much more, neighborhood, local sort of voice. I think that's important. And it could go one way or the other, but I think at least we can have the conversation. The other way is really what Professor Bose was saying about my grandchildren, I guess, is that the book is dedicated to my grandchildren, and it probably maybe should be dedicated to their children, but depends on your sense of time. Someone asked me recently, how do I think about the future? What am I writing for? And I realized, well, I got really concrete about the answer because instead of saying something, well, it's kind of like, the horizon that you see, I said, how about the year 2070? And someone said, why do you do that? Why do you say 2070 or 2075 or whatever? And I said, well, that's probably when people graduate from law school now are going to retire. It's kind of a funny way to think about it, but I mean, you got a career to work on this, and so in that sense, there's both not a lot of time, and there's actually decades of time. But here's I mean, I got a lot of thoughts about this, obviously, but let me just close with this comment with this. Do you know people in your life who you get into an argument, and what they're really concerned with is whose fault was it, right? And they can't let go, and they can't look to the future because they're worried about who's to blame, right? You're probably related to people like this. Okay. And I think we're kind of stuck in that mode of saying, whose fault is this? Who's the guilty one? Who perpetrated what against whom? And it's not really kind of trying to move on, And here's why this goes back to your earlier question about citizenship. I think that we tend to look at citizenship as something that is kept for the innocent, and then you have to decide who's innocent. And it's something that is recognizing some past accomplishment or non-accomplishment, right? There's a very different way to think about citizenship, which is how you use it to build a stronger country. And if that's the case, it's not a diploma. It's a vehicle for cohesion. And if you think about citizenship as a vehicle for cohesion, then it really matters that you have people who are born in this country fully recognized as part of its future, because all opposite is to marginalize them forever. And regardless of whether the person should be given the merit badge or getting docked in some way, the real question, if you look forward, is how you use citizenship to move forward. And that's a sense of, so what I'm emphasizing is both local participation, thinking about time in a longer horizon, and thinking more about how to make this a better country instead of deciding whose fault it was.
So Professor Moore is referencing a prior work of his, Americans in Waiting, which is, I think, an exceptional read if any of you are intrigued by what we've been talking about today. But it is this conception, right, that we are all here in a community that people typically come in good faith, trying to build a life for themselves, a life for their families, a life for their communities, seeking some path forward. And I again, this book is such a helpful tool for this idea of solutions-oriented thinking, right? What is the conversation that we're going to have? We can't continue to pit an in-group versus an out-group forever. We've seen how that turns out historically. And so then what are we going to do, right? What is our long-term solution? And I think you will say clearly that the answers are not all here, but the questions are all here, right? The ways in which we should be thinking about this issue are all here. I was just thinking about a conversation that I had actually with Professor Kit Johnson, who's on a panel later today, and which it was part of a larger group. And the question was, who was the best president for immigrants? Was it Ronald Reagan or Richard Nixon? And if you are surprised by those names, you should be. And yet, historically, right, Reagan was responsible for the largest amnesty legalization project here in our history. And so the fact that we sort of forget that and have ideas about the way in which history is operated, President Obama, up till recently, was the person most responsible for the highest number of deportations in a specific presidency. So I think we need to reconceptualize who is, what a purity test looks like as far as politics, and engage in this broader concept of what might be possible based on what we've seen is possible. I think the issue with the legalization question is that it's a one-time fix, right? And that one-time fix either needs to be repeated or it's going to be contested going forward. And so the biggest issue, I think, tends to be this clear delineation of you're either lawful or you're not. And many of the lawful statuses are temporary in nature. And so we end up with hundreds of thousands of people who at the flick of a switch can suddenly be cast into this unlawful status. But it is this bigger question then of what are the pathways that we offer? Right now, the pathways are extremely limited. For those of you who have taken immigration law, you know this. For those of you who are enrolled in the spring, you're about to find out how limited they are. But there's simply many times not a line for people to get into, which is how we've found ourselves in this situation. So I think that's a much broader conversation, but I just wanted to, maybe blow a few minds talking about Ronald Reagan. So.
And our last topic today is crimmigration. We only have about 13 more minutes left, but at least if we could just touch on it real quick. So even in ICE arrests, and I know Professor Moore, you said earlier that immigration is not just a border issue, it's moving inward. ICE arrests have increased in non-border states all across the country. Kentucky alone, 40% increase in the last year. What does this tell us about how immigration is enforced?
Well, a couple things here. One is that there are, there's clearly this year sort of a ramped up effort, for enforcement, and we've had a lot of infusion of appropriations into the enforcement apparatus, and so that's going to naturally lead to more enforcement capacity and exercise of that capacity, and so you're seeing that in a lot of interior, places that are far away from the border, geographically far away from the border, at least the physical border. And this relates to what we're seeing with regard to the number of people who are being arrested and detained and deported. Now, one thing I should add, though, is that the statistics are very clear that the number of people who are being arrested, detained, and deported, who are people with criminal convictions, is a diminishing percentage. That we're seeing people being targeted for enforcement who are not, who are not in that category. Unless you decide that everyone who is in the country without status is in the country in a criminal manner in some way. And I suppose rhetorically, in terms of narrative, you could. That's part of what we're seeing. Although, I mean, as a legal matter, that's not actually true. It is not a crime to be in the country in the United States without status. But you can criminalize them in the public eye, and that's a lot of what you're seeing. And I think that's what's leading to a lot of the local tensions here, because it has tremendous effects on the economy, and that relates to what Professor Bose was saying about the narrow lawful pathways. By the way, I should mention that I'm the straight man in a Try Guys video on this question. Some of you may know who the Try Guys are, but it's a combination of probably, I don't know, Monty Python, John Oliver, and Jon Stewart or something like that. And there's a 16-minute video that summarizes the entire immigration law course and immigration law policy with the Try Guys, who normally do things like try to wear high heels for the weekend or something. But anyway, that's sorry about that self plug. But
No, it's a great YouTube video, and I think you said, that's the most watched thing you've ever
Well,
done by.
well, it has like
Exponential.
7.5 million views,
Yeah.
right? Which is like, I mean, that's pretty. This book's got a long way to go.
Yeah.
He's viral.
If you all just, don't have time or aren't interested in taking a full immigration law class, this
Watch
is
the
like the
video.
TikTok version of that. Yeah. So the one thing I wanted to comment about immigration enforcement right now is I took students to Boone County Detention Facility, which is the largest immigration detention facility in Kentucky 2 weeks ago. And it was a reminder of a few things, which is the way that the immigration detention system is supposed to function is to ensure that people show up to their hearings, right? That's its primary purpose. It's got a secondary purpose, which is to ensure that harm doesn't come to the community. But we could, if you want to talk about that, we can have a longer conversation about it. Primarily, it's to make sure that people show up. What we've seen right now is a change in the way that the law is interpreted, a self-imposed change by the Board of Immigration Appeals, in which they believe that any person who entered without inspection, meaning crossed the border without a visa, is subject to mandatory detention. So we've seen this huge explosion. At the end of the Biden administration, there were 35,000 people who were in detention. There's now 60,000 people who are in detention, and we anticipate that it's going to continue to grow as the big, beautiful bill spending allocation comes through. We're seeing contracts with private detention facilities or private prison companies popping up all over the country, including in Indiana, where facilities might be as much as 1,000 people being held in one place. Now, the reason I want to highlight that is because detention facilities are jails. I mean, they literally are, in many cases, actual prisons. That's the case with Boone County. It's a prison where people typically are held after they've committed a crime, they've had a hearing, they were found guilty, and that's where they serve out their sentence. But not the case for immigration detainees. They're held there just while their proceedings are ongoing, many times after they've accepted a removal order. We met with many people who had been there for 4 months after they had said, yes, I agree, I don't have status, I would like to be removed, and they are sitting in these facilities. But more importantly, we see detention facilities as like a cudgel or a leverage or pressure point on people to accept a specific outcome in their hearings. What we know is that the representation rates in immigration detention facilities are extremely, extremely low. Part of the project that I started my career in was to try to represent people who didn't have representation. And what we saw was that if you didn't have an attorney, the likelihood of your success in a specific case was around 10%. But if you did have an attorney, all else being similar, you almost had a 50% likelihood of success. The same was true for children. Children who are not in detention facilities but simply don't have an attorney won about 13% of their cases. But if they had an attorney, almost 3/4 of their cases were successful. So what we're seeing in this case, and part of what Judge Katzman was trying to fulfill, is not necessarily that people aren't even eligible for these narrow pathways, but in many cases, they don't understand the complexities of the system. There's language barriers, and they're held in a detention facility while they're trying to fight their cases for months at a time, even though they might be eligible for some form of relief that would provide them with lawful status.
I think you were just describing it. Is that the concept of double enforcement? I mean, how is that interplay with the criminal law aspect and then the civil law, immigration law generally? How does it affect one's constitutional rights who are here? Constitution protects people who are here.
Well, the double enforcement idea is a really interesting one because it's a litmus test for a lot of the things we've been talking about today. If you think that people are being doubly punished by having a criminal sentence or serving their time or whatever it may be and being deported, then I think what you're really saying is that someone belongs, and that if they have a price to pay in the criminal justice system, then they pay it here because they're here, and and that it is truly double punishment to deport them. But if you take the view that they don't belong, then it doesn't seem like double punishment at all, because it seems that you would really separate conceptually the idea of a criminal justice penalty with being deported from this country. So that's an interesting, and I tend to be troubled by a lot of the things. I tend to call it double. I tend to think of it as double enforcement, but I also want to confess that the reason I do is because I think that people who are being deported for criminal activity have paid their price in the criminal justice system, and that it's truly double enforcement. But I want to explain that that's the reason I think of it.
I'll defer any answer. I know that we're sort of close to time here in case you wanted to solicit any audience questions.
We can open it up.
Sure.
Yeah.
Would anyone like to ask any questions?
We're not going to call on anyone in the back row unless you want us to.
Ryan? Yeah. Oh, sorry. Ben, do you want to handle the queue? That's my fault.
Saw one right there. Ryan. I heard a little bit about the asylum pre-termination, where there are times where the court treats asylum application that's not complete at a master hearing. They just take this, the application is being waived, folks are putting the expedited. Anything about that?
Yes. So what Ryan is asking about is something called pretermission, which is essentially intervening before the substance of an asylum claim can be litigated in court. That is the policy of EOIR right now, is that if there is a box that's not checked or a form is incorrectly filled out, then the immigration judge can decide to end the inquiry at that point. My understanding is that that's being litigated. I'm not sure by whom, but yes.
I just add quickly that this is an entire area that I try to address in chapter 2, but it's also that we have a real complete need to overhaul the way we think about humanitarian protection. And much of what you're seeing contested in the space of asylum is people who think that it really needs to be expanded, and people who think asylum is a scam, right? So, I mean, and it's coming out in many, many ways like this one.
We have a couple more questions, or a couple more minutes, if anyone has another question.
One argument I hear from the crowd that opposes immigration is this idea of assimilation. And I was curious to hear what your thoughts are. Is that an argument that actually has merit? And if so, how does that tie into your general idea of belonging?
Well, I mean, there's a lot of contests certainly on the vocabulary of integration versus assimilation. I mean, I think that in order to make people, I mean, belonging does not happen, overnight. I think it's a process that involves some emphasis on integration and really bringing people in. I think integration involves not coerced assimilation, but really respect for the cultures that people come from. And I think that we're in this vicious cycle now where people feel marginalized as immigrants, and so they withdraw and sort of say, well, we're not going to become, we're not going to do all the things you expect us to do, and then you end up with immigrant enclaves. Although I should add that immigrant enclaves, often are just transition points. That people do. I mean, it's really, maybe there's a more general way to register and way to answer your question. There's a whole half chapter, but anyway, I think that there's much. This goes to time. I think there's so much emphasis on the degree of assimilation or non-assimilation, or integration or non-integration in the generation of the parents. And whether it's economic or language or culture, whatever it may be. But I mean, and people decry the lack of English acquisition among parents, but the language loss of the old country language in the second and third generation is really dramatic. And it's sort of a disconnect between what social science can measure, which is the current generation, and what policymakers should think about, which is how are the grandchildren or the children going to be part of American society? I mean, the parents in a way don't matter as much as the children and grandchildren.
If I can use an inverse example, which is that there are studies about the likelihood of immigrants to commit crime, for example, and those studies seem to bear out that the longer a group is in the United States, the more assimilated that they become, and actually the more likely they are 5 or 4 generations down to transgress the criminal laws, whereas those who have recently entered are much less likely to, which is,
Well, I believe that's all the time we have today. Thank you both, Professor Monomura, Professor Bose.
Thank you so much.
Thank you for having us.
Also, if this conversation was of any interest, please buy Professor Monomura's book, Borders and Belonging. Thank you all.
Alrighty, we will keep on moving forward according to schedule. So the next panel will be starting pretty soon, and it will be State Representative Nima Kulkarni, Miss Katie Taylor, and Professor Chris Kozol. So thank you all.
Nice to meet you. I'm with Neighbors Immigration Supply. I was with Jungle Care 7 years. Yeah, so we're part of their national network. Yeah, it's actually we're around. I'm Katie. I've heard about you from Emily and everybody else. So nice to meet you.
Yeah, you're doing awesome.
Yeah, put it over here. Don't have to worry about it.
We can do.
Yeah, and then.
Oh, this moves, okay. This one?
Yeah. We're good. We're.
Oh, sorry.
No, you're passing around.
Make sure I know God.
Yeah. You can, I don't.
We can share mics.
We can, yeah. Does these go on?
Oh, sure.
Yeah, you can have.
See, and I have the opposite thing. If I get have a chair too high, it cuts off the circulation of my wares.
Oh, yeah, no. This is. But
Is this an act mic?
yes, it works. But you have to push the button.
Oh, you have to hold the button the whole time.
No, no, no. You just push. And it's
Oh.
green.
Look at your, Mr. Speaker. But
That's how our little buttons works. That's the only reason I.
You know all the inside tricks.
you know, in crazy things is. So most courtrooms you have order of clerk.
Yeah.
But the immigration court, because they have to, the judge is in charge of like.
Oh, gosh.
Checks, like run, equipment.
I'll take one. That'd be great. Thank you.
Cold, is it room temperature? No, I like rooms. I don't like cold. I'll. Oh, good to see you. How are you liking? Yeah. Oh, almost. Good to see you.
So, general questions if you want to answer.
Sounds good. Technical questions. Why are you doing this? To yourselves.
Why is this your life choice?
That's right.
All right, can y'all hear me okay? All right, sweet. Okay. Good morning, everyone. Thank you so much for joining us today. My name is Ellie Driver. I am a staff editor on the Kentucky Law Journal, and I am honored to be moderating our Navigating Immigration in Kentucky panel today with our three amazing panelists who were gracious enough to join us here in person. But before we dive into today's topics, I just want to take a moment to introduce our panelists. So panelists, if you don't mind, whenever I say your name, just give the audience a little wave or something so that way they can make the connection. So starting off, I would like to introduce Representative Nima Kulkarni. Representative Kulkarni currently represents Kentucky's 40th District in the State House of Representatives and is the first immigrant to serve in the legislature. Elected in 2018, she has sponsored or co-sponsored over 441 bills while continuing to practice immigration law, which she has done for the last 15 years. Most recently, she founded the New Americans Initiative, which is a nonprofit which seeks to educate, engage, and empower our immigrant and refugee communities by providing free green card and citizenship legal assistance, expanding voter registration, and encouraging sustained civic engagement through in-language resources and targeted canvassing. Next, I would like to introduce Ms. Katie Taylor. Ms. Taylor has been the legal director of Neighbors Immigration Clinic since January of 2024. In this role, she leads the clinic's mission to provide low-cost, accessible legal services to immigrants across Kentucky. While earning her JD from Harvard Law School in 2017, she volunteered at a Boston asylum clinic, gaining early hands-on experience with asylum law and supporting immigrant communities. Throughout her career, Ms. Taylor has gained extensive experience in asylum, visa, and naturalization work. And finally, I'd like to thank Professor Christopher Kozol for joining us today. Professor Kozol is an assistant professor of law at the University of Louisville Brandeis School of Law and is the director of the university's immigration clinic. Before joining the Brandeis faculty, Professor Kozol served as an immigration judge with the U.S. Department of Justice in Memphis, Tennessee, where he adjudicated various asylum and removal cases. Moreover, through his work, Professor Kozol possesses significant knowledge in how state and local practices shape immigrant communities' access to justice. Thank you all so much for being here today. Now let's dive in to navigating immigration in Kentucky. Okay, so before we get started into some of the specifics, I just wanted to ask you all a preliminary question, which is, where did your initial interest in immigration or immigration law stem from, and what led you to pursue that passion here in Kentucky?
All right, I'll start. Good morning, everybody. Thank you all for being here, and thank you for inviting us to be on this panel. I'm an immigrant. I was born in India, and my family and I moved to Louisville when I was about 6 or 7 years old. So immigration is just something that I obviously grew up with. I was naturalized when I was 14. I became an immigration attorney because I took an immigration law clinic in a law school and really enjoyed it. Enjoyed the fact that law could be something that directly impacts somebody. It's not this abstract concept. Was never interested in, tax law or criminal law, for instance, but it was a really eye-opening experience to see the need that these families had. So I became interested in immigration law, and really because of that clinic have been doing it ever since. Why Kentucky? I moved away for about 10 to 12 years, worked in different practices in a few different states, and moved back to start my own law practice in 2010. And I moved back to Kentucky because I figured if I'm going to start a solo law practice, my family's here, so if it all goes wrong, I'll at least have someone's basement to sleep in. But it's been really rewarding to see how Kentucky and Louisville and Lexington and now, Bowling Green, Northern Kentucky, how much they've grown because of international migration to our Commonwealth.
Thank you. Can you hear me? Thank you. Thank you to the Kentucky Law Journal for putting on the symposium and for hosting us. I'm actually really glad to have this question, and I'll get to that in a second. My first formative experience of immigration law that I recall, or immigration that I recall, I don't think I appreciated at the time. It was when I had sold everything I owned and saved for several months and moved to Japan with my best friend. And we looked for work and we're offered jobs, and we're told it is legal for you to work, and we hold your pay in abeyance until we can get your visas sorted out. And that's going to take some period of time. You have 90 days. And 2 weeks before the 90-day period, we had been bugging for several weeks. We had been bugging the person in charge of that. And 2 weeks before our 90 days was to run out, we learned that they had not filed our visas or moved forward on our paperwork at all, and that we were subject to deportation in 2 weeks. We did manage to get that sorted out. But later, as I came to work in immigration law, it gave me the tiniest sliver of recognizing what many of the people that I have had the privilege to represent go through. Because although I had sold my car and many possessions and saved my money, I too had a family that I could go back to. And the worst thing I was going to have to do is admit that I had failed. But I was not going to return to a situation where my family might be in danger, or they might have leveraged themselves in order to send me to this other country to start the career that I had been looking to start. The reason that I am particularly glad to have had this question is because, as I was telling my co-panelists, Professor Motomura was actually the professor who taught me both civil procedure and immigration law. And it was near the end of my first year in law school that I was flipping through what was back in the early 2000s, a binder of job listings, and came across an internship with the Rocky Mountain Immigrant Advocacy Network, and mentioned that Professor Motomura was the person to talk to for that. We went and spoke, and I had previously worked in refugee resettlement, and he said, well, your experience is directly relevant. Take my class and you can have this internship conducting essentially jailhouse interviews and finding representation for people. And I say this because how often does one get the opportunity to publicly thank a great mentor for starting them down the road on their career? I don't know that without Professor Motomura, I would have had this career, and I'm deeply grateful for that. So thank you. And I hope I haven't embarrassed you too much.
For me, I guess it's like a variety of experiences that have kind of led me to do immigration law, like everybody else shared. But I think exposure to people I love and care about deeply that are immigrants is the number one thing. I have 3 adopted siblings, 2 of whom were adopted internationally, and was exposed to how immigration plays into international adoption and the messiness of that. I also went to undergrad here at UK and had a ton of friends that were international students and saw a lot of what they were going through. And I spent summers in college as well in the Dominican Republic, semi close to the border of Haiti and saw a lot of the immigration. There's a lot of historic racism between the Dominican Republic and Haiti, and a lot of immigration issues between those two countries, as well as people fleeing from Haiti to the DR to try to come to the United States, and kind of saw some of that interplay. While I was at Harvard Law School, I had the privilege of taking the asylum clinic there and worked in conjunction with the Greater Boston Legal Services to represent asylum clients. And I think with immigration, there is such a hole in legal representation that I have never seen in a different legal field. Like the amount of I actually had a call from someone the other night that was like, okay, so when these kids show up to court tomorrow, they'll just be appointed a lawyer. And I was like, no, that's not how immigration works. It's not like criminal law. So many people just do not have access to legal representation. I remember one of my first days in the clinic, this was like before I had had a class on immigration, before I had had my first day in like Asylum 101 law. I was given 2 clients, and the attorney that I was working with was like, okay, they're your clients. Just, you're going to fill out asylum applications for them, file asylum cases, no interpreter. My Spanish is pretty broken. So just make it work. Well, I'm like sitting in there meeting with them, Googling what is asylum. And and I was like, okay, it seems like you gotta be afraid to go back. So I'm like, in broken Spanish, like, are you afraid to go back? And they're like, no. And I was like, okay. Which, come to find out, yes, they were. My Spanish sucks. There's other issues. Like, but it was one of those things that, like, when I talked to the professor, I was like, I really feel like I'm not helping. I feel like they need a real lawyer. And he was like, it's you or no lawyer. There is no other option. And so I think that's kind of what kind of started me wanting to do immigration.
Thank you all for sharing that. So now I want to start talking about immigration practice in Kentucky generally. And so my question is, what are some of the most common immigration matters that are being addressed in Kentucky? And how would you say that compares to immigration matters that are being addressed nationwide?
I guess I can go on one perspective. There's a bunch I'm sure we could talk about. One of the things that I do a lot with is special immigrant juvenile cases. So this is for children that have been abandoned, abused, or neglected by one of their parents. And it's a really powerful way for kids to be able to get green cards because, like Professor Boa said, there's not a lot of pathways to lawful status, but this is one of them, like to permanent citizenship one day. In Kentucky, we as Neighbors Immigration Clinic, we represent people in every county other than Jefferson County, so everywhere but Louisville. And I feel like last year, all I did was drive around the state to different family courts because for these cases, the first step is getting a family court judge to sign a sole custody order for someone to get custody of these children, which most of these children have never had anyone get a sole custody order or anyone get any type of family court order before. So it kind of seemed like a straightforward thing, and was, I feel like, until a few years ago. And then in Kentucky, it became a really political thing, and which judges were willing to sign these orders and which weren't. In Fayette County, it has been a wild experience. We've switched into dependency, neglect, and abuse court, which is traditionally used for children in foster care. Now we're half in that. We're half in custody court because the judges have changed their mind. In every county you go to, each judge has their own opinion on how they want to do these. And so that has been one thing that I feel like has been really unique to Kentucky. We're part of a national network, and so we have 16 sites throughout the nation. And I have not seen that in our other sites as the way that has been much more of a fight and much more time consumptive in Kentucky.
I'll briefly mention that I practice in employment-based immigration. And so a lot of the attorneys in Kentucky, of which there are vanishingly few, we need law students to turn into immigration lawyers. So contact any of us if you have even the barest interest. I have a lot of law students. I see some familiar faces that have volunteered for New Americans Initiative. But in employment-based immigration, one of the largest probably practices that you'll see out in the state are H-2A, so agriculture worker visas, especially for our horse farmers. And so they're all very familiar. So I'll have legislators, for instance, from rural counties who are well versed in the nuances of immigration law with that specific visa category. There's a lot of businesses that I work with in Louisville and around the country throughout Kentucky. So a lot of individuals who are immigrants founding businesses, companies that want to hire foreign nationals that are researchers, for instance, or in STEM. And I think that has been a very rewarding practice. I tried my hand at removal defense when I first started practicing, and it takes a lot more, a lot stronger constitution than I have, because I could not charge anybody for any money because I couldn't do anything for them. Our immigration system is completely broken, as we heard so eloquently from the last panel, and has not been updated for decades because Congress refuses to. I mean, it's just a matter of political will. The solutions are, very well known. They're not difficult to implement, but nobody's willing to take that step. So we talked about President Reagan, and I'm rambling a little bit now, but all that is to say that there are a lot of different aspects to immigration law and a lot of different needs to fill, even in Kentucky.
And from my perspective, and part of the reason our clinic was founded, we have either, depending on how you cut the statistics, either the second or third largest population of Cuban nationals in Louisville and in Kentucky. I believe the last statistic I heard was 40 to 60,000 Cuban nationals living in I believe mostly in Jefferson County. And most of those individuals, at least in my experience, are from the city of Holguin in Cuba. I believe I see one of my colleagues nodding his head in the back. So that is a large percentage of the work that we do at the clinic. And that is because Cuban nationals who have been inspected and admitted or paroled into the United States have, under the Cuban Adjustment Act, the right to apply for their permanent residence after being physically present for 1 year. And it is a great benefit to the Cuban community, but one not available to other members, other people who enter the United States and seek to become part of the country. I would say there's also a fairly significant in Kentucky U visa and VAWA practice if people are interested in helping domestic violence victims. It is an unfortunately common experience that there are within many mixed marriages, often violence, and that immigration status can become a means of control. So that is another common practice. And my practice, when I was in private practice, was also family-based and removal. So there continues to be a lot of that. I would say, from my perspective, the strong percentage of Cubans is one of the distinctions of Kentucky practice, because my brother-in-law, who's from Miami, was lamenting lack of Cuban food in Los Angeles when we were out visiting family together. And I said, "Oh, you can get great Cuban food in Louisville." He was, "What?" But to me, that is a distinguishing feature of the practice here.
Yeah, absolutely. And one thing too that I've seen more recently, I don't know how much you guys are seeing it as well, is because we have more and more detention facilities in Kentucky that are popping up. And for instance, Chicago. So you guys, I'm sure, have seen it on the news of the enforcement operations going on in Chicago. Well, Illinois has a law that they don't have detention facilities, ICE detention facilities in the state of Illinois. And so we have seen from our sister organizations in Chicago a lot of clients that are getting caught up in these ICE raids being sent to detention facilities in Kentucky. And so we're having to deal with that now of, okay, they have Chicago-based lawyer, but they need a Kentucky-based lawyer to deal with the habeas petition to get them out of detention and things like that, because Chicago doesn't have detention facilities.
And that actually brings up a great aspect of the practice of immigration law in Kentucky that is different from many parts of other parts of the country. When I moved here from Denver, I had been practicing for about 3 years in Denver when we had our first child and moved back here where my wife is from. In Denver, we had a ICE, a full-time immigration court with 3 judges that soon thereafter expanded to 5, and USCIS all had regional headquarters in Denver. And so there was a district director for ICE, there was a district director for USCIS, and there was a physical immigration court where we could walk in and get relief, as well as a district, federal district court where we could file habeas, and the 10th Circuit Court of Appeals. When we moved to Kentucky, we had ICE, which is under the supervision of the Chicago field office, USCIS, which I believe is Cincinnati, or it's in Ohio. Oh, it hasn't changed. When I first moved here, it was in Ohio. And the immigration court, we had a judge appearing by video once a week in a room that held 6 to 8 people, and you'd wait and then go in with your clients. And he was in Memphis. And so you were dealing with multiple jurisdictions, and you were far away. For those who don't remember pre-Zoom, pre-WebEx days, it was really hard to get a hold of people. And whereas in Denver, I could essentially, start not yelling at, but making noise with the USCIS district director and actually get a meeting with the USCIS district director. It's been probably 15 years since they've come out to do a meet and greet with the local bar, and would never hear from them out here. And that's not to castigate them. It's just there's large areas of responsibility. And of course, immigration has become more of a political football in the last 20 years than perhaps it once was.
And I'll only add that, immigration enforcement, like these agencies, these offices aren't here is because we only have about 4.5% of our population that's foreign born. And that's everybody. That includes permanent residents, naturalized citizens, temporary workers, students, et cetera. And so the reason, a lot of questions that I get have to do with, are we seeing an uptick in anything like we're seeing in Chicago or LA or in, Portland or these other sort of targeted cities? And the answer is no, because there it simply isn't a presence here. It's not for a lack of wanting to enforce or have some of that that increase. There just aren't that many immigrants here. There's not enough agents. That being said, there's $177 billion that's been allocated to detention and removal and enforcement actions. And so I think we're all kind of in a holding pattern and waiting to see what will happen. We've seen, of course, the administration basically delegalize individuals. So the Cubans that Chris was talking about, we had 500,000 people come to this country on parole, right, on the Cuban, Haitian, Nicaraguan, Venezuelan parole program, which ended for all of them. There's litigation happening, but Cubans have this pathway, but there's not enough lawyers to handle that load, basically. And so one of the things that certainly New Americans Initiative, it marries my experience as an elected and an immigration attorney, and the fact that in Frankfurt, as in Congress, we just don't hear from our foreign-born communities. It doesn't have to be about immigration, but we just don't hear from immigrant business owners. We don't hear from immigrant healthcare workers, whatever their concerns and needs are. And so the idea of stabilizing people's status, so filing the green card adjustment for Cubans or anyone else that's eligible, making sure that if you are eligible for citizenship, you don't just keep renewing your green card, because at this point, green cards can be revoked pretty easily. Citizenship, much harder to do. Whenever they figure out the birthright citizenship, we'll deal with all of that. But as of now, it is far more secure to become a citizen than it is to continue renewing your green card. And so that's that idea of stabilizing people's immigration status, putting them on a pathway to citizenship, making sure that they are aware of the changes in policy and the importance of their engagement beyond just their own community, is the point, right? Is the point of New Americans Initiative. Ultimately, of course, we'd like to see a lot more immigrants in elected office. We'd like to see representation at all levels. But I think that is a doable goal, right? That's a feasible objective in Kentucky because it's a quantifiable number, right? You have a quantifiable number of refugees, for instance, which were the 4th highest rate of resettlement by numbers, not just by per capita or percentage in the country. And so there is a significant need for folks to be able to get on that pathway to citizenship, to make sure that their lives, their families' lives, their children's lives are stable, and that's not something that they have to worry about or keep worrying about into the future. So I think that there's different ways to approach this, but I think in Kentucky, there's a lot of things we can do because of that smaller immigration population. And I think, you know, a lot of the immigration attorneys meet, right? They meet, they talk to each other, they figure out strategies, what's happening on the ground. And that's also something we can do because we have a small number of immigration attorneys. So it's, I think, important for everyone to recognize that strategies moving forward to deal with either enforcement, to deal with stabilizing the status of individuals who are eligible is the goal, I think, is the short-term goal for all of us as we weather the changes and the shifts in immigration policy.
Yeah, and you all just hit on a lot of different aspects of immigration law that is being dealt with here in Kentucky. We've talked about employment law, family law, residency, citizenship. I mean, you all really hit it all. And we started to talk about this a little bit about what's been going on in some other cities across the United States. And one of the most prevalent immigration issues that has been discussed in Kentucky recently was the designation of Louisville as a sanctuary city earlier this year by the Department of Homeland Security. But before we get into that, I sort of just want to ask you all, just generally, what even is a sanctuary city? Because I think that there's a lot of confusion around that term. And so what is actually happening in these cities that are getting that designation?
My panelists may disagree, but I don't think anybody really knows. I think a sanctuary city is, as with many things in life and things that become politicized, it's whatever the speaker wants it to mean at that moment. And I think that's part of the difficulty. Ultimately, the movement towards sanctuary cities had begun in the 70s and 80s, is my understanding, and is part of many of you who are first or second year law or third year law students will remember the anti-commandeering doctrine, that the federal government cannot just step in and commandeer the machinery of state and local government. And so that, as with all things in life, there are things that help and hurt any particular position in that regard. And so much of what is referred to as the sanctuary city movement comes out of the anti-commandeering doctrines that say, we are paying state and local taxes to have a jail to keep people that we think are violent or have committed crimes or who have otherwise are perhaps dangerous to our community, to keep them in custody while we figure out what's happening in their criminal cases. And for example, when ICE issues a detainer and asks that the jail hold them for an additional 48 hours, that burden is borne by the local taxpayers. And so at however many hundreds of dollars per day, however many individuals get the ICE detainers put on them, local taxpayers are paying their taxes to detain these individuals without recompense from the federal government after the local authorities have already determined they're eligible for release and should not be held. And I think that's a huge part of what is the sanctuary city movement. Should we be using state and local resources to effectuate a federal policy? And you can have different answers on that. But it is the realization that it is your state and local taxes that are paying for that often.
And I'll add a little bit about the faith-based history. The sanctuary movement was essentially churches deeming themselves sanctuaries for people that were fleeing violence from El Salvador, Guatemala, Honduras. And we're seeing a lot of that again today, right? A lot of these individuals that are fleeing the same kind of instability and violence, gang violence in their countries. And a lot of the children that parents sent ahead of them to just sort of take their chances and with a border agent and hope that they get a lawyer and are able to, you know, live here. I think one of the things that we forget about that Chris mentioned is that it's all our tax dollars. We're paying for all of these operations, all of this enforcement, all of this activity, and people don't really connect the dots in that way. But I think the question about Louisville being deemed a sanctuary city is important because in 2017, Louisville Metro Council, they passed an ordinance that basically said LMPD, so Louisville Police, cannot aid or even assist or be present at an immigration enforcement action unless they had an underlying reason to be there. So if there was a law, an actual law that was broken where LMPD would ordinarily be present, only then could they also be present at an enforcement action. That was investigated by the prior Trump administration, and they said, no, you're not a sanctuary city. That happened again earlier this year. We were put on a list, removed from the list, and then there was this, threatening letter that Pam Bondi sent to several jurisdictions saying, if you don't comply with ICE detainers, which are requests, by the way, they're just requests. There's no obligation, there's no mandate to comply with them. And as Chris mentioned, to hold somebody for 48 additional hours after whatever they were in jail or in court for. So if they're being released, you are supposed to hold them for 48 additional hours without any probable cause, without any underlying basis, so that ICE can pick them up. Historically, ICE has failed repeatedly to pick these individuals up within the 48-hour window. So now you're dealing with a lot of constitutional issues, due process issues. You're opening up the local jails and local law enforcement to legal liability because you're holding somebody without cause, without right to an attorney, because this is a civil violation. You don't get a right to a phone call. You don't get a right to an attorney. You might be picked up at this point because of the mandatory detention, because of the expedited removal process, all of these expansions for removal pathways. You might be picked up and then taken to Louisiana or Texas, and citizens have been picked up and put in that detention machine. Because if you're not carrying your passport with you or your documentation, which, by a show of hands, how many people in this room have documents on them right now proving that they're lawfully present in the United States? Driver's licenses don't count. 0 hands went up. I have my passport. I carry my passport with me. And I've advised clients to carry documentation, certified copies or originals if they can, because these are precious documents. They cost money. If you lose your green card, it takes months to get another one, and it costs you a lot of money. USCIS is a fee-based system, so government shutdowns don't impact it. Sorry, I'm going off on many tangents here, but it's important to know that all of these kinds of policies and these agencies, how they kind of interact and interplay with each other, because it's all moving towards pathways to remove people from the United States. First, detaining them for months, potentially years, because we don't have the money to physically remove the number of people that this administration wants to remove, and it costs too much to do it. So they will be held in these local jails, and they're expanding, right? So Grayson County is expanding its facilities. This is all, private prisons coming, private prison companies where there's very little oversight. So people are being harmed because they're not getting medical care. People are dying in these detention facilities with very little oversight. People don't just get to go into the detention facility and see what's going on. You've seen lawmakers try to shed a light on some of these activities. But I will say this about that ICE detainer policy that our mayor agreed to. In response to Pam Bondi's letter, we're the only jurisdiction that actually did that in the country. The letter was sent out to 50 jurisdictions. Louisville was the only one that complied. And the reason was federal funding. We don't want to have our federal funding cut off, but we also are willing to sacrifice a few immigrants for the sake of not having raids, the mass raids that we're seeing in these other metropolitan areas. And again, we were the only ones to do it. There have been legal challenges that it has been blocked by courts. So we did that really for no reason. And what we have done instead is say that we're going to comply with a request to keep people for an additional 48 hours who might have been picked up on a traffic violation for a broken taillight or for speeding. And that is just another expedited pathway to take a person off the street and put them into detention, ready for removal from the United States. So all we've done is created another easier pathway for police to pick up a person, put them in jail, notify ICE, and have ICE pick them up for something that is not even considered by any of us in this room to be a major violation of any law. And that's what we've done in Louisville. And I've spoken publicly about it. I'm sure you can tell I don't agree with that policy or the action to comply with something that is unconstitutional and has been blocked. This idea of withholding federal funding if you don't comply with something that is not a mandate. So I think that, the fact is that this administration, the previous administration, has said that we're not a sanctuary jurisdiction, And the fact that we have, gone ahead and implemented this compliance with ICE detainer policy is a bit of it's in conflict, right, with who we are, because we also call ourselves a welcoming city. And a lot of the economic engine that Louisville is for the Commonwealth comes from people moving to Louisville from other countries and choosing to stay because we were supposed to be a welcoming city. So I think we're going to see a lot of fallout from those decisions. And I think a lot of jurisdictions are struggling with those types of decisions at this point, because we're going to continue seeing threats of withholding funding, threats of mass raids and ICE enforcement if they don't comply. So it's an intimidation tactic, it's a bullying tactic, and I think it's up to all of us locally, right? Each city, almost each county, to figure out how they're going to respond to this administration's bullying.
Yeah, and I guess on the county level too, I think the big thing is there's something called 237G agreements. And like my panelists were describing, right, the federal government can't commandeer state officials, state resources. But in Kentucky, each county, well, really even more small than that, because there's sometimes like multiple police departments operating in one county, but each specific department gets to decide whether they're going to comply with these ICE detainers. So you can like go online and look up who has signed 237G agreements in Kentucky and see if the county you're from has signed them or not. But it is something that at least, I'd say, I don't know, 15 now? Okay, so about, yeah. So there were 0 of these agreements signed in January, 15 that are now enforced. I know Georgetown has one, so that's a close one to us in Scott County. And so just knowing that they're voluntarily agreeing to work with ICE agents to help detain immigrants. I think the other thing, I really agree with the what the heck does sanctuary city mean? Because I think people just make it mean whatever they want, like you said. But I think something that we've been trying to do a lot of work with is, my coworker especially, is doing presentations, helping churches, helping healthcare facilities, helping businesses develop documentation of how to protect their place of business from ICE officers having access. So I'm sure you guys have seen on social media and stuff, like nurses trying to block ICE or things like that. And so there are ways that ICE has access to public spaces, but if you put certain signage up, like we had a healthcare facility we worked with here in Lexington that now has put up signage saying only patients and family members allowed in the building at all. So now all of a sudden, if ICE were to come, they could keep ICE out of even their lobbies because they are not patients or family members. And so working with individual organizations very locally to say, okay, regardless of what we say with our words, what does it look like to create a policy where you actually would have the right to not let ICE in? And so I think we've seen a lot of organizations, especially this year, trying to address that.
And I'll just quickly add, so there's a lot of nonprofits, right? Neighbors and New Americans. So we've pivoted, besides just providing legal services or whatever the long-term goal is, to these Know Your Rights presentations. And it has been a lot of churches, employers, schools, campuses, wanting to know, what do we do? The idea of knowing the difference between a judicial warrant and an administrative warrant. One, of course, passes constitutional muster, one does not. That has been, I think, the bulk of the work, certainly, that we've been doing this year, and I'm assuming that you as well, because it's, yeah. So it's important to support your local organizations as well as they do this work.
And I just want to add something to consider and think about when we are thinking about these issues is the downstream effect of having a non-cooperation agreement or refusing to cooperate. As somebody who practiced in primarily deportation defense for the bulk of my career, while I was grateful that people were not being held in the Louisville Metro Jail, it also shifted the practice and meant that I lost easy access to many of my clients. Because when Louisville Metro stopped holding people and would not cooperate and would not contract as a facility, then everybody got moved to Boone County or to Illinois County, Illinois, or other more rural detention facilities that had overbuilt their detention facilities back in the tough on crime 80s and 90s, and now had lots of room in their detention facilities that was going to waste unless they filled those beds, and they were more than happy to subcontract with ICE to fill those beds. Which, if somebody is going to be detained, is not, if they're going to be detained one way or the other, to some degree, it's neither here nor there. But if your attorney is in Louisville and now it's a 3-hour drive each way for your attorney to meet with you, it can become less likely that your attorney is going to be able, that is if it's 3 hours each way, that is a full work day for an attorney. And by the time they do a 2-hour interview with you in person, and at that time, there was less option to have telephone calls, video calls, less assurance that they were going to be secured by the means that would allow you to have a privileged and confidential conversation with your client. And so many attorneys began declining that representation because it was burdensome. And this is one of the factors that is common in immigration law. Even when a person has a very good defense, even when they can find an attorney, there are moves that make it extraordinarily expensive. And for those who are not yet practicing law, if you're in private practice in your own office, you have to understand that you are both practicing law and running a business that has to pay rent, pay your legal assistants a living wage, hopefully pay yourself a living wage, hopefully provide health care to your employees and vacation time and everything else, because the stress is real and everybody needs to decompress. And so sometimes well-intentioned actions can have downstream effects that are not helpful to the immigrant community.
So you all just did a great job summarizing what's happened in Louisville and the ultimate decision to comply with the federal request, what the potential consequences of that has looked like, and then also you all touched on what we can still do now to make sure that immigrant communities' needs are still being met. And so now I want to transition to asking you all how people can get involved in this kind of work. What are the most important skills for people working in immigration law to have? What organizations would be a great way for our students to reach out to? And then what do you think are some great summer job opportunities or things like that for people to get started in this type of work?
Yeah, I guess from the Lexington base, we do at Neighbors Immigration Clinic, we do externships or we do summer internships for students if that's something that you're interested in. The other thing that we've had students do that has been super helpful is organize fundraisers. Having funding to do this as nonprofits especially has been wildly hard. I think in Kentucky, we've gone from like 15 nonprofit immigration attorneys down to 3 right now, or 4, kind of how you're counting it, just this year because of funding cuts. And so that means all of those people, and unfortunately, most of those nonprofits just withdrew from all of those cases. So there's thousands of people that used to have representation that no longer do in Kentucky. We do a lot of humanitarian work. So a lot of those asylum, a lot of those U visas, VAWA, like victim-based cases, as well as children-based cases, and are now trying to expand into doing detention work because there is not a nonprofit in Kentucky that has ever done the detention work. And so trying to expand though, and having funding thing is a big thing. And so we've had some students at Berea and some other organizations that have like organized fundraisers. I know New Americans, all of the nonprofits in Kentucky are doing great work, but because the federal government has revoked the grants, and even like USCIS used to give a grant to help people apply for citizenship, like that doesn't exist anymore, and things like that, is finding ways to rally your community to support long-term legal change and ideally full representation where possible, and using clinic models where that is effective. Like having the ability within organizations to be able to weed out kind of even like who can fit into this category and who can fit into this category, even that takes a lot of administrative work. And so just recognizing that there's a lot of groups in Kentucky that are doing the hard work of trying to figure out how we triage and how we represent everyone well. And so, supporting that as well. And I completely agree. Even if you're interested in going into private practice, I've had the privilege of helping two of my past students this year open up private offices here in Lexington. And there is such a gap in private attorneys. We don't just need more nonprofits. We need more private attorneys. Like having private attorneys that I can trust to refer clients to is difficult. And having that ability to like kind of learn what you're saying of the like business aspect, if you're at all interested in that, like see if you can cross-register and take a class at the business school, like while you're still in law school, to get a little bit of that business knowledge. Because opening up your own private firm is a huge benefit to our immigrant community as well.
Yeah, and I'll reiterate everything Katie just said. Support for nonprofit organizations, whether it's legal services, whether it's direct services, it's a critical need right now. You've heard about all of the funding cuts, and I'll talk briefly about our refugee community. Of course, that program has been shut down. There were folks that had been vetted for years and years that were about to get on a plane, and then that's just shut down. So they're still in refugee camps wherever they have been. And I think it's just important for us to know that there's a population here, again, a large, significant population of refugees that needs that legal assistance. So New Americans, for instance, provides limited legal representation. So the clinic model is something we adopted because there's not enough attorneys and there is so much need. We're helping a recently opened resettlement agency called International Rescue Committee in Louisville. They resettled over 400 individuals over the past year and a half. They have no legal services. So we're providing essentially legal services to make sure that those refugees that they brought over, mainly from East African countries like Congo and Rwanda, that they have the ability to apply for their green cards when they become eligible. Because you don't just, when you come in as a refugee, you don't just get handed a green card. You have to then affirmatively apply to USCIS, wait for months. Usually you're eligible for a fee waiver. It's a 24-page form. There's all kinds of things that this administration has added to it. So it's already complicated, and now it's even more complicated. They changed the citizenship test. Meanwhile, they've revoked grants that educated individuals on how to become permanent residents and how to take the civics exam and the English exam and how to go through the citizenship process. So the lack of knowledge and information about how to do all of this is part of also what we do, is just educating the immigrant community on what their options are and how they can go around it, how they can go about it. But having attorneys to be able to refer people to is just, it's a daily concern. Every day, whether people have been picked up, whether they are, U visa holders, whether they have gone to a notario and paid tens of thousands of dollars to somebody who's not a lawyer in hopes that they filed something, only to find out that nothing was filed and some deadlines have passed and now they're undocumented, they're illegally here, they're subject to this expedited removal process, for instance. So having attorneys is crucial. What I will say, and I'm really proud of this, we have at least one baby immigration attorney that I know Chris went through your clinic. She volunteered at several, I think at every single one of our workshops, and is now working for an immigration attorney in Louisville. We need more of that. And so I think exposure for law students, just like we had, right, in law school clinics, et cetera, is important to figure out, do you like it? Do you hate it? Is this something you can see yourself doing? And then figuring out, okay, I want to be in private practice. I want to work for a larger firm. And quick note on that, larger firms that do any immigration, it's only going to be employment because you have to make a living. So you're not going to get a lot of experience unless you have, a law firm that is providing like the opportunity to do pro bono work, and then you can kind of volunteer your services. It is a dire need. And I think that the biggest thing that you can do is find an organization that provides immigration legal services, find an attorney that provides immigration legal services, and intern or volunteer or just get connected and just see what they do. Just see what they do and try to become a part of that. Try to get engaged with that because it's a very engaging area of law. It's interesting. It is incredibly frustrating. It is incredibly political and changeable. But because of that, you're always on your toes. It is not a static area of law. But I think in addition to just supporting nonprofits in wherever you are, in Louisville, Lexington, Northern Kentucky, Bowling Green, what you want to do is support them, but also volunteer or show up, right? Just show up at events. You can organize fundraisers, but there's just a need for our nonprofit community, and there's also a separate need to build a pipeline of immigration practitioners in Kentucky, and plug yourselves in wherever it fits, right? Whatever makes sense in your career, in your plans. I'll briefly just tell the story, and I present this as an example of the family. We've helped hundreds of families at this point, like 200-300. And with one legal director, by the way, Emily Jones, who maybe folks in this room know, who's out on parental leave. She just had baby Josie on Halloween. But just sort of single-handedly, right, organizing all of the clinics that we've done. And it's astonishing what a person that is full of dedication and passion for this area of law and helping families, what they can accomplish. And one of the families we were able to help, and I say this as an example to people who have no idea like what the process is like. It was a Congolese mother of 3 daughters. She had spent the last 23 years in a Tanzanian refugee camp. Her 3 daughters were born there. So 23 years and before she found her way to Louisville and to one of our green card adjustment legal workshops. We were able to help her apply, her and her 3 daughters. And one of the things that, I talk about a lot is the economic impact of immigrants and refugees in our communities, right? They billions of dollars in taxes. They build our businesses, right? They contribute, they spend money in our economy. And so one of the things that we don't think about at the advantages of having a green card is not just stability, but access to benefits and resources that non-citizens and non-permanent residents don't. So certain home loans or business loans, in-state tuition. So if her 3 daughters, when they're ready for college, if they didn't have lawful permanent residence, they wouldn't be eligible for in-state tuition. So these sort of practical, logistical impacts are critical for people who want to feel safe, but also have the ability to stay here and thrive. And so that's kind of what you would be getting involved in. It's not just paperwork, it's not just filing things, it's not just deadlines. It is the direct impact to a family and potentially generations of a family that you would have by getting involved in this work.
And I would add, to echo the first panel, I think one of the most important things we can all do, myself included, I can do more of, is to engage. We've in many ways become siloed in our society, and I don't know about you, but politics has been banned from every large family gathering because it's going to end up in a food fight. But we have to find ways to engage with those who, at least initially, may disagree with us, and those who take positions different from us, and recognize that just because someone disagrees with us doesn't make them stupid or irrational or racist. Certainly there are people the individuals who are stupid, irrational, and racist exist in the world, without doubt. But to presume that somebody who disagrees with you on a particular issue is one of those things is dehumanizing to them, and ultimately limits you in your ability to grow and engage. I can't tell you the number of times I have had people who walked into my private office who would say, well, I'm a conservative and I'm opposed to illegal immigration, but I know this person and they've worked hard and contributed to their community and I want to help, and then pays for the person's defense. And the number of times I've had somebody come in and say, I was going down a bad road, and I met this person and they were a coworker and they were a friend, and they changed my mind just by being who they are. What can we do to help them? Humanity is a spectrum in all areas, and we really, I think if we are losing the argument on immigration, by we, I say those who are advocates for immigrants and perhaps for more immigration, if we are losing that, then it is incumbent upon us to come up with better arguments, to be more persuasive, and to acknowledge when we might be wrong or when somebody else has a point, and to address those concerns and points. And I think that is one of the best things that you can do if you are interested in these issues, is to engage, not in an angry, self-righteous manner, but to say, this is what I think and what I advocate for, and I'm willing to talk to you about it as long as you are willing to talk with me in a respectful and honest manner as well. And it can be hard, right? Every one of us gets our back up and starts yelling and feels defensive when we're called out. And every other person we meet does as well. And letting go of that and trying to actually talk to people, I think, is the best option we have. Professor Bose had spoken at other symposium in St. Louis with me, and we talked about it. Democracy is hard work. It is really hard work to be in a free and a democratic society. And if that's what you want, the society you want to live in, you have to do that hard work. You have to engage other people. You have to allow for difference.
Thank you all for sharing that. It's such an important message. We've got about 2 minutes left. And so to close it out, I really want to ask you all just really quickly, what is something that you wish you would have known at the beginning of your career? Or alternatively, what is something that you wish you could have told your law school self?
I guess one thing is like, just try stuff. I think lawyers are so scared to do something they don't know how to do. Like even lawyers that have worked for like 20 years, they'll be like, well, I've never filed that before. I'm like, well, I don't know what I'm doing either. Like the number of times I've been told by a judge, you should ask a lawyer. And I'm like, I am the lawyer. Like, try something. I think don't be scared to do something different, because that's how you get victories that aren't common. That's how you get the uncommon victories. That's how you get someone to look at something differently. So like, if you don't know what you're doing, go ask annoying questions to the clerks, or go Google it, try it, get it rejected 7 times, and it'll get accepted the 8th. Like, just try something. And I think whatever field you go into in law, there's going to be a way to do it. And then there's going to be ways that you think, what if I tried this? Just try it.
The students who've taken my clinic, I don't know that any are here, know that in my clinic, there are always 3 right answers. Number 1, look at the statute, look at the regulations. Number 2, it depends. And number 3, I don't know, but let's find out. Don't be afraid to dig in and do the hard work. If you practice in immigration law, for those of us who were of a generation where it was in a book, you'd go to section 1. As cross-reference, for instance, section 1350, go to section 1350. If you fall under section 250, 485, or 645, then you can do this. So go to look at each of those sections, and you will spend hours at the beginning of your career doing that. And I suspect in any field of law. The other thing is, don't worry about small embarrassments. I've told this story 1,000 times. So the very first time I appeared in the immigration court, I'm there with my boss. I'm a new attorney, and I'm wearing a suit that I put on a little weight. And my boss said, do we have the blah, blah, blah in the file? And I bent down to get it, and I felt my pants split from the bottom to the top. And I'm standing against a wall in a courtroom full of people, and I turned to my boss and just say, yeah, I'm about to flash the entire court if I go up there. And he said, go up. And he made me stand in front of the courtroom. Nobody remembers that except for the fact that I tell that story. Don't worry about your moments of embarrassment and perceived failure. You'll survive them and get over them. And you grow from them. And now it's a funny story.
I think that's hilarious, Chris. I don't think you've told me that story, so thank you for sharing. I think the one thing I would tell myself and all of you is don't be afraid to be an advocate. I think lawyers think a certain way. I think law school teaches us to think a certain way. You're thinking about your job, your internship, what is going to be my career path, how careful do I need to be? about everything, right? And I think sometimes that holds us back from being advocates for things and for people and not just lawyers. So not being afraid to speak your mind, not being able or not being afraid to stand by your conviction and your principles and your values. I think that kind of North Star and moral compass is something that is also important to nourish and listen to. And I think just being an advocate in addition to being an attorney is important.
Thank you all so much for sharing your knowledge and experience with us today. That was our Navigating Immigration in Kentucky panel. Please give a big round of applause for our amazing panelists. Thank you all.
That would be more prepared. Okay.
I'm sure you're, yeah, sorry. Just told me a lot about your work. Yes. We'll talk again. I know. I'm so excited.
Yeah. Well, it's weird. I took a little, like, I was at KRM with Emily for like 7 years, and then I took like a year off. I was doing family law for a hot minute, and so it was like getting back. Yeah. CAYLLR.
Absolutely. Talk to the kids. It seems like stuff like
Yeah. Yeah. Yes. Feeling great. Yeah, absolutely. Well, that's it. We started so many about I was like, yes,
That's the way to do it.
All right, we are going to go ahead and keep this rolling. Our next panel will have Mr. Dan Galindo and Austin Phillips. Thank you all.
See how this, all right.
All right, good morning, everybody. Thank you for coming to the Litigation's Perspective on Immigration Justice panel. I'm Austin Phillips, and I'm a 2L staff editor on the Kentucky Law Journal, and I'll be moderating the panel. And I'm here with Mr. Daniel Galindo. Daniel is a senior staff attorney at the ACLU Immigrants Rights Project based in New York City. That's a position he's held since 2018. Throughout his career, he's been an advocate for rights and fair treatment of immigrants in the United States and continues to represent plaintiffs in ongoing immigration litigation. Prior to joining the ACLU, Mr. Galindo served as a public defender with the Neighborhood Defender Service of Harlem. He earned his JD at Stanford Law School in 2012 and then subsequently clerked for the Honorable David O'Connor on the U.S. District Court for the Central District of California and the Honorable Kermit Lopez on the Court of Appeals for the First Circuit. He also holds a BA in history from the University of Cornell University, I'm sorry. And so, Mr. Galindo, I'm thrilled to be here and talk a little bit about, litigation perspectives in immigration justice, as the panel suggests. I think maybe the best place for us to start is with the type of work that you do at the ACLU. I think it's a little bit different than the way people traditionally think about immigration litigation. So if you don't mind to talk just a little bit about, the types of cases that you deal with and how that is a little bit different than what people traditionally think of.
Yeah, happy to, and thanks for having me. So at the Immigrants Rights Project, we litigate large-scale cases that affect the rights of immigrants on a large scale. So sort of you can think of it more as the subject, the person who is affected is an immigrant, and that's sort of the unifying theme. Whatever body of law is at issue is something that we'll sort of pick up, learn if we need to, or things like admin law or constitutional law are like frequently the topics, but the subject is an immigrant is affected. And in most of our cases, it's because tens of thousands, if not hundreds of thousands, if not millions of immigrants are affected. So things like changing whether you, attempting to change whether you have citizenship by birthright, that is an ACLU IRP case. Changing sort of the fundamental rules of who gets put into fast-track removal processes like expedited removal, that is also a case of ours because it affects hundreds of thousands of people who are potentially put in to faster removal proceedings with fewer procedural protections. And so that's the kind of case that we bring. And so we rely on folks who I think are a little bit more what you might have in mind when you're saying someone's practicing immigration law. We rely on the sort of attorneys who are helping people naturalize, helping people apply for status in some way, shape, or form, defending people against removal in individual removal proceedings, going to sort of the administrative courts that adjudicate most immigration removal cases. We rely on those types of attorneys, but we don't directly practice that stuff ourselves.
And so, you talk about kind of these broader scale issues are more the type of work that you do. And so maybe for the people who aren't super familiar, how do those type of things emerge? And then how does it move from more of those individualized practitioners into sort of the work that you're doing at the ACLU?
Yeah, so many of the changes that we litigate, well, you learn about them in all the more conventional ways that you learn about them is, like a published regulation, essentially, where the administration says, we are thinking about doing the following thing, or we hereby do the following thing effective immediately. Folks have X number of days to comment, but sometimes this regulation goes into effect right now, or it'll go into effect in like 60 days, something like that. That can sort of start the clock. In ideal circumstances, we already knew that regulation was coming. We have started preparing since we even knew, but in some circumstances, there can be sort of surprises or less well known, things like that. To skip a little, but to sort of illustrate kind of how the current era can be a little bit different, and also how cases can come about. About a year before the current administration, we began to prepare for the possibility of that administration. So we divided up things that we thought that they would attempt to do. We didn't have to sort of divine that Project 2025. Folks are familiar with that document, and that effort laid out a lot of the proposed ideas for the immigration system. And then, there are also many, even things like sort of public statements, talk shows, like posts on X, that kind of thing, can telegraph, here's what is anticipated. So in the Alien Enemies Act case, we had started preparing more than a year in advance, sort of looking at the case law, looking at the statutes, trying to think through what are the arguments that we're going to face, what is it going to look like, how do we be ready once it actually arrives. The way that interacts with, there can be a bunch of different ways that it interacts with the direct practitioners. In the Alien Enemies Act case, you always need plaintiffs. And so you need to find folks who are directly affected by it, who would have standing, who face designation under the Alien Enemies Act. And so what that, because the act was being used against people accused of being in a gang, we began to reach out to practitioners, folks who represent people who would be likely affected. So if you have clients who are Venezuelan, because it was going to be used against a Venezuelan gang, folks who are generally younger men, because that's what we anticipated who would be accused of being in a gang. And then sort of who even does that work, because the reality is that there's not that much funded defense of immigrants. And so in that sense too, it's in some of the typical places that have more funding for that kind of defense where you can find more possible clients and more representation and more lawyers. So places like New York, Los Angeles, places that have stepped up and funded immigration defense. Anyway, that is maybe the beginnings of too long an answer. So why don't you help keep me on track? But
No, I definitely want to move into this discussion of the Alien Enemies Act and kind of dive a little bit deeper into what it means and kind of how unprecedented it is. But before we do, I just have one more question, kind of more on the practical side of it. It's my understanding that these sorts of immigration cases on an individualized level are litigated a lot more frequently than people realize. And so I guess I'm just curious, with your work kind of being a little bit different, is that the case for you? Do you guys usually end up in court? Is there alternative remedies that come about, or just kind of how that process tends to play out?
Yeah. So I guess stepping back for a second, definitely the direct line of defense against removal folks are in court all the time, litigating all the time, constantly. It can closely resemble what public defense work looks like. And so to sort of illustrate the point, when I was a public defender in state court, I was in court 3 to 4 days a week, if not all 5. And if you're in trial, of course, you're in court every single day. In my current work, allowing for COVID times, but making things a little bit weird in terms of the number of court appearances and everything else. Maybe a half dozen times, maybe a dozen times a year, we would be in court. It just sort of, it'll depend a little bit on how busy our cases are and at what level. But certainly if your case is at a circuit court of appeals, or if it's on its way to the Supreme Court, you're doing many months of preparation to be there for one day, for one hearing, for maybe a half an hour. So the pace of when you find yourself in court is just far less. Whether things can resolve without going to court, not really. I mean, generally not for the current sort of climate. There are, in the sort of policy realm, so like if a regulation is announced and it asks for comments, there are groups, we are litigators, so we primarily are just litigating, but there are groups that will sort of put in a comment that says, you should change this, here are the reasons, here's evidence about why this is a bad idea. that type of thing. And, depending on the regulatory climate, that might result in a change, but that's not really as I understand it, that's not the current sort of picture of any regulations coming out.
Makes sense. So I guess moving on to sort of this discussion that you alluded to with the Alien and Enemies Act, I think it's been mentioned in some of the panels before, but for people who aren't super familiar, could you give us just a little bit of kind of the backdrop for this, 1798 Act and kind of what our traditional understanding of what powers it provided the president?
Yeah. So in the 18th century, there was a fear at the time of the passing of the act, anticipating possible war with France. If you remember maybe from high school or college, the sort of Alien and Sedition Acts and the ones that sort of seemed outrageous and that were repealed and are sort of a moral stain historically and all of that. The Alien Enemies Act is the one of those package of acts that is still on the books. It's the one that's still there. It allows the president upon public proclamation to declare a nation or government to be alien enemies, and all, I'm simplifying, but all nationals of that country or folks under that government can be declared alien enemies. So it's supposed to be used in declared war or invasion or predatory incursion against the territory of the United States. It's been used 3 times. It was used in the War of 1812. It was used in World War I, and it was used in World War II. And its use in World War II, towards the tail end of the war, it was first used as the beginnings of detention and of what, paired with executive orders, then became internment, for example, of Japanese Americans, mostly out west. So that's its last use. And towards the tail end of World War II, it was used to try to remove people. So it has language that allows detaining folks, and that, as best we can tell from the historical record, is how it was used up until the sort of tail end of World War II. And then they tried to use it to actually remove people in World War II. There's relatively little case law interpreting its use, directly interpreting its use. One of the foundational cases sort of examines whether the war is over or not, because there had not been a congressional declaration to the end of the war, and decided that the court could review questions of interpretation of the act, but that it was not going to second guess whether the war had ended in light of Congress not having ended the war, and so on. So that's the sort of backdrop. Again, hasn't been used since then, and its purported use here is to label a gang as the alien enemies and to summarily, upon labeling people, the way it was used was to summarily remove them without notice, without a chance to challenge their designation whatsoever, and with forms, an attorney general's memo telling law enforcement officers, but also telling them to in turn tell the people designated that they had no right to judicial review whatsoever of the designation itself. And so that is what led to about 137 people being removed to a terrorism confinement center in El Salvador on March 15th, which was also the beginning of this litigation.
So I think you touched on a few things there that I'd like to dive a little bit deeper into. I think the first thing is sort of how the unprecedented nature of the use of the Alien Enemies Act combined with this sort of under the radar approach by the current administration. Could you maybe talk to us just a little bit about your thoughts on both maybe how sort of a novel legal concept, like using the act in ways that we haven't seen it used in the past, in combination with no notice, really has an effect on, sort of the civil rights aspect for both immigrants and regular citizens.
Yeah. So the folks against whom this was applied, the very, very, very common fact scenario across all of them, across these cases, super, super common, is folks were in proceedings. They were in the normal manner in which their claims to asylum, their claims to be here were being adjudicated. They had upcoming court hearings. They were sometimes, some of them were beginning their cases, some of them were waiting for their sort of merits hearing to figure out the validity of their claim and whether they'd be granted asylum in the first place. 3 of them came in as highly, highly vetted refugees. So having applied for refugee status abroad and having been granted permission and having come, were nonetheless designated. So just in terms of how, so there is this sort of how unusual it is historically, not used since World War II. We're not in a declared war. And the sort of actions attributed to this gang, it's called Tren de Aragua. It's often just referred to as shorthand of TDA. But the allegations are, and this also ties into the military strikes on boats that have been occurring over the recent months, because some of those are alleged to be against TDA folks. So that's the sudden designation, not of a country, not in a declared war, and trying to sort of use allegations of essentially law enforcement matters, alleged crimes, or migration as counting as an invasion or counting as a predatory incursion against the territory of the United States. So I think I think that's as surprising and as unusual as it should just sort of strike you from the face of it. So that's the sort of writ large, but in the narrower, like, what is our sense of due process for each person? The sort of shocking aspect of it is, you're defending a client, you're about to have your hearing, and all of a sudden they are moved from New York to Texas, and their case is not in Texas. They have no reason to be in Texas. They have no reason to be immediately removed, et cetera. And then they are put on a plane, flown, multiple stops, and then dropped off in a country that's not their country and taken straight to prison with sort of film cameras taking it all in, and the whole thing being posted online by the Secretary of State and the President of El Salvador. So that I could sort of go on for quite some time about how unusual and how shocking it is, but that's like, those are just different elements of just how unprecedented this use was.
Yeah. And I think maybe kind of, you alluded to it a little bit there, but looking kind of in a practical sense, what does the sort of removal or lack thereof of a proceeding kind of look like on the ground? I think you talked about at the beginning this idea that we've had sort of expedited removal as something that existed in deportation matters, but I guess maybe if you could give us a little bit of an idea about the scale of the difference between, that sort of traditional expedited removal and kind of what's happening now, both in terms of the timeline and also kind of the procedural matter.
Yeah, so let me try to step back and
yeah, apologize.
Well, and also just sort of caution that, like, I don't represent folks in expedited removal or in regular removal proceedings, so I am going to give a very short overview, but yeah. So expedited removal was passed in 1996. It attempts to create a very fast way to remove people that raises a lot of due process concerns. The sort of scale at which you might be able to remove someone under expedited removal can be same day, it can be a few days, it can be about a week. It sort of depends. What's unusual about expedited removal and why that itself was such a big change was it's not generally before an immigration judge in the initial interview. It can be just with the sort of border officer that you've encountered there at the border. And so within the course of a couple of hours, and my understanding of sort of what it looks like when you might be subject to it is someone asks you if you've been in the country fewer than 2 years, because that is one of the criteria for whom it's applied against. So that can be a few hours. If you say that you have a fear of persecution, if you say you have an asylum claim, you are supposed to be referred for a credible fear interview that an asylum officer can administer to you, usually remotely. You usually don't have a lawyer there when that happens. And then if you lose that, then you can be summarily removed without further, generally without further proceedings. You can, in some circumstances, also ask for an immigration judge to review the determination if you lose. That review is supposed to happen within 24 hours and not more than 7 days. So that's very, very fast. If you were to pass that credible fear interview and you then get taken out of this fast track removal and instead you go into regular removal proceedings. Regular removal proceedings, and I'm simplifying so much, but regular removal proceedings, how fast that goes, I'd say the sort of biggest determiner is whether you're detained or not. If you're detained, it goes faster. It could resolve itself within a few months, might be the sort of timeline. You'll have different hearings. If you're not detained, those are the kinds of things that can happen over the course of years because of how slow the immigration system is and how understaffed it is, and so on. So that's some of the normal pace. And like I said, the folks, and so the Alien Enemies Act is sort of just, its designations are inserting itself into that system, plucking someone who is in those adjudications that could be months if they're detained or years if they're not, and then that's it, just removing them and taking them to prison where, the representations to them at the time were, you're not getting out, there is no getting out of this prison, there is no access to counsel, you're in not your country, and being told that you have zero rights for what happened. I know this is jumping around a little bit, but some months after our litigation began, the US and Venezuela negotiated a swap. And so people were taken out of that, Venezuelans were taken out of that prison in El Salvador, and they are now back in Venezuela.
So I think what you're kind of alluding to is that, traditionally there is some level of recourse once these deportation proceedings begin under our traditional understanding and the system before kind of this implementation of the Alien Enemies Act. And so I guess the question is there recourse for somebody who falls into the designation that at least the administration claims allows them to remove somebody through their authority under the Alien Enemies Act?
Yeah, so that's the litigation here has a bunch of different elements, but one of the very first ones is just procedural. What process are you entitled to? And then there are also aspects of it that are the substance of, can this even be invoked in the first place, which raises questions of, can the court review it? What does it do with sort of representations made by the government? What kind of review can it provide to those representations, et cetera? But the sort of bedrock first step is, are you entitled to notice in the first place? What does that look like? How much time do you have, et cetera? In its past uses in World War II, generally folks were given 30 days notice before, and a chance to leave if they wish to leave. The statute has a clause about essentially folks have the chance to depart voluntarily if they wish to. So this use purported to give no notice, no time, and just summarily put you on a plane. And from declarations and talking to people, our reconstruction of how it played out is that when the plane had landed, folks were handed forms that they didn't understand, not in their language, that told them what happened. So once the plane is already there and they're gone. So the first trip of this case up the sort of chain from district court to the District of Columbia Circuit Court of Appeals, sorry, the DC Circuit, and then to the Supreme Court, was about two things. One is somewhat technical, is whether the case had to proceed in habeas. But then the second, and the point at which the court was unanimous the first time it went up there, was that folks have to be entitled to due process, to notice, to a chance to file, and a chance to respond. And that part of the holding was 9-0, everyone agreeing that essentially what was done to these folks does not comport with due process and that they require it. Why don't I pause?
Oh, no, I'm just enjoying listening to you go on about it. I think, go ahead, sorry.
Okay, so then about a month, so that's March 15th of this year. And that goes up very quickly to the Supreme Court. About a month later, after that ruling, essentially the government tries again, and this time they try removal with about 12 hours notice, as little as 12 hours and perhaps 24 hours. And they do it, now the cases have to proceed in habeas because of the Supreme Court's ruling. That raises interesting habeas issues, including whether you can proceed as a class, as a habeas. And they do it at a facility called Bluebonnet, which is pretty hard to get to, not well resourced in terms of immigration lawyers who can talk to folks, but a lot of the people there came from other places and did have counsel, and that counsel worked extremely hard to be in touch with their clients and understand what was happening to them. And when they started getting these forms again, that they had sort of told their clients, if you get a form you've never seen before, call me. If you get a form that, we had seen what the forms look like, and they have a little notation in the bottom corner. And so, if you get a form that has this notation in the corner, like schedule a counsel call, tell them immediately, et cetera. And so that is the second time this case went to the Supreme Court, this time on emergency appeals brought by us on a very, very fast sort of same-day basis to try to stop 12 to 24 hours of notice that folks were going to get. We are now at the point, having won that emergency appeal and having effectively, for now, halted the use of this Alien Enemies Act, we're now at the point where the government thinks that 7 days would suffice. So 7 days of notice. If you get to file it, if you manage to file a habeas claim, which for many people is going to be pro se, then you won't immediately be removed. But 7 days, which for anyone who's worked with folks in detention, especially in some of these facilities, is just extremely, extremely hard. But that's 2 trips to the Supreme Court later. The sort of ideas of how quickly this might proceed has reached the point of perhaps in 7 days, and folks are still fighting over it. And so all of that is, again, we spend so much time on process in law school, in part because oftentimes, like, that's the very first threshold. What is to be figured out first in these cases, and that's where this case still is thinking about process, thinking about how the case had to be brought, and thinking about how fast, what is appropriate for someone to be told, and how much time should they have before you whisk them to a jail of torture in another country.
Oh, absolutely. I think, we've talked a lot about this due process issue, and obviously that's very central to the issue. But I think one thing that you and I have talked about is that that's not kind of the only civil rights aspect that the sort of implementation of the Alien Enemies Act brings with it. I think there's been at least a hint from the Attorney General's office that they don't feel particularly bound by traditional Fourth Amendment protections during the implementation of these sorts of proceedings and detainments. And so I was hoping you could maybe talk just a little bit about sort of the implications beyond just the due process and into our more traditional civil rights that, even a layperson thinks of.
Yeah, I think it is a little bit receded from prominence just because of the temporary halt to use of the act. But the original Attorney General's memo, and I should say that memo was not, that memo was leaked and published in media, et cetera. It was not openly published by the Attorney General, just as the president signed this proclamation in secret and did not publish it on the White House's website until after we had sued and after folks were being moved onto planes. So again, just to sort of underscore like how sort of shocking and unusual government operating in secret is in these circumstances. But the Attorney General's memo also mentions in a footnote, indicates that they do not think that if they are pursuing an alien enemy, that protections of the Fourth Amendment would apply to stop them from entering someone's home. That I think, like thematically and where things are with other emergency litigation and deployment of National Guard and sort of enforcement of immigration in cities, ties into sort of a broader idea of Fourth Amendment principles of just what is enough basis for restraints on your liberty, what is enough basis to stop anyone and accuse them of not being here lawfully in the country, and what does that look like? And so that memo, that aspect of entering someone's house without a warrant, I think is salient, I think, to all of us, right? But it also ties into some of the Los Angeles raids and immigration enforcement as well, because the sort of central point from all folks concerned about Fourth Amendment rights is that deprivation of someone's liberty is not going to be correct many times, especially if folks are acting quickly or acting on limited criteria or profiling or any of the sort of abuses that folks have documented and seen in the first few months of this administration and its enforcement efforts. So that's the sort of broader tie-in, and that's the sort of broader thematic point about why, again, this is sort of a broader civil rights issue of seizures and stops and that kind of thing. And then it also, affects everyone, but it also particularly targets immigrants.
And so you talked about it a little bit, but maybe could you talk just a little bit more about how the use of the Alien Enemies Act kind of plays into this wider approach to the current administration's immigration policy, whether it is the deployment of the National Guard in cities or the president's use of Section 212F to close the border and some of these other things, asylum fees associated with different procedures. Could you just talk about maybe what it all means, sort of taking a step back holistically?
Yeah, I mean, I think it's a breadth of attempts to restrict liberties, to make it harder to seek asylum, to sort of restrict, fundamental promises that this country made in building its immigration system and in responding to World War II and in responding to sort of the various, very obvious facts that people have always sought refuge in this country and always will seek refuge, and what obligations we owe to not return people to places where they might be killed. And so, I think it is such a broad range of things, and it is sort of a lot of things that were anticipated, but that actually, just hadn't been carried out until this administration, hadn't been attempted before, and now they're finally being tried, and we have to sort of see how our court systems respond and see how lawmakers respond and see how the public responds as well. But I think in your question, you sort of covered like just some of the so many different points of our immigration system where the effort is to make it just much, much harder, or categorically make it impossible to seek asylum, or make it impossible to seek asylum unless you pay, $1,000 once you're granted it, or pay a fee for how long your asylum application is pending. That's one of the fees, though obviously the length of which your application is pending is not up to you. It's up to how slow our asylum system is, but essentially taxing people for the pendency of their application, or fees for visas for folks abroad. All of those are sort of it's a vast system that regulates who gets to immigrate to the country and on what basis. and at all these different steps, and then also at the sort of point of attempting to remove people, you're seeing these like drastic changes and changes to the rules, changes to who enforces them, changes to how they're enforced through use of military or through increasing sort of use of military to do things that they didn't do before and go to our cities to assist in immigration enforcement. And so I think that all is a bunch of different pieces, but it's all, the same general effort that we're seeing.
And so maybe kind of turning back to this litigation perspective, what is, all of this uncertainty about the implementation and all the changes that are going on in immigration policy kind of mean for both practitioners like yourself who are kind of working on broader issues, but also for individual practitioners, working on individualized cases?
Yeah, I mean, I think it is dizzying across the board. I mean, I think in different sort of ways. If you are trying to help someone navigate and apply for asylum and trying just to figure out even like what fees apply and what you should tell your client about it, even that has sort of changed. For folks who are trying to defend rights under our system and defend that promise of being able to seek refuge in this country, it means sort of a tremendous amount of like divide up all the different fights that need to happen and make sure that someone can cover them, because there are, it is very much not just us who does this work. There are many, many great, strong partners that work on these types of cases. And so there's just a certain amount of coordination that has to go into what folks see coming in the future, who has capacity to litigate them, who has expertise, has anybody litigated this type of issue before? Does it raise any, we work a lot on sort of jurisdictional bars and things that prevent you from being able to even get into court in the first place. And so that's like an overarching gloss in many, many of these cases, is not just, do you have an argument that this is illegal, but can you actually be heard by a court somewhere? Can you get class-wide relief? All of those things are recurring issues across the board. And so because we specialize in can you even get into court in the first place in many cases, that does mean there's a lot of cases for us to track and a lot of ways that we might, even if it's not our case, consult on, well, what are the obstacles you're going to face to even get this case heard or to try to get the relief that you're seeking? But then aside from that, there are some of the ideas going on are new, but some of them are not. So I mentioned expansion of expedited removal, that like fast way to attempt to remove people. That was tried in the first Trump administration and de facto blocked by a case that we brought. And so now it's back again, and now we are litigating that again. And so, when it comes to figuring out, well, who's going to fight that particular fight, it obviously makes sense for the people who already brought the case and already did all that work to do so. But that's the kind of, a thing that I did not appreciate about this work before I did it, because when you're a public defender, you sort of are like a little bit of like an island to yourself, and you don't have to coordinate that much with that many other lawyers. But when you are sort of a impact litigator in this universe, you spend a ton of time talking to other people about who sees what coming and who will tackle it and who has capacity to do so, and just making sure that you're not all litigating the same case, because there's just too many to be brought.
So we're getting close to lunch here, and I don't want to keep anybody from their lunch, but I think we do want to open it up and give people the chance to ask some questions based on kind of everything that you've talked about. But before we do that, I just would ask if there's any piece of advice you would give somebody who is kind of entering into this space with kind of all the uncertainty and all the different legal challenges that are coming. I guess what would be kind of your thoughts?
Yeah, I mean, I thought I caught the tail end of the last panel, and I really liked the sort of advice that folks gave, because it strikes me as just kind of universal across contexts of like be willing to try out different kinds of advocacy, be willing to sort of like, I think a lot of lawyering is a sort of or effective advocacy is like getting over yourself and doing it for the client and figuring it out and asking that embarrassing question and figuring out like, right, there's the sort of like, there's the sort of stand up in, I don't know if everyone was in the last panel, but there's the like stand up in court anyway, even if you ripped your pants. But there's the sort of rhetorical version of that, which is like, good, that was great. But but there's the rhetorical version. There's the less colorful desk office version of that, which is a sort of like email someone else and say like, hey, even though I've been doing this for seven years, I have no idea what I'm doing when it comes to this particular challenge that I'm looking into. Can I pick your brain? Like, you might think that I would, like, people all the time will sort of be like, oh, you litigate like large scale immigration issues. Like, what about this? I'll be like, that's not, I know who to reach. And that's like very often the answer is, the beginning of who to reach. And so, I think that reaching out, leaning on other people because they're almost always willing to help. And then I think there definitely is like a very healthy dose of like, think about and like challenge yourself to make sure you understand your own like moral compass and what is right and what is wrong, because I think that center matters so much. And especially like, I often think legal training can sort of inculcate this idea of like, you become a lawyer to like engage in this game and there are arguments on both sides and you need to understand both sides and all that. All of that is true. I generally think one side is right morally, especially for the work that I do. And so I think you like cannot lose sight of that, because it just has to be always sort of guiding like your sense of what's possible, your sense of what you have to do, your sense of when to push back, and like how to sort of calibrate that as you go about.
That's awesome. Thank you. Okay, I think we're gonna open it up to questions. So if anybody in the audience has a question, feel free if you are starving to go get lunch, but we did want to give the opportunity. Go ahead.
That really stuck out to me was you're talking about how you're anticipating things, like looking at Project 25 to act podcast better. I hadn't heard that before, and I was wondering where the AEA fits in that. Like, is it a Project 25? Did you find out about it on Twitter? Who mentioned it on a podcast? I hadn't heard this kind of discourse.
Yeah, it was in various forms of reporting, usually like not attributed. Believe Stephen Miller talked about it on a podcast. So it circulated enough. I mean, essentially, yeah. So but it didn't. It was not as prominent as some of the other telegraphed. This is what they're thinking about doing. But yeah. So it was like it was there. It was bubbling, and thinking through, including its use against gangs and not against a nation or a government, which is its own aspect of this case that I've only like gestured at, but is super interesting as well. So it is a little bit just sort of like snippets of how they're going to use it and who it's going to be used against, and like a lot of, that's the part of being a lawyer and understanding your opponent and who's going to do what and so on that you have to indulge, right? Just like if I were trying to think like that, what's the most extreme use that I could use, and like ignore the little part of your brain that says like, that sounds really wrong, or like that's right, because that no longer, that does not mean that's not how it's going to happen. Like that guardrail does not exist. If your part is like, well, that seems too extreme, that's not a guardrail anymore. So that's the sort of thinking through process. But then, yeah, paying a lot of attention to like news coverage and like publications and media you might not otherwise read.
Any other questions?
You mentioned last night, we were talking some, is that as an ACLU litigator, the case work that you do is not entirely based in immigration law. I guess I just wanted to ask, what are some potential challenges that you faced or that you see other litigators facing that want to try to work more in that field, particularly, or go back and forth between different fields?
Yeah, I mean, it actually, I think, sort of ties into the like advice of humbling yourself, because it just, we really want to think that, like, we as lawyers really want to think that we are an expert in this before we like open our mouth and like talk about it, or like put things down to pen, or start to work out what a claim looks like. And it's amazing when you feel like you are an expert on it and you can sort of be like, well, I understand this, or like, I feel relatively comfortable when someone sort of brings me like an interaction with like criminal law and the work that we're going to do. So like when I sort of read in the Attorney General's memo, like an idea that they might think that they can go into someone's house without a warrant, like that sounds in like an area that I have some comfort with, because I have like litigated suppression motions and have that sort of world. But then, you know, so much of the stuff that we do is admin law, which can be quite painful as a sort of like body to like corral and to feel comfortable in and to feel any degree of expertise on and so on. But again, it's a sort of like humbling yourself about what you know and how you're going to get up to speed. I mean, I like across all contexts of being a lawyer, including this one, it's the same basic move of getting over yourself, whatever it means, whether it's, you know, intellectual confidence, whether it's social confidence, any of the ways that like you feel a hesitation that is perfectly normal, but getting past that is like the hardest part of it.
Any other questions? All right, I think that is our immigration perspectives on litigation panel, and we just want to say thank you so much again, Mr. Galindo, for coming.
Yeah. Thanks for having me. Oh.
We will return at 1:20 p.m. for the next panel. Thank you all.
All right. Thank you guys for being here. I hope everyone enjoyed their lunch. We are going to be moving on to the birthright citizenship and U.S. territories panels. All of our panelists are going to be joining us virtually today. And so I'm going to start with those introductions. We have Professor Anthony Scioli. He's the senior law clerk and special assistant to the Chief Justice of the Supreme Court in the U.S. Virgin Islands. He also serves as an adjunct professor at St. Mary's University School of Law. His scholarship is focused on the constitutional, institutional, and human rights dimensions of territory-based law. We're also joined by Mr. Neil Weir. He grew up in Guam. He's practiced as a civil rights attorney for over 15 years. He's the co-founder and co-director of Right to Democracy, an advocacy group that is focused on dismantling the colonial framework in U.S. territories that are promulgated by the Insular Cases. He's co-authoring a forthcoming casebook, The Law of U.S. Territories, with Professor Scioli as well. And then we're also joined by Mr. Charles Ala Lima. He was born in American Samoa and has practiced law for over 40 years, working to make birthright citizenship a guaranteed right to those born in the U.S. territories. He serves on the board of directors for Right to Democracy. And Mr. Ala Lima and Professor Weir have worked together to litigate several landmark cases addressing birthright citizenship. We're extremely excited for this panel in particular because while birthright citizenship has been a popular topic of debate nationally in the last year, this panel is going to narrow the scope of that conversation, specifically addressing how the 14th Amendment applies to birthright citizenship in U.S. territories. And we're going to start off with some background information. Professor Scioli, I'd like to turn it over to you. What concepts would you say are the most important for people to be familiar with before we dive into the discussion?
Hi, good day, everyone. I'm sorry I can't be there in person. I was scheduled to be there with all of you, but as a consequence of the government shutdown and the reduction of the number of flights starting today, I had to cancel my trips because I just cannot afford to be stranded in Lexington or Philadelphia overnight because tomorrow is my daughter's 6-year birthday party, and she would be very mad at me if Daddy was not there bright and early to celebrate with her. So I apologize for that. I also apologize because I was expressly told I cannot use PowerPoint, I cannot share my screen, but I was not told I can't use props. So I have some physical props with me here because I think what I'm about to discuss needs a little bit of visual. So when you think of the United States, you probably think of something like this. And the lower 48 states, if you were a tourist from abroad, you're going to the Empire State Building, you're going to see the U.S. Capitol, you're probably going to buy a T-shirt that has the United States look like that. Now, as we know, that's not really the map of the United States. This is a map of the United States, right? With Alaska and Hawaii added. Wrong. That is not the map of the United States. This is the map of the United States. And you're probably not able to see everything, but you have you have the lower 48, you have Alaska, Hawaii. Then you have places like American Samoa, the U.S. Virgin Islands, Puerto Rico, Baker Island, Howland Island, Wake Island. And so the question is, how do we get here? You know, the topic of this is birthright citizenship and the 14th Amendment. I mean, the 14th Amendment says if you're born in the United States, you're a U.S. citizen. So how are we even having a discussion about the 14th Amendment and how it applies to U.S. territories? Well, I'm going to go back a little bit in history to explain how this came to be. Now, just like we think of the T-shirt map of the United States, when we talk about the 13 colonies, the original 13 states, we're probably thinking of something that looks like this, which is the boundaries of those 13 states as they are now. But again, that's wrong. It really looked like this back at the time of the founding. You're probably not able to see this because of the color of the screen, but you have West Virginia as part of Virginia. You have Massachusetts claiming parts of Michigan. You have Connecticut claiming parts of Michigan. You have Vermont being claimed by New York. You have North Carolina going way, way, way out to the west, as is Georgia. And South Carolina has little tiny tips, similar to Oklahoma, going down that way as well. So what happened was you had states making claims to all the land in the West, an uncontrollable amount of claims, making claims by themselves, no order, a lot of disputes between them. When it came time to create the U.S. Constitution, the solution to this was the territorial clause, which was to make Congress essentially make needful rules and regulations respecting the territory, essentially to act as an overseer. Now, I'm not going to go into manifest destiny and all that, but that T-shirt map that I showed you became the shape of the United States in 1854. And that only stayed in place for about 4 years. And even when it did come into place, a big chunk of the US, more than half its landmass, was still US territory. So 1854 to 1858. What happened in 1858? It's not us getting Alaska or Hawaii. It's us getting, I'm sorry, 1856. It's us getting Baker Island and Jarvis Island all the way in the Pacific. Now, I ordinarily have about 10 slides showing all the random islands that the US claimed in the 1850s to the late 1890s, but the real point of the story is, why did they do this? Why are they getting all these uninhabited islands in the middle of nowhere and claiming them? Well, it comes down to essentially bird poop, guano, which was very useful ingredient for making gunpowder and a variety of other materials. And so the U.S. Congress passed the Guano Act and said, hey, if you're a U.S. citizen, you find some random uninhabited island that has guano in it, you can declare it as part of the United States. And people did that. And in addition to that, though, the U.S., of course, acquired Alaska from Russia, annexed the Kingdom of Hawaii, and also brought in other territories such as American Samoa, which joined voluntarily by treaty. It also won the Spanish-American War and got the Philippines, Guam, Puerto Rico. In 1917, it purchased the U.S. Virgin Islands from Denmark. It created the Panama Canal Zone and took a slip of that land from Panama. So the map of the United States, as it was at the turn of the century, was like this. The U.S. had area that claimed pretty much all over the world. Now, what made these new territories different from those territories that were part of the mainland United States and that big giant middle that existed in the 1850s? Well, here's some political cartoons from that era that should give you an idea, give you a sense of it. They were largely non-white. They were of, in the U.S. Virgin Islands, they were of Afro-Caribbean descent. Elsewhere, had Pacific Islander descent. In the Philippines and Puerto Rico, obviously had Puerto Ricans. They were all, virtually all non-white. And this is how a large segment of America viewed the inhabitants of those possessions. And that spurred debate. And, do we really want to treat these territories the same way as we treated these other territories that came before? These other territories in the Midwest, the Mountain West, should Guam, should American Samoa, should the Philippines be treated the exact same way? Should they all get the same rights? Should they have a right to free speech? Should they have a right to a jury trial? Should they have the right to bear arms? Should they be able to have representation in Congress or vote for president? And the answer ultimately was, from the perspective of many people, no. And the reason for that was the white man's burden. Here you've got another political cartoon that shows really how how a lot of people felt about these territories. Probably can't see the writing, but essentially you have Uncle Sam carrying Cuba, Puerto Rico, Philippines on his back. And the whole idea of the white man's burden was that you can't treat people in these alien races and these savage lands the same way as you would, white Anglo-Saxons. And so I'm just going to very quickly read some quotes, some real quotes that were made at the time when this is all happening. This is from U.S. Senator Benjamin Tillman from South Carolina on the floor of the Senate. Those Filipino peoples are not suited to our institutions. They're not ready for liberty as we understand it. They do not want it. Why are we bent on forcing upon them a civilization not suited to them, and which only means, in their view, degradation and a loss of self-respect, which is worse than the loss of life itself? I've other quotes there from people like Simeon Baldwin, Avid Lois Lowell, and Chris Columbus Langdell, and the like. But essentially, it was a form of paternalism. It's racist paternalism, and that you believe that the white race is so superior, American, European institutions are so superior, and the people in these islands from a different culture don't speak English, they're not white, they just don't understand it. They've had their own different institutions based on Spanish law or based on local indigenous custom that's been in place for hundreds of years, but they just can't handle free speech. They can't handle being on a jury. They don't know what it is to be on a jury. We can't trust them to arrive at the right results. So, it's actually bad to force it on them. We're not going to force this on people who don't want it. So let's just say they can do what they want. Now here's the problem. The U.S. Constitution. The U.S. Constitution says you have a right to a jury trial. The 14th Amendment says that you have a right to be a citizen if you're born on U.S. soil in the United States. Well, here's where the insular cases come in. The U.S. Supreme Court had to resolve this divisive issue, a series of 5-4 decisions, and the majority essentially held, and Neil can go on to some more detail, essentially held, hey, these territories, there are different types of territories. There are the so-called incorporated territories that made up what is now the 50 states, made up that Midwest area, that Mountain West area, and just so happen to be majority white. And those territories, we always plan to make them states. Those territories are states in training. They're incorporated into the Union. The Constitution is incorporated into them. And so every aspect of the U.S. Constitution, the Bill of Rights, all that applies if you're in the Northwest Territory, if you're in the Colorado Territory, if you're in any of those places. But these other possessions, the Puerto Rico, Guam, the Philippines, they're unincorporated. We're not going to make them states. They're never going to be states. We're never going to have them advance beyond this level. And we also care enough about them to not force our way of life onto them. So Puerto Rico, if you want to continue to have people tried in criminal cases without a jury, fine. That's perfectly okay. If you want to go and place restrictions on firearms that maybe couldn't be done elsewhere in the United States, go for it. If you want to limit who's able to vote, just if you want to violate one man, one vote principles, go for it. All in the name of preservation of indigenous culture, essentially. And that is where the 14th Amendment comes in, because the U.S. Supreme Court in some cases did leave one little crack, a little chink in that armor of cultural, of doing all this in the name of preserving culture. If a right is fundamental, then it applies regardless of whether you're incorporated or unincorporated. Now, what does it mean to be fundamental? We consider things like the right to a jury trial to be fundamental, but the U.S. Supreme Court disagreed and held in the Balzac case, which was the last of insular cases, that the right to jury trial doesn't apply. It's not fundamental. It doesn't apply in the courts of Puerto Rico or the courts of the Philippines. So citizenship, you would think that citizenship is, it's often called the right to have rights. We think it is the most fundamental of all the rights in the U.S. Constitution. But you may be surprised at how some federal courts have held otherwise. And with that, I'm going to turn it over to Neil and Charles to explain the practical significance of how this continues to apply today.
Thank you, Professor. So yeah, we will be handing it over to Mr. Alaa Lima. He actually has some hands-on experience, working to overturn the insular cases, specifically with the case that he's litigating right now, Alaska v. Smith. So Mr. Alaa Lima, could you kind of explain some of the information on that case to us?
Well, thank you very much for this opportunity.
Thank you.
Neil and I have been working together for the last 12 years, trying to bring some kind of closure to these issues of why we are not considered U.S. citizens by birth, despite being born in sovereign U.S. territory. Our most recent effort, our past efforts, we have been knocking on the door of the Supreme Court, but have not been able to get into that door through the first case called Tuaua, and the second case, the Fitisimanu case. And one of the reasons why I think we were not able to get through the door was that were objections from the local government, plus also the unwillingness of the Supreme Court to try to overturn the insular cases. So we're still knocking on the door. Alaska v. Smith represents, I think, one of the reasons why I think a lot of people were looking at those cases is they're just being advisory. there was not really any, serious effort. They think that was just the, White Tower professors trying to get the insular cases overruled, and that didn't have any real world impact. Alaska v. Smith presents a much a real dynamic where there is real effect on regular people. Tupe Smith, our client in this matter, is a young mother. She's married to Michael Pese, and they were both born in American Samoa, and they graduated from high school there. They met again in in Seattle, and they got married there. They then moved up to this little tiny town called Whittier in Alaska. Beautiful location, surrounded by a fjord, surrounded by glaciers, and only one way in through a one-way tunnel. The permanent population of this town is about 250 people, and they live most of them live in this one apartment building. Tupe had 2 children, and they were going to school at the very small school there. Samoans at that time represented about 30% of the population of the school, and she was very active in it. And she was asked by the community to run for school board. She said yes, she could run. She was also a member of this Provident Fund that Alaska has for giving funds to residents based upon any lawful resident of Alaska is entitled to it. And so during the time of doing that application, she was automatically registered to be a voter, as were thousands of other Samoans up in Anchorage who registered to vote up in Alaska, who were then automatically registered to vote up in Alaska because of the automatic voter registration. Tupe did run for a school board, and she won. Unfortunately, there was somebody there that did not like the fact that she won and reported up to the state level police that there had been, or to the Attorney General, we're not too sure where, reported that there is some illegal voting. In late 2023, the police secured a warrant, came through that long tunnel, came up to her house, interviewed her, then arrested her in front of her children, took her 50 miles away to the women's facility just north of Alaska, strip searched her, charged her with numerous felonies for voting, and then she was released. Her husband followed her from Whittier and was able to get the bail and posted bail. She was then released and sent back. She was then indicted by grand jury and proceeded. First, initially, she had the public defender. And then when I heard about the situation, Neil and I discussed it, and we decided that we'd go up and see what we could do to assist her, and also to help the Samoan community up there understand their rights. We then went up there, met with the family and with Tupe. We met with the public defender, and basically there was an agreement that and through Neil's connections up in Alaska, we got a very good team of private attorneys to take the case up pro bono to assist us in what we thought was a very important matter. We took over her representation. At the time, there was a motion, pretrial motion, before the court that had been filed by the public defender, arguing the issue of whether there was an intentional violation of the law dealing with the intent. We then, that motion was denied initially by the judge, but then it was taken up by appeal, and usually the Alaska Appellate Court took up this appeal pre-trial so that it could review the situation. we recently filed our briefing on it. The state has responded, and we've filed our reply brief. And so that situation as it exists now is that the everything is sort of on hold until the appeal court rules on this issue of intentional violations of intent. In the meantime, Alaska state decided that they were not just going to be happy using Tupi as an example. What they did was then in 2024, around February, they sent 25 state troopers through that small tunnel, going out and fanning out into that small community looking for the Samoans and going with a list of people that they wanted to find out about. They went to these people's place of employment. They went up to their homes, knocking on doors, creating a very difficult situation for the Samoans living there. And they were specifically looking for Samoans. They did not take anybody in. They did interviews, but they didn't take anybody in. However, subsequently, this year, they decided to add 10 more people to their list of people they're going to charge, including most of Tupi's family, her husband, her mother-in-law, who was suffering from cancer, and others were then charged with their voting and perjury for basically ticking what they said was the wrong box on the application form that got them registered, the application for that Provident Fund. Those cases, they have gotten through the indictment phase. Everything is sort of like on hold, waiting to see how the appeal court rules in Tupi's case on the issue of intent. So at this point in time, we are working with the Samoan community in Alaska to try to ask that the government not look at this situation for American Samoans as a criminal action, but just deal with this thing administratively. We've also gotten support from our local politicians in American Samoa and from the local community in American Samoa to ask that at least prosecutorial discretion be asserted here and not take American Samoans who were born on U.S. soil, deal with the issue administratively, do not deal with it as a criminal act, because these people are born owing their allegiance to the United States. So that's the status of the Tupi case.
Thank you. Thank you so much. We're actually going to move on next to Mr. Weir, who has worked extensively alongside you on these cases, specifically through his advocacy group, Right to Democracy. And so, Mr. Weir, if you don't mind explaining first Right to Democracy's mission, and then could you delve into some of the specific legal concerns with Alaska and the other cases that you guys have worked on?
Absolutely. And again, sorry we can't be there in person today. I appreciate you accommodating us to talk about these issues. So I co-direct Right to Democracy with Eddie Martinez-Roman. We work on advancing democracy, equity, and self-determination for the 3.6 million people who live in U.S. territories. I grew up in Guam, so we do a lot of work in Guam, the Northern Mariana Islands, American Samoa, Puerto Rico, and the U.S. Virgin Islands. And this case, as Charlie said, really highlights what's at stake when people are denied recognition as U.S. citizens and instead labeled with the subordinate status of non-citizen U.S. national. And so just in Alaska, in some situations, American Samoans are treated the same as U.S. citizens. And under Alaska law, U.S. citizen is even sometimes defined to mean people born in American Samoa for certain benefits purposes. Other times, American Samoans are treated the same because they're also residents of Alaska for benefits like the permanent fund dividend or for other benefits programs. But for more than 24 programs and purposes in Alaska, everything from voting to serving on a jury to running for office to serving on boards and commissions to being able to get mineral license rights or to have fishing rights. Those are restricted to United States citizens only. And then there's another category in Alaska where certain benefits are provided to people who are either US citizens or permanent resident aliens. And so there are actually a lot of situations in Alaska where these people born on US soil, recognized as US nationals, are actually treated worse off than people who are foreign nationals. And all of this, perhaps not surprisingly, is incredibly confusing, not just to the American Samoans living in Alaska, but to state and local officials who actually guided and instructed these defendants to check that they were US citizens because they didn't know the difference, that told them they were eligible to vote, to run for office. You have members of the Whittier City Council testifying to that in local hearings. You have the Department of Motor Vehicles chair saying they didn't know the difference between US nationals and US citizens, and there was no place on the forms where they could check that they were a US national and not a citizen. You have the director of elections who had been asked for years, are American Samoans able to vote? Had not answered that. And then even after this litigation took place, said that local election officials aren't trained to know that there are some people who have US passports, but aren't actually recognized as citizens. And all of this, again, because of this anomalous status of non-citizen US national, people who owe permanent allegiance to the United States, but whose rights and benefits are subject to the determination of Congress, to local states, and even local municipalities. And all of this flies in the face of the text, structure, history, and purpose of the Citizenship Clause of the 14th Amendment. So you have, in very plain terms, the text of the Citizenship Clause says if you're born, quote, in the United States, you have a right to be recognized as a US citizen and a citizen of the state you reside. And at the time the 14th Amendment was ratified, there was a widespread understanding that the United States included the territory. So you actually had a very well-known Supreme Court decision, Loughborough versus Blake. The famous Chief Justice John Marshall said, the United States was the name given to our great republic, which is composed of states and territories. Then you have the structure of the 14th Amendment itself. So in Section 1, the Citizenship Clause, it talks about in the United States. In Section 2, apportionment, it talks about in the several states. And then going to history, you had Senator Lyman Trumbull, who was then the chair of the Senate Judiciary Committee, so kind of the leader of the push to ratify the 14th Amendment. He explained the structural difference, saying that while the second section refers only to persons, refers to no persons except those in the states of the Union, the first section refers to persons everywhere, whether in the states or in the territories or in the District of Columbia. And so you have a very clear textual, structural, and historical understanding at the time of ratification. And of course, as my colleague Anthony mentioned, at the time the Citizenship Clause was ratified, nearly half of the United States was in fact US territories. The land area of the United States was US territories. So had those who drafted and ratified the Citizenship Clause intended to exclude people in the territories from being recognized as birthright citizens, certainly they would have said so at the time. And so these issues are, as the United States is discussing these issues in the context of the Trump executive order, and as people are being prosecuted in Alaska for being denied recognition of US citizen, since despite being on US soil, these are critical issues for conversation. So I'm glad you have this forum to talk about them today.
Yeah, thank you so much for that explanation. And now I'm gonna open this question up to any of you guys. You just mentioned the Trump executive orders, and I know that when we talked, these might not have the same effect in the territories as they will here. So would any of you like to explain that difference?
Yeah, I can jump on that. So the Trump executive order focuses on the part of the text of the citizenship clause that says subject to the jurisdiction thereof, and understanding what that exception in the citizenship clause, how broad is that exception? Up until very recently, the near universal understanding was that it was an extremely narrow exception, focusing on children born to diplomats in the United States, to children of Indian tribes that were not subject to US law, and then also the children of foreign invaders. And that was really well understood and discussed at the time of ratification. Now, the Trump administration and an increasing number of others are arguing for a more expansive exception to exclude people born on sovereign US soil whose parents are unlawful immigrants or who are here on a lawful but temporary basis. That is currently on petition for certiorari before the US Supreme Court, which is likely to take those issues up this term. But again, it is a slightly different question. What does subject to the jurisdiction thereof mean, as opposed to what does in the United States mean? And while I think the arguments for the traditional understanding of the citizenship clause, there's strong original meaning arguments on both sides for recognizing in the United States includes territories, recognizing that subject to the jurisdiction thereof includes just these three narrow categories. The evidence is even stronger for the understanding of that in the United States means US territories. That's likely not to be a big consideration before the US Supreme Court as it addresses that other question. But it all shows what's at stake. If the political branches, if the president, if Congress can redefine the scope and meaning of the citizenship clause, what does it mean to have a written constitution? We'll be following those issues closely, as I expect all of you will as well. And we'll have to see, how these 9 justices take up these issues and what, if anything, they say about the separate but related issue of birth by people in U.S. territories. Charlie, you're muted.
Thank you.
To follow up on what Neil is saying, the definition, the U.S. Immigration Act does create, following the insular cases and following the concept that they've created, defines a national to mean a person owing permanent allegiance to a state, and state in the small state, meaning a country. Section 20, subsection 22 of 11017 U.S.C. says a national of the United States means A, a citizen of the United States, or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. The definitional section 29, subsection 29, says outlying possession of the United States means American Samoan Swains Island. Subsection 36 says state includes District of Columbia, meaning for purposes of immigration, a state capital state, meaning a state of the United States, includes District of Columbia, Puerto Rico, Guam, Virgin Islands, and the Commonwealth of the Northern Marianas. And importantly, subsection 38 defines the United States, when used in a geographical sense, means the continental United States, Alaska, Hawaii, Puerto Rico, Guam, and Virgin Islands, and the Commonwealth of the Northern Marianas Islands, not including American Samoa, which is considered a outlying possession. These definitions, and particularly that issue of national versus citizen, is what creates this dichotomy between a national, that I think the 14th Amendment was intended to overcome. Because now we have sovereign U.S. territory, which has now lesser rights than the rest of the people, the rest of the, quote, United States. So these are the things that are statutorily there. And then basically giving nationals certain rights that are national non-citizens, which now just means people born in American Samoa. So these are those kind of distinctions are the things that need to be addressed, and that I think important at this point in time, because American Samoa is so strongly connected to the United States. They do not want to be anything other than part of the United States.
If you found that hard to follow, you're not alone. Everyone finds it hard to follow. It makes absolutely no sense. The statutory definitions of United States are Swiss cheese, and so is the case law defining what is the United States and what isn't. It's not limited just to citizenship either.
And I would add just a little bit on this. We don't want to make a kind of a political or partisan point here either. The Trump administration is taking these positions on narrowing birthright citizenship or not recognizing the text and history of the citizenship clause. But in the context of the territories, this goes back to the Biden administration. The Biden administration argued against birthright citizenship in the territories. The Obama administration very strongly argued against recognition of birthright citizenship in U.S. territories. So this is not a Republican or Democrat thing or a Trump or something else. This is Democrats and Republicans, presidential administrations, really for the last 125 years that have failed to respect the command of the Constitution and the Citizenship Clause that if you're born in the United States, whether that's a state, a territory, the District of Columbia, you have a right to citizenship that no president, no Congress, no state legislature, no local election clerk can deny. Everyone that swears an oath to uphold the Constitution of the United States should recognize that people born in the United States, again, whether that's American Samoa, whether that's Kentucky, whether that's somewhere else, have this right that is guaranteed by the Constitution.
Yeah, and I want to echo this is a bipartisan, or maybe better phrase as nonpartisan issue, in that you have some very strong Republicans vehemently in favor of everything that we've talked about here. You have some Democrats who are very much anti everything, anti all this, or don't want to go as far as some Republicans do, and vice versa. The Republicans are hostile to the territories and Democrats are friendly to the territories. And to show even more this isn't really a partisan issue, take a look at the party affiliation of the non-voting, or probably better discuss the phrase is limited voting, because they get to vote in committees, delegates to Congress that come from the 5 territories. It's split, I believe, 3 Republicans and 2 Democrats. So even amongst the territories, that's some lean more left or more right than others. But even the territories, the bulk of them, if they were made of states, would probably end up being swing states. And same with judges as well. I mean, it's a very bipartisan issue on the Supreme Court bench, on the lower court bench. Probably the 2 biggest champions of territories' rights right now in the U.S. Supreme Court are Justice Sotomayor and Justice Gorsuch.
And then
For different reasons, but go ahead.
And then following up on this issue of, well, we want to remain citizens. We don't want to be citizens because it'll adversely impact our custom and culture. This seems to be a real bugaboo in people's minds, particularly on the liberal side. When somebody says, oh, you're going to affect my custom and culture, they never explain what it means. They just want to knee-jerk response. Yes, this imposing citizenship is going to destroy the custom and culture of your society, without ever explaining why. And explaining what custom and culture really is. Some people think, well, the custom and culture is something written in stone. It isn't. It changes with each generation. The Samoan generations before Christianity were totally different. Once Christianity came in, became totally different. Those generations, when Americans came to take over American Samoa, the American Samoan side, their custom and culture changed significantly because they got rid of their high chiefs, the highest chiefs, who were their political superiors, and substituted the United States as part of their system. So custom and culture is not something to be preserved. It is something to exist, locally by and preserved by the Samoans themselves as each generation, adapts itself to changing environments that they're in. They're no longer isolated, so they have to deal with things that come in from overseas, and they do it. So the idea that somehow you're protecting custom and culture by maintaining this distinction is, this racist distinction. Some people are saying, well, we are going to the courts understand that there was a racist underpinning to the original insular cases. They said, well, we're going to reinvent the insular cases to do the reverse discrimination. Well, that's so what some people are arguing, well, we want this to protect us so that we can have reverse discrimination against, people that are coming into, that become part of our society. And a lot of it has to do with based on racial distinctions that even some, and blood quantum requirements that even Samoans don't recognize.
A lot of that applies to the alienation of land. That's a big issue, and you might wonder, one part missing here is, why are American Samoans against citizenship? It's not that the government of American Samoa is against citizenship per se. It's just the fear that if you bring in part of the 14th Amendment, you also bring in the rest of the 14th Amendment. To bring in the citizenship clause means you have to bring in equal protection, which means that the system we've set up of communal ownership of land alienation laws based on race and ancestry, chieftain titles, titles of some describe as titles of nobility, that all needs to go away. So that's really the fear there. It's not necessarily fear of citizen per se. It's not you don't want to be a U.S. citizen, just that you don't want to bring in equal protection under the 14th Amendment. Now, to put this in perspective, the culture issue, it doesn't just come up in this context. It has come up in other contexts as well. So, for example, when the U.S. Supreme Court issued its Obergefell decision, which essentially mandated same-sex marriages to be recognized nationwide, the governor of American Samoa said, we are not going to follow that. We're a Christian territory. This goes against our culture. This isn't a fundamental right under the insert cases, and so we're going to only do opposite-sex marriage going forward, and that's it. And essentially nullified the U.S. Supreme Court decision by executive fiat, essentially. But on the other hand, a recent decision came out from the High Court of American Samoa saying, hey, the Second Amendment does not apply in American Samoa at all, so American Samoa can ban guns, can do any regulations it wants. And that, of course, then angers the right side of the spectrum. So it's really all sides are getting hit by American Samoa invoking its culture. Like I said, it's not easy left or right, this Republican territory, this Democrat territory issue. They're going after everybody with this, essentially. So I want to make that clear as well.
Yeah, and the cultural issues are to be, addressed locally, and they are addressed locally. I've had 40 years of experience in the courts, from being prosecutor, being a judge, being, a private attorney and defending lands and things of that sort. It's got nothing to do with citizenship. The protection comes, and the issues of racial blood quantums, are just not issues in the Samoan mind. It is basically a right of descent, which in U.S. law, the ideas of trusts, can exist for people of descent. What you have to get over is the rule against perpetuities, which is a common law rule, which can easily be taken care of. You can just by law say, these lands are protected for the descendants of these people. And the free alienability of land does not exist. Those are just common. Free alienability is a common law distinction. Now, this is the point that we have, is that we as attorneys have the ability to not rely on insular cases, which say we're doing this totally according to race and we don't want, and we can do blood quantum restrictions and go to real issues to try to and work on the idea of developing trusts, developing ideas legally that will protect, custom and culture. And I think we had a set of cases in American Samoa called the Craddock cases, which say, there is a obligation that exists, and it requires that there be strict scrutiny on efforts to try to alienate land. So I think that is the point that you can go without having to implicate the whole racist theories that underlie the insular cases.
Thank you guys for that discussion. I think we have time for just one more question before we wrap up. And so, you know, as we said, this is a nonpartisan issue. It's widely regarded, you know, as something that is pervasive. And so, since the insular cases are seen this way and they still have yet to be overturned, what do you think would finally like be the tipping point or the catalyst for their removal?
I think you need a replacement. I think that is a problem here, in that we've governed these territories for about 125 years now under this system. I think members of the U.S. Supreme Court are worried that, again, most of them don't know much about the territories, just like many of you probably didn't before this panel. They're worried, well, if we overrule the insert cases, what does that mean? Does that mean that the government of Puerto Rico, the government of Virgin Islands, democratically elected governments, are they illegal? The courts that operate in the Virgin Islands and Guam, CNMI, have Article 4 courts instead of Article 3 courts. The judgments of all those courts void. I think they're afraid of delving into this area and having unexpected, unanticipated mistakes. If you're pro-life and you disagree with the Roe decision, well, it's very easy to know what's going to happen if they overturn Roe. Very easy to imagine, very simple, straightforward. You might not like it if you're on the other side, but it's going to be life's going to be under Dobbs. Life under a world where the insert cases are gone, well, what comes next? Are you going to just revert to what the law was prior to the insert cases? Well, guess what? The leading decision on territories prior to insert cases was a Dred Scott decision. So are you going to go back, roll things back to Dred Scott, or do you go back even further to whatever may have been in place, prior to Dred Scott? And then, and so what exactly is the alternative? Once there's an alternative, once there's some study of the meaning, the originalist meaning of the territorial clause that's going to be of interest to the majority on the U.S. Supreme Court using those interpretive tools. But once you have some sort of concrete theory that says, hey, here's what's going to happen if the insert cases are gone, I think that will be a catalyst for there to be an insert case being overruled. And part of it, as I say, also is because I mentioned before, Gorsuch and Sotomayor both are against insert cases pro-territory. Their positions are very different. Justice Gorsuch's position looks more to the plain text of the Constitution. There's nothing there about incorporated territories, unincorporated territories. That's all, essentially saying, look, the plain text doesn't support it, historical sources don't support it. This is racist, completely, separate from the Constitution. It's just made up law. Just Sotomayor, on the other hand, is like, well, Puerto Rico became a commonwealth in the 1950s, and this was a significant moment in the development of Puerto Rico. And so it's really Puerto Rico centric. It's like, okay, that's true of Puerto Rico, but what about Guam? What about the U.S. Virgin Islands? Does that apply to them as well? She's been very silent on that. And so, even so, from her point of view, she might be against these cases, but it's more of a Puerto Rico exceptionalist type of opposition as opposed to maybe a general pro-territory opposition. So again, you have to have some sort of clear majority. The insert cases themselves were fragmented 5-4 decisions. Sometimes the 5-4 would actually flip. Sometimes it was ridiculous. And if you have a 5-member majority of this Supreme Court overruling insert cases, you might not have 5 in support of overrule them on the same basis. And if that happens, then that's probably even crazier to have insert cases have this bad law be on the books from perspective of Supreme Court justice, I would imagine.
Yeah, and I would just add and maybe plug our forthcoming casebook, Law of U.S. Territories. When the insert cases were decided by the Supreme Court, these issues of the Constitution and U.S. territories, that was in conversation across law schools across the United States. It was in all of the law reviews. Everybody was focused and talking about it. And that's why we think panels and we thank the Kentucky Law Journal for having this platform. There's an important role that academic institutions play for there to be more research and discussion and debate around these important constitutional questions, and that can provide more of a framework for the U.S. Supreme Court as they tackle these issues to find a path forward that is able to be in line with the founding ideals of consent to the governed and all created equal in the United States Declaration of Independence, but also with protecting and advancing ideas of self-determination and indigenous rights for communities across the territories as well.
I think when we go back to, if you overrule the insular cases, you go back to what the 14th Amendment was intended, and that's one mark. You are a citizen. You take the citizenship from the time that they were were born in the U.S. when it was under U.S. sovereignty. That is the point. Now, the question of protection of custom and culture, how is that going to be done within the framework? That is something for lawyers to work on and to, work on with a clarity so that it deals with problems that come up, real problems, and not just these ideas and philosophies. It comes dealing with real problems that come up as we go through the process. Be an interesting time if they do that.
Yes, thank you, Mr. Alalima. And I think that this is going to wrap up our discussion. And so I just wanted to thank each of you for being here today and for sharing your expertise on such an interesting topic.
Thank you.
Thank you very much.
Thank you. Have a wonderful day, everyone.
Yeah, I just need the draft.
Check. Yes, if you'll slide that in your left pocket.
Dr. Wigginton, Dr. Middleton, can you hear me?
Yes, I can.
Fantastic. We will start very shortly with the next panel.
Insert this.
Lapel. Yeah.
Legendary. Awesome.
Actually, now you probably need to look at them. Oh, and okay.
You know, they read in so many different they have. So now I'll be able to think, guess who? Oh no, I already pre-told them, I did. It is truly the only case of people just which other places of truth. This one.
All good. Dr. Sheridan, Dr. Middleton, or Wigginton, you guys able to turn on your cameras? Can you guys hear us okay?
Yes, I can.
Okay, awesome. Well, thank you all so much for being here. My name is Jason. I'm currently a staff editor for the Kentucky Law Journal, and I'm also a 2L here. Just to do a brief introduction in no particular order of our panelists here today. To my far left,
So your far right is Mr. Timothy Arnold. Mr. Arnold is a veteran criminal defense attorney within the Kentucky Department of Public Advocacy, where he has served since earning his JD from the University of Kentucky in 1996. Over nearly 3 decades, he has held multiple leadership roles, including the Director of Post-Trial Division, and has represented clients before the Kentucky Supreme Court, the Sixth Circuit, and the U.S. Supreme Court. Mr. Arnold has received numerous awards for his advocacy in capital, juvenile, and immigrant rights cases, and is best known for his work as counsel in the infamous case Padilla v. Kentucky, which we will talk about later. Which was a landmark U.S. Supreme Court case establishing basically just that defense attorneys must advise non-citizen clients of immigration consequences before a plea. Next, Mr. Arnold is Professor Kit Johnson. Professor Kit Johnson is the Hugh Roth Professor of Law and a Thomas P. Hester Presidential Professor at the University of Oklahoma, and also a graduate of Wesleyan University and UC Berkeley School of Law. She previously practiced commercial litigation at Munger, Tolles, and Olson LLP and clerked for federal judges on both the Ninth Circuit and the District of Arizona. And lastly, next to Professor Johnson is Professor Tiffany Liu. Professor Liu is a lecturer on law and clinical instructor at Harvard Law School, where she teaches and supervises students in their crimmigration clinic, focusing on appellate and affirmative litigation, as well as direct representation. Her teaching and scholarship center on the intersection of criminal and immigration law, emphasizing procedural fairness and due process in immigration proceedings. Professor Liu also is a graduate of Duke University and Stanford Law School, and she previously clerked for federal judges on the Fourth Circuit and the Southern District of Texas, and worked as a staff attorney with the National Immigration Litigation Alliance. On Zoom, joining us virtually here today, we have Dr. Richard T. Middleton IV. Dr. Middleton IV is a tenured professor of political science at the University of Missouri-St. Louis and an adjunct professor of law at both St. Louis University and the University of Missouri School of Law. His specific teachings examine research, race, ethnicity, and political power, within the broader context of governance and public administration. Dr. Middleton also operates a solo law practice focused on immigration and minor criminal defense, and is deeply committed to pro bono work through organizations such as MICA Project and the Legal Services of Eastern Missouri. And lastly, we have Dr. Sheridan Wigington also joining us virtually. Dr. Wigington is a professor of Spanish and Latin American Studies at California Lutheran University, whose teaching and research focus on race, ethnicity, and identity in Latin America and the Caribbean. Not only was she a graduate of Eastern Kentucky University and the University of Missouri, she has held leadership roles in academia, including the department chair and vice chair of the Faculty Senate, and has been a strong advocate for equity and diversity in her education. Going from the intros, we obviously have some incredible people here. This is one of our larger panels today, so I thank you all so much for sticking with us and for you all being here and making the time. Really what crimmigration is, and we'll dive into the roots of it, it's really where two areas of law, criminal and immigration, obviously meet, hence the term crimmigration. And the purpose of our panel and our discussion today is to really not only understand its historical foundations, but also to conceptualize a topic that may not be as unfamiliar as we may think, and while narrowly tailoring our view in the lens of the United States and our similar but maybe more egregious practices that we might have seen when looking in the past. And so to start off with our historical foundations, Dr. Wigington and Dr. Middleton actually have done extensive research, like I had stated before, on previous history, but more focused on national and overseas. And a lot of our discussions throughout today from the earlier panels had focused on the United States history as a whole. But starting with where it all started in history, starting with you, Dr. Wigington, we shared a brief discussion before our panel in which you explained to me that you have done some extensive research on the Dominican Republic and Haiti. And so kind of, going off that discussion, if you could explain to us, how does your research highlight how education systems really shape ideas of race and citizenship? I think we're having just a little... Can you hear me? I'm unable to hear you, Dr. Wigington. No problem.
Are you able to hear me?
I can hear you.
Yes.
Hear me now?
Okay, there you go, Dr. Wigginton. All good.
Oh, yes, we can.
Technology, it's fine. So to answer your question, thank you. My research looks at how Dominican national identity is taught in social studies textbooks and school materials there. The DR has a nationally set curriculum, and textbooks are written and adopted with the knowledge that the books will arrive to students carrying the assumption of validity and being, quote, the truth. What I found is that the othering of Blackness and African ancestry in those books, especially in those lessons that are focused on what it means to be a Dominican, reflect long-standing negative stereotypes that are found in popular culture. How do I frame this? And that anti-Blackness isn't in general, but it's specifically aimed at the Haitian neighbor on the western end of the island. My work shows that the school materials act more as a reflection of the cultural and political climate rather than trying to do the work of establishing new norms or perspectives about race and citizenship. The texts largely just validate anti-Blackness biases that the students have probably already encountered before they even begin school. So I would say that the education system more legitimizes and entrenches existing ideas and perspectives rather than taking on the explicit and difficult work of resetting those cultural norms.
And so in taking all of that, how would you say that these patterns connect to any sort of earlier practices, which, bureaucratic discretion and policing practices to reinforce longstanding ideas about who belongs? When we look at the Dominican Republic and Haiti, to codify national identity through institutions like education and law, how do those really intertwine when we're trying to focus on the United States?
Okay. So in the Dominican Republic, rank and file bureaucrats have a tremendous amount of power in deciding who belongs, because these individuals are the first line of defense in the Dominican Republic toward protecting its perceived whiteness and connection to European identity from those Haitian influences and from Blackness. The most well-known instance of how this plays out was in 1997, when two Dominican-born mothers went to one of the civil registry offices to obtain birth certificates for their daughters, both of whom were also born in the Dominican Republic. The requests for the birth certificates were denied because the two girls were of Haitian descent. And so the civil registry required that the mothers produce this very difficult to obtain documents as a condition for being issued the birth certificates for their daughters. The birth certificates are a critical piece of documentation for the girls to be able to access the free public education system in the Dominican Republic, and to which they were completely entitled because they were born in the Dominican Republic. However, the bureaucratic discretion shown at the civil registry level launched a years-long battle over birthright citizenship, which has left tens of thousands of Dominicans of Haitian descent effectively stateless, starting in about 2014.
And so shifting over to you, Dr. Middleton, and how you handle the law side of things in your and Dr. Wigginton's, collaborative research work. In your comparative work of unequal protection of the law, you examine specifically how legal systems around the world distinguish citizens and non-citizens, and building off of Dr. Wigginton's, previous question about where does this idea of who belongs comes into play. How did early national narratives codify who belonged, and what does that teach us about belonging today?
Yeah, so there really are two main approaches to sort of belonging if we sort of use the nomenclature of citizen or national, and that is jus soli, which means right by soil. So under a jus soli scheme, an individual born on the soil of that nation state is deemed to be a citizen of that nation state. And the other approach is jus sanguinis, right by blood. So we trace ancestry. We look at one's ancestors to determine if nationality or citizenship sort of flows through those veins of one's ancestors to the person born in that nation state. And so inevitably, nation states have excluded individuals from even jus soli rooted belonging. based upon race, ethnicity, language, or even immigration status. Such was the case in 2010, to bring it back to Dr. Wigington's conversation, in the Dominican Republic, when the Constitution of the Dominican Republic, the in-transit clause of their jus soli provision, was interpreted by the Dominican Supreme Court to exclude migrants from Haiti who had arrived in the country to work in the sugarcane plantations, the bateas, in the Dominican Republic. And so today, the majority of nation states espouse the jus sanguinis approach, either constitutionally, in some instances by statute, but is most predominantly espoused in a national constitution. You may have a hybrid approach to jus soli that incorporates some element of jus sanguinis. The United States and a handful of countries, predominantly in the Caribbean, maintain what's pretty close to an absolute form of jus soli, but even the U.S. Constitution has a limiting clause, which is the subject of much controversy and litigation currently in our country. So that tells us that the contours of belonging can be shaped in a manner to exclude from membership those individuals who do not have perhaps a first or second generational blood ancestral tie to a community that's considered to be sort of a bounded community, to borrow from Benedict Anderson, a nation. And that even a legal construct that comes close to a more absolute jus soli approach, such as that in the U.S. Constitution, the 14th Amendment, can be restricted by, as I mentioned, a limiting clause, with the intention being to exclude from belonging those individuals who are seen as outsiders or different based upon their race, ethnicity, language, and or immigration status.
And so, Mr. Arnold, I want to ask you a question directly. We've talked about, the historical research. We've talked about, the law and legal perspective, and having you on the panel is fantastic, along with you, Professor Liu and Professor Johnson, with, just the in-practice experience, whether that be professing or working in legal clinics, but from being a public defender, how do you see this historical analysis either make an effect in your day-to-day practice, or is it really just kind of being disregarded from what we have learned so far in our historical roots?
I think certainly, to the extent that, is there a lot of conversation about historical practices within the context of a criminal case? Probably not very much, most of the time. I think the fact of, the sort of growing awareness of immigration, and immigration status as an issue is something that, we've been dealing with for the last 20 years, 20, 30 years, where we're trying to figure out, it's now a question that you have to ask, like, are you a citizen or you're not a citizen? Because the implications are substantial to what the next step is. So that wasn't a question that was asked when I became an attorney, which you all know is 1996. But it is, it's a question that I think every attorney should be asking today. The other issue that sort of comes up is not specifically an immigration issue, but it touches on immigration, which is sort of language and sort of cultural competence. And all of those things are now, there are, the court system and the systems that work with criminal defense and criminal prosecution don't have very good resources for language interpretation. And so, there are often times when there are problems with just basic communication between people who are speaking in different languages. And then you have this additional sense of, for people who are not, if you're trying a case in Fayette County, Kentucky, and the person is from Fayette County, Kentucky, everybody knows what a person from Fayette County, Kentucky would think about a thing. But if you didn't grow up there, you grew up in a completely different environment, how does that person perceive the situation? How do they perceive what they're supposed to do in the situation? How do they understand what they did? And does that in any way provide some explanation for the behavior that could be mitigating or exonerating? And so those are things that, as an attorney, you're trying to figure out, but, the extent to which different attorneys do it varies pretty wide.
Is there any sort of, just a quick follow-up, is there any sort of challenge that you might see happening in the future with all of this ambiguity on immigration laws, history and past, and how we're interpreting it right now in the present that you either are seeing right now, or you think it's going to be more of a bigger issue in the future if we haven't acted?
Yeah, I think that my perception is that the challenges in immigration law are probably more going to come from the immigration side than from the criminal side. There are issues about immigration law and what it means in general that are still being resolved. The issue with immigration law in general you saw it, you heard it this morning when they were talking in the panel this morning, the conversation was sort of like, well, this is all very confusing, isn't it? And, that is a significant issue with immigration law in general. It's just how much notice does anybody have about what the actual rules are about how to deal with the situation? Because so many of these questions are unresolved or ambiguously resolved. And it is especially true when you're talking about criminal immigration and the intersection between those two, because the government, the US didn't write a statute that said in Kentucky, KRS 527030 is an aggravated felony. They wrote a statute that said, this federal crime is an aggravated felony, and so are all the things that kind of sort of look like it. And kind of sort of look like it isn't a very precise standard. And so you have a lot of ambiguity about whether or not what your client is looking at is really what those implications are going to be in the immigration court is far from certain in the vast majority of cases because of the sort of lack of any clarity about what crimes constitute an aggravated felony or a crime of moral turpitude or something else.
And so one last question before we move to, kind of our next theme, looking at what other countries have done and how the US has sort of mirrored it. Professor Liu, Professor Johnson, in your work that you guys have done in, the field and the background you guys have, to what extent does history repeat itself when states use criminal frameworks to police migration or national identity?
Rock, paper, scissors?
Rock,
Well, I think that we see a lot of historical patterns with the ways in which the states use criminal frameworks, and we're seeing that a lot more now, right, with 287G agreements and the ways in which state officers are being deputized by the federal government for immigration enforcement. So I think that that's certainly one thing that we're seeing a lot of interaction therein. But I think that federalism themes are ones that really come up a lot in immigration. And I think of both ways in which states enforce immigration, but also ways in which states are trying to help immigrants on the local level, right? And the ways in which the federal immigration system does or does not respond. And so, there are examples of this in which states will try to amend their criminal codes so that there are fewer consequences on the immigration side. But whether or not those post-conviction relief options, those vacatures, those expungements are actually recognized for immigration purposes, and whether those convictions can continue to have immigration consequences is not always straightforward, right? So a conviction for federal immigration purposes is not necessarily the same as what the state sees it as. And so I think we see history play itself over and over in these ways in which the state and federal dynamics, both on the enforcement side and in the ways that they try to structure laws, have a mismatch.
I'm sorry, I have nothing to add. I
No.
keep thinking of it.
No, that's okay. So first of all, thank you all so much for your responses and everything. I really appreciate that. And diving just a little deeper to, what other countries have done versus, the United States, and thinking about our own patterns. I want to start with Dr. Middleton, and you're going back to your comparative research. We obviously have discussed how, you highlight international law and treaties and to safeguard the rights of non-citizens, but how exactly or how specifically or what trends have you seen specifically do other nations balance sovereignty with human rights obligations more effectively than the US does now?
Yes, that's a fantastic question. And, frankly, I would say that all nation states grapple and struggle with balancing sovereignty with human rights obligations. The United States is not in a unique position there. Now, some nation states, quite frankly, elect to not ratify specific human rights conventions and thus assert that they're not obligated to uphold those legal precepts. Some nation states that do ratify human rights conventions elect to ignore them. The Dominican Republic, again, to go back to that example, they simply ignore their obligations, knowing that there's really little in the way of meaningful or real punishment that would befall them for violating a human rights convention. There's really oftentimes little recourse for an individual who is the victim of a human rights violation. And so then other nation states simply ignore the rulings of international tribunals that have found that particular country to have violated human rights laws. And so the news here is a bit pessimistic in its tone. In the United States, as we all know, has currently elected to withdraw from the UN Human Rights Council. And in 2002, the United States withdrew its signature from the Rome Statute and thus doesn't recognize the jurisdiction of the International Criminal Court. And so in just looking at, some numbers in preparation for today, and talking about human rights, meeting human rights obligations, according to the Human Index 2024, the top rated countries for based upon proxies, using proxies that are often most commonly associated with human rights. Switzerland, New Zealand, and Denmark are the top ranking countries, and the United States comes in 17, and that's out of 165 jurisdictions measured. So, the assessment is in the eye of the beholder in terms of how well the United States does vis-a-vis other nation states. And so I'll leave that for us individually, each one of us individually, to make our own conclusions.
Yeah, absolutely. And I appreciate that. And, Professor Johnson, when we shared our discussion about preparing for today, you're currently working on a current project, and you had shared that you talked about this evolution from, militarization to military in immigration enforcement. And we've talked about human rights, we've talked about history, but sometimes in the media, we can construe that as this is, militarization of one's own personal rights. And we always talk about, whose right is it? Are non-US citizens allowed that same right that we are? And so when looking at your work and when you compare the US to global examples, is this approach genuinely new or part of a broader pattern we've seen elsewhere?
Yeah, so my piece is talking about how from the very beginning, when we first started enforcing immigration law, which was, more than 100 years after we became a country, because we didn't have federal immigration law until then. And it has always been in what we call civilian control, meaning it is non-military, it is civilian. And it's sort of bounced around from a bunch of different federal agencies to where it lands now. And you guys are most familiar with the Department of Homeland Security, which, sounds very military, but isn't. It's still civilian. It has nothing to do with the Department of Defense. And so we've had a situation where immigration enforcement has been in the hands of civilians for a long time. But as you said, very much influenced by the military. And that's what we call militarization, sort of taking on the trappings of what the military has in terms of its toys, right? The planes and the cars and the tanks and the guns and grenades and the tactics, right? Doing sweep ups and raids and sort of how things are done. The immigration enforcement has taken on those trappings, just like you're maybe more familiar with criminal law taking on those trappings, right? That when you see your local police officers on TV, right? Are they wearing camo? And you're like, and why? When I live in a suburb, right? Or even a city, it doesn't make any sense. So we've often had this intersection, and we've also sort of moved past that intersection at times over history if we just look at modern times, every single president since Carter has tapped the military to do something in relation to immigration enforcement. But everybody prior to President Trump has done so in a supporting role, right? They've not been the one who are doing the enforcement. I think what we are seeing with President Trump now, and I truly believe Trump 2.0 is significantly different from Trump 1.0, is a real shift to wanting to utilize military servicemen and women in enforcing immigration law. So enforcing what is civil law against civilians, which is not what we use the military for. And I don't believe that there is precedent for it in the same way that we have so many of these cycles that we've talked about, both in the United States and elsewhere. I think this is a genuinely unique moment.
And going off of that, Professor Liu, making it more in a sense of the law student center and the classroom today, how do you tackle these issues of, inclusion and exclusion or police militarization while taking cases and representing people in need at the Harvard Law School?
I think questions of inclusion and exclusion are at the heart of how we decide what cases to take on and make the very hard decision, right, to turn cases away, because if any of us had it, we would say yes to everything, and then no one would ever sleep, and it wouldn't be good for anyone. And also how we represent those cases, right? And I see inclusion and exclusion really happening in two ways in this dynamic of how we approach taking on cases and that representation. The first is that everyone deserves counsel. Everyone deserves a fair shot. Everyone deserves due process in the system that we have, even with the flaws that our system has. But I think that oftentimes people will be excluded from representation and having that fair shot because of, precisely what is the topic of this panel, which is the intersection of criminal and immigration law. And so, for example, there are universal representation programs across in certain jurisdictions across the country where individuals, so on the immigration side, you have a right to counsel, but at your own expense, which means that most people don't have representation. And this is a concept that I know that other panelists have talked about over the course of today. But in a lot of those jurisdictions, people are excluded from that counsel because they have some form of prior criminal encounter or they have prior criminal convictions. And so, one thing that we dedicate our work to at the Crimmigration Clinic is to ensure that everyone has equal access to counsel, and that's not something that we'll exclude when we take on cases. And I think that kind of dovetails into the second consideration, which is the sense of othering and how can we zealously and responsibly represent our clients without perpetuating problematic stereotypes or kind of problematic components of the system that we're working within, right? So Jazia Zaman has a really powerful article about how she was driven away from being an immigration attorney because time and again in asylum proceedings, she was forced to, and we are all forced to do this, right? Put our clients into very specific boxes so that they can check, is there a fear to return to this country? We have to characterize the country in a certain way to ensure that we meet the asylum standard, right? That's one way in which we're potentially playing into or perpetuating stereotypes that can enhance and perpetuate exclusion. And another way is by creating this quote unquote good immigrant versus bad immigrant narrative, and painting your client as one of the quote unquote good immigrants, right? And so how do we fight against that? And so to give you one concrete and brief example, we have a client who came to the US as a refugee decades ago and has lived in the US basically since he was 10 years old. And when he came to the US as a refugee alone, was trafficked and so became addicted to drugs and then fell into the criminal system, had several convictions, all of which are at this point 25 years old. But he has now been put back in proceedings, is detained, subject to mandatory detention, and we're fighting his case, right? And one of the things that were the impulse, right, that really kind of puts up this tension of the how do we fight against this perpetuating narratives is these are really old convictions. He's been able to rehabilitate, et cetera, right? But what does that mean for other folks who may not have that particular, right? Who may have had more recent criminal interactions. And so I think these are things in which we need to be careful about the ways in which we represent our clients zealously, because we must do so zealously. But also, how do we not close the door to others and other clients and exclude them from the polity and exclude them from being able to have their fair day in court?
Yeah, and really diving into where we are today and the law in action. Professor Johnson, I want to start with you really quick, and I know that when it comes to the United States, we've already talked about your amazing research, with militarization and police power, but really just going deeper, what have you found or what have you seen about how this affects the constitutional balance between executive power, due process, and civilian oversight?
Well, it's a really interesting question, particularly in light of earlier panels. They talked about the fact that we haven't had real legislative action since 1990, so 35 years to do the math. That was somebody was struggling with it earlier. And in that space, then we have the executive stepping in and trying to control and make moves on immigration. Another theme that has come up on that is in other panels is the nonpartisan nature of that move into immigration, in that you have both Democratic and Republican presidents who are trying to use as much power as possible as the head of the executive to enforce immigration law or have an effect on immigration law. And then I forgot the second half of your question. I'm so sorry.
No,
You were
that's
saying.
okay. It was jam-packed.
Oh,
It was really just civilian oversight. Yeah.
Yeah, like I said a moment ago when I was speaking, I do think that the way in which Trump 2.0 is using the military is really, really different and extensive. So I'm really only focusing on kind of two things in this particular paper. I'm focusing on the expansion of bases at the US border and the use or the allocation of JAG attorneys, military attorneys as temporary immigration judges. But there's a myriad ways you've more probably seen on the news in terms of the National Guard sent to American cities to enforce immigration law. You were just talking about 287 agreements. I don't know if you knew this. I didn't know until I was researching that there are 287 agreements with the National Guard in certain states. So Texas, Florida, and I think I'm missing one. So just embroiling the military in a lot of different ways. And we have laws on the books that say that the military should not be in a position to enforce civil law against civilians. And yet we are in a place where the administration seems to be pushing for the military to exert power over civilians. And maybe your thought is, well, it's not civilians because they aren't citizens. And maybe our concept of civilians is only US citizens. And then I think about what other panelists had said, which is that you do end up with citizens who are swept up into this system. I was thinking, I'm going to actually just say I was going to talk to you afterwards, but I'll tell you now, Mr. Arnold, just the importance of Padilla, right? And you said, how important it is to ask if they are citizens, your clients. And when I was in, so I've lived in a lot of different places, but one of the places I lived in was in North Dakota. And a lot of my students there found jobs essentially doing Padilla opinions for the local PD. Right? They were hired out and they would do research and, into this client, are they in fact a non-citizen? And then what are the consequences? And I always thought this was really important because I actually had numerous students at the University of North Dakota who would come and talk to me about their lives and, I'm sorry, I'm not explaining. about 20% of our population's from Canada. And so these Canadian students would come to me and they'd say, I want to stay in the United States. And I'm like, great, tell me about your grandma. And they're like, why are you asking about my grandma? And then every year I found a Canadian who was a US citizen who didn't know they were a US citizen. So you both have the problem of even asking, are you a citizen you don't know? And that's not even what I was going to tell you, although I do find that interesting. Obviously, I'm saying it out loud. But I moved to Oklahoma, right? A much bigger city, and you would think they've got their stuff together, as it were. And I have students who are working for the PD up in OKC, and they don't actually talk to their clients. They only have them sign a quote unquote Padilla waiver. And there is with no explanation.
believe that, yeah.
I couldn't believe that. I was like, how is North Dakota doing something better than Oklahoma? And that is, and not only are they doing that, but I have another student who is working in the prosecution's office at OKC with defense attorneys, where she has had to tell the defense attorney that they need a Padilla waiver because she can identify. And the guy's like, well, I don't see a problem. And she's like, this is a felony. And he's like, oh, it's not a felony. She's like, it is for federal law. Anyway, it just all kind of circles together in terms of, you know, how are we getting information to people? Are we identifying who needs help and what kind of help they need? Sorry, that was a bit of a all over the place, but I was just what I was thinking about sitting here next to you.
No, that was great. I really do want to turn to Mr. Arnold, though. Do you mind giving us just a broad overview of not only the fantastic work you did with Padilla v. Kentucky, but what precedent did it set for us? Kind of, if people don't know what it is, give us the background, all that stuff.
So to understand Padilla, you first sort of need to understand a little bit about the criminal justice system, which is that guilty pleas are the tail that wags the dog of the criminal justice system. Is that, you know, different numbers are thrown about as to what percentage of cases end in a plea, everywhere from 95 to 98. It could be 99. The fact is, if 10% more people went to trial, the criminal justice system would explode. It would break down. There was no way to do it. We don't have enough courthouses. We don't have judges. We pay for about 5% of the throughput of the criminal justice system. And the reason we can do that is because of guilty pleas. So that creates a huge incentive to not make the process hard, right? And it creates a real value in not expecting too much of the process in terms of what the individual understands. And so, you know, when you look at the history of guilty pleas, you see we have this sort of pattern like Boykin, you read Boykin and you think, well, this is kind of we really need to have an understanding and there's going to be a process and everything else. So, you know, I was reading the other day, somebody had done a study where they'd gone on YouTube and found all these Zoom guilty pleas that are on YouTube. And they, coded them. The average time it took to take a plea was less than 4 minutes. And that checks out. But, that's about right. And that's because the amount of information that we started with this idea, the judge needs to make sure you understand. And then we decided that the judge only needs to make sure you understand the sentence, really. And that you're not being coerced. Like you don't, you have to have at least acknowledge, you have to at least tell him you're not being coerced, or her, that you're not being coerced. So we put all that on the lawyers. And then we started moving it off the lawyers by saying, well, the lawyer's effectiveness is really not, just because the lawyer didn't tell you something doesn't mean that you get to withdraw your plea. It depends on a lot of different factors in terms of whether the lawyer's advice was unreasonable and below professional norms and other things. So the bottom line is there's this information gap between what any of us would expect to know before we decided to plead guilty to a serious crime and what the system actually ensures that we do know. And the question in Padilla was, which side of the gap does this immigration consequence fall on? And the Kentucky Supreme Court was 7-0 that it fell on the side of you don't need to know it. There were two justices who felt like they, that because he had asked and because his lawyer had given him incorrect advice, that triggers a different kind of rule, that the lawyer can't tell him something wrong and induce the plea. But that was the minority opinion. The 5-vote majority opinion was, because it's immigration, no right to know anything. So the Supreme Court, in deciding the case, decided that because this consequence was automatic and clear, that the attorney had an obligation to let the client know about it. And in doing so, they said a number of things that I think are very good, not least of which is just sort of that this is, the description of immigration is, it's nominally civil, but it's really not. Like, it's a highly punitive system in some ways because the consequences are fairly great. And so they sort of acknowledged that, and because that's so important, we want to do that. And so that was that's a good thing. Mr. Padilla, I think, was the person for whom this was done because he was a veteran. I think that we counted there were 17 prior petitions on this exact issue that were denied. Here comes Mr. Padilla, who had served in the armed forces and was honorably discharged, and Justice Stevens, who wrote the opinion, is a veteran. And you just shouldn't do this to a veteran. And I might add, that followed him throughout the case. When it goes back for a hearing, the prosecutor is a veteran. And so I have this bizarre experience of watching the prosecutor thank my client for his service while he's trying to get him deported, like at the same time. So so in terms of the significance of it, I think in the moment it was decided, the hope was that this would be a moment where we would try to take a step forward towards improving people's understanding before they plead guilty. Like this is really is terrible to have agreed to sign your own deportation warrant, just as it's terrible to agree to sign it to a number of collateral consequences that come from a conviction. And there was movement in that direction early on that was good. There was, people were, trying to figure out how can we provide resources for people to figure out what is a safe harbor plea, what is a, kind of safe harbor plea, like how can we figure out how to help people manage this system. And then what happened is what happened with Boykin is what happened with everything else. We started watering down this rule so that now you can sort of waive this, you can sign a waiver and suddenly there you are. But also, we only apply Padilla in Kentucky if the actual resolution of the immigration question is clear and obvious upon momentary review, which is basically no issue, right? So we found a way to un-Padilla Padilla. And, and because of that now, that's reduced the ability of people to be able to get the benefit of these are people who are seeking post-conviction relief, trying to get out of a deportation consequence. And that reduces their access to it. But that is because of the sort of severe concerns that people have with trying to protect the plea process and making sure the plea process continues to work as the sort of industrial machine that it is. And so, I think in terms of, what it is meant for people, I think there's obviously been a lot of positives. It certainly was good for Mr. Padilla. And, it was, there are a lot of, there are plenty of places that, North Dakota I didn't know North Dakota was doing it, but North Dakota, if you have access to University of North Dakota students to do this review, you are getting it done, right? So that's good. But then, you have a lot of other jurisdictions where it is, where it's not as much. DPA, my agency, hired an immigration lawyer in the aftermath of Padilla. The immigration lawyer left. They haven't been rehired. So Kentucky doesn't have an immigration lawyer on staff. The principal advice that you give to a person who's, in that boat is we should talk to an immigration lawyer, which is, of course, completely infuriating because first of all, that's not how people think. Like if you're telling me I'm going to go to prison and then you say there's also this immigration thing, I'll figure out about prison and then I'll deal with the immigration thing. Like the idea that that's the same thing is hard for people to understand and just to deal with, just emotionally to deal with. But also, they're our clients, so they don't have money to pay for an immigration lawyer. So that's just not going to happen for that reason. So, there is a lot of, this hasn't had the sort of effect on the system that I hoped it had, although it has had some effect. I don't want to belittle the positives that were there.
So
with a sad panel today.
Well, if I may just briefly,
absolutely.
When you talk about safe harbor, please, it's very important. I maintain a solo part-time practice, and it allows me to sort of stay fresh, and it informs my teaching and research. And so, from time to time, I represent clients who have perhaps ordinance infractions that they're charged with. Let's say they go into a Walmart and steal a number of items, and they're charged with larceny. And so from time to time, in working with prosecutors to explain to them the potential immigration consequences of a plea, I've been able to get, in many instances, prosecutors to agree to engage a deferred prosecution agreement. But even then, it requires additional advocacy and awareness, because oftentimes in those types of documents, the prosecutor will want the defendant to agree to sign off that they recognize that there's sufficient facts to find them guilty. And I immediately say, no, that cannot be in this deferred prosecution agreement, and then I'll pull out my mobile device and I'll go to INA 101 A48, and I'll sit there with them and explain to them the definition of conviction in immigration law and tell them, the definition of conviction in immigration law is really as wide as the ocean in terms of what could constitute a conviction. And so it really requires, and this is for many of the students at University of Kentucky Law School who have aspirations to go into immigration law, to be aware of the nexus between criminal convictions and immigration law, and the advocacy that one can take on in working with clients and speaking with prosecutors. Because you're right, Mr. Arnold, the vast majority of these criminal matters will ultimately be resolved in the form of a plea. And that's where the immigration attorney can really sort of come into play and strike the best result possible for that defendant who has some type of, potential immigration consequences from that plea.
And so moving into what the law says, does, and really just where we're headed, Professor Liu, your clinic has challenged ICE's refusal to produce detainees for criminal hearings. We shared a conversation before we sat here today for our panel, and I think one thing that's extremely important in understanding is really what type of specific arguments are being made in those types of proceedings, specifically as well from a law clinic. And so my direct question for you is, what types of constitutional arguments form the basis of your litigation when you're representing these kinds of individuals?
Yeah, no, absolutely. I'll start with kind of sharing a little bit about a current putative class action that we are involved in and how the criminal and immigration systems interact, because I think this is crucial to answering your question about what types of legal claims can you raise. So there is a detention facility in Pennsylvania, the Moshannon facility, that's one of the largest in the country. And this facility, ICE has a policy of not permitting people who have pending state court proceedings to go to those state court proceedings, criminal court proceedings, virtually. And so, this is so even though ICE does produce people to their immigration court proceedings virtually and to state family court proceedings virtually, they just won't do so for state criminal court proceedings. And so really what ICE requires is that the state, so for example, New Jersey, drive from New Jersey to Moshannon, pick up a client, pick up an individual, go to another jail to let them zoom into court, and then bring them back and then drive back to New Jersey. It's an 8-hour drive without traffic, one way. And so needless to say, many people are not able to go to their criminal court proceedings. As a result, on the criminal side, there are any number of constitutional violations that might impact, right? For those of you, I'm sure all of you may have already taken criminal procedure or criminal law. You have a right to go to have your day in court. That right includes the compulsory process. It includes the confrontation, being able to confront witnesses against you, right? It includes having a right to counsel. But often what happens is that when people can't go to their criminal court proceedings, they can't request that they get court-appointed counsel. And so individuals then are left without defense counsel, which they are constitutionally entitled to, right? And you get into this vicious cycle because you then need an attorney effectively to help you get a defense attorney. And so these are, extreme problems, not only on the criminal law side, but also because of the vicious cycle in which it plays back on the immigration side. And so when you have a pending state criminal charge or pending criminal charge period, that can be used against you and often is used against you in your immigration proceedings on a number of fronts. One way is that it can it can deny you bond, so release from detention in the first place, right? To be released from detention on bond, if you're eligible, you need to prove to the judge that you're not a flight risk or that you're not a danger to the community. And even though you haven't had your day in court, judges often use that pending criminal court charge against you to deny you release. And because you are stuck in detention, you then can't go to your state criminal court proceeding to resolve that charge, and hence a vicious cycle.
The other way in which it can be used against you in your immigration court proceedings is that, again, even though you may never have had your day in criminal court, it can be used to deny immigration relief. So I had a client, for example, who was statutorily eligible for adjustment of status to become a legal permanent resident and get a green card, but it was denied based solely on a pending criminal charge that had been pending for 3 years because he had been detained in immigration detention and not once was able to go to his criminal court proceedings during that time. So he was ultimately deported. We ended up winning his case in the First Circuit, but it's impossible to get individuals back, so he is still deported. So this is the back context to your question of what exactly are the legal arguments that we're raising in this case, which is a first of its kind. And so we're hoping that, we'll be able to file it in other jurisdictions as well, because ICE has this practice in many. And so many immigrants who are stuck in detention, ever expanding detention with the enforcement practices of this current administration, aren't able to go to the criminal court proceedings. So it's a number of constitutional criminal procedure claims under the Fifth Amendment, the Sixth Amendment, right to counsel, compulsory and confrontation clause. And then it's a number of APA, Administrative Procedure Act claims as well, arguing that these are arbitrary and capricious policies because how does ICE determine that individuals should be able to be produced virtually via Zoom, which is a free platform for us all, to family court proceedings, but not criminal court proceedings, particularly where those criminal court proceedings have such a vicious back cycle loop to impact an individual's immigration case. So these are, some of the many claims that we are continuing to litigate. I have an article that just came out that discusses this and discusses also the ways in which this interaction between the criminal and immigration system really makes us rethink crimmigration.
And I think, at least, in practice, we always want to understand, especially in law school, there's always, you're reading cases and it's like, here's the historical context. And we're going from where we were before, now we are now. And you're always left with the question, specifically when you're tested on exams, it's, well, what does this mean? We have all this historical past and now future precedent. You're always kind of left with that guessing game. So I think that clarity and context is what was needed, because we can sit and talk for hours. This is how immigration law has changed. This is what past and, current presidents are doing, but it's really getting the keynote into what's actually happening in the court system and what's going on. And so shifting into more of the historical American narratives and where that's also changed as well. Dr. Wigginton, you in your cultural and educational work, you emphasize how narratives shape both policy and also the public understanding. And so my direct question for you is, how do American narratives about illegality and security continue to justify these very blatant patterns of exclusion, though they might not be expressly written?
I would, of course, say everything is narrative. Using illegality and security narratives to justify patterns of exclusion are simultaneously inaccurate and inflammatory, but also effective for galvanizing a political base around shared anxiety about what are largely end up being economic issues. And this is what we see in the Dominican Republic especially. So this is what is true about on the island of Hispaniola, and the same script is being, or could at least be, acted out across the Americas, not only in the United States. I think the idea of what kind of political figure is going to use certain tools to use immigration for certain goals really spans the political spectrum. I think the local population oftentimes finds themselves, and we all know this, susceptible to certain arguments depending on what the economic situation is in the country. So you see this especially in the Dominican Republic, but the truth is, using these sort of dog whistles that are going through the lens of immigration that provide a way to avoid addressing more local economic issues, it's just a pattern that ends up being framed as illegality and security issues. But oftentimes what we find is it's going to boil down to economic issues that are not largely being addressed.
In your research, what do you think a clear path forward or maybe a clear answer would look like? Does that change? Is it focusing more resources on, American soil? Is it diving more into past history and how we can not just learn from it, but really in practice doctrinally try to engage with what's happening here today?
So for me, for Richard, I can.
Yes, or either one of you.
I think this sort of connects to what I was thinking about sort of, I was putting this together with sort of tensions, national tensions and identity and migration control. So I think, so although my focus is on the Dominican Republic, and the DR gets a lot of attention and criticism about its handling of these issues, but the truth is what they're doing is not particularly unique. And someone else on the panel mentioned this before. The political rhetoric around safety, economic development, and cultural traditions being threatened by the other is well-tread territory. So you don't need, you can find the sort of Caudillo figure throughout Latin America. But what sets the Dominican Republic apart is the close proximity that they're in to the people they are othering, the people that they are using to shape as their counterweight. So as the Dominican Republic likes to popularly imagine themselves as being sort of white, European, Spanish-speaking Catholics, their other is who they have shaped as the Haitian threat, right? So they are Black, they speak Creole, they are dangerous voodoo practitioners. And I think to connect to what you were saying before, this does bring us back into the schools, back into the textbooks, back into the content that gets state legitimacy as here's our definition of self, and here's our nationally codified definition of the other. So in terms of moving forward, a lot of this is going to find itself making its way maybe first into the courtrooms, in other contexts, also into the churches, but eventually it's going to make its way into the classrooms. Because keeping in mind that the people making the decisions about who is the other, who are we and who is our other, who do we want here, who belongs, who doesn't belong, those decisions are made by people who have who have had contact with the curriculum that taught them what to think. And that curriculum was shaped by someone before them and someone before them. So, et cetera, et cetera. So I think keeping in mind that looking at what's being taught and given legitimacy as this is our foundation for understanding who we are and what we have at stake to protect, the people making decisions they've absorbed that content, and we see that happen in all the decisions that get made. So I think it's important, again, to go back to there are lots of fronts where this issue gets addressed, is security and inclusion and exclusion, but I would like us not to forget about the importance of where those first steps happen, and oftentimes those are within school systems, and all that content is held together within the content of the schools and the curriculum.
That was Dr. Middleton. Did you want to contribute to that? I didn't know if you both.
I'll just add another anecdote. If you on your own time, just take a look at some of the background, the history relative to the proposed textbook by the title of Mississippi Conflict and Change. I'm a native of the state of Mississippi. And so, in the 1970s, there was a proposed Mississippi history textbook titled Mississippi Conflict and Change. And it was submitted to the State Textbook Purchasing Commission for approval to be adopted as an approved textbook for Mississippi history classrooms in high school. And so the Textbook Purchasing Commission ultimately turned down the adoption of that book. They voted it down. And they deemed it to be, quote, too controversial for its depiction of slavery, Jim Crow. And so what happened was that ultimately this matter found its way into federal court in the state of Mississippi. And the court opined that the legislative history, which actually was not memorialized, but the court took the liberty to sort of review the legislative history and found that the state of Mississippi actually intentionally, by state statute, vested control for textbook adoption in two parts, one being the governor. And as you know, in Southern politics, the governor of Mississippi, particularly in the 1970s, is a very powerful individual. So the governor at that time was William Waller. And during the debating of that legislation to give power to the Textbook Purchasing Commission, the governor opined that it would be critical to allow such power to be vested in that entity because, and this is a quote, he said, "Our efforts to clean up," now listen to this language, it sounds like a lot of the rhetoric today, in talking about educational materials and books. "Our efforts to clean up our public school textbooks and give our children the instructional material they must have if they are to be properly informed of the Southern and true American way of life." And so when we talk about mediums of information dissemination, they can be used to create and promote a script, what we call in our book that Dr. Wigington and I published. It could be a master script, focusing on who belongs and the contours of belonging in the community.
And thank you for that both. And leaning a little bit further into that, Mr. Arnold, in practice, do you think, are these two systems, immigration and criminal law, are they learning from each other's failures from your experience?
I mean, yes and no. I hope, I have, if I have a dream, it is that over time, more due process is afforded to immigrants facing deportation consequences. Like that is the thing, so, you gave me a nice introduction earlier. A shorter introduction would be that Tim Arnold has a unique talent for finding the crazy and getting that case. And I feel like that is the crazy right now. Like if you look around, just the extent to which we have basically permitted a system that is highly punitive and yet affords no basic protections that we find fundamental in every other context. Like we wouldn't let the state take your dog without giving you more opportunities than what an immigrant gets. That's what I hope the changes are. Like that's where I hope those changes come from, is that there is more movement to at least ensure some degree of due process into the system. And so that somewhat is learning from the criminal justice system. It's not as though the criminal justice system is exemplary in that area, but it is better in that area. And hopefully there is some learning that can happen there. So that would be my hopeful remark. In terms of what has happened so far, I do think there are people, we have more awareness of immigration as an issue. We have more awareness of the challenges that are there. It is something that does get discussed in a way it didn't used to get discussed, and that is a good thing. Although part of the reason for that is it wasn't discussed before because it really didn't matter before. Like there was a period of time when we really didn't do this. And so it is but we now are at least making those sorts of changes. But I don't know how much the two systems are very, very different. And so it's hard for one to learn from the other than just to adopt some of the things the other does.
And Professor Liu, being able to, dabble in both the academic side and also the in-practice side, how do you view immigration and criminal law together or against each other? Or how do you try to find that balance beyond the textbook so your students really understand where we're going and how meaningful and powerful the law really is outside of the classroom?
Yeah, I mean, I think what you were just saying really resonates, right? Is like, how can we port over some of the protections from other systems? Not to say that the criminal legal system does it perfectly by any means, right? But it is a modicum better than what is afforded on the immigration side. I mean, I think of a couple of things. One is the ways in which our immigration system and the way that it interacts with the criminal system kind of flips some of the criminal system on its head. So guilty until proven innocent is one of the pillars. based on what I was describing before, I think oftentimes on the immigration side, it's innocent until proven guilty. You may not have had your opportunity to go to criminal court, and yet it is used against you on the immigration side. And so I think the thing that, I try to impart on to my students is, one, to really think creatively about how the two systems interact and how we can really challenge that in individual cases, but also at different courts, right? And so this is maybe, to your point, a hopeful note as well, which is that, there's a lot of dark times in the enforcement of immigration right now. We're seeing so many individuals who are being detained, those who have criminal encounters, but also, like panelists were talking about earlier today, increasingly people who don't, right, are being swept up into our immigration detention dragnet. And so how do we challenge this, particularly where the rights of people who are in detention to get out of detention are being eroded through things like the Lake and Riley Act that expand mandatory detention, things like Board of Immigration decisions that have come out over the last couple of months that have similarly increased the number of individuals who are subject to another type of mandatory detention that had been little discussed previously, right? Who are now no longer eligible for bond hearings. So how do we challenge that, and how do we do that creatively, right? How do we think beyond what's in the textbooks to figure out how can we leverage different court systems? How can we leverage different modes of advocacy to make this work? And one thing that we're seeing is that, at least, for us, we're very lucky to be in the District of Massachusetts, but federal district judges are really stepping up and holding that mantle. So anyone and everyone has been learning how to file a habeas petition. And there have been a record number of habeas petitions that have been filed. There was a spike under the first Trump administration, and now there's another spike now, because that's how people are are getting out of detention. And district courts, district judges are issuing orders immediately after receiving a habeas petition, stopping ICE from transferring individuals to detention centers in other states where they are far away from counsel, from family, and where their immigration court proceedings may be, the venue of the jurisdiction may shift, which changes it to potentially entirely different circuit's law, right? So immediately issuing orders to stop those transfers, and then also then ordering that immigration judges do in fact have jurisdiction to issue bond hearings. So either releasing the individual outright or requiring that they get process in immigration courts, right? So that's one avenue in which folks are trying to broaden the scope of advocacy to look elsewhere beyond the immigration system, the immigration court system, to vindicate the rights of individuals. And then thinking creatively as well, right? States can step up and are stepping up. And so there's been an increase in the number of pardon applications that are being filed and post-conviction relief applications that are being filed, so that we can try to vacate some of these convictions that are resulting in immigration consequences.
Thank you. And I could sit and talk to you all for absolute hours. You guys are a fantastic panel about everything involving crimmigration, but I do have one final question. I just want to leave a little bit of time for anybody out there to ask any questions. We have a fantastic group of people here. And my last question is for you, Professor Johnson, and really just going back to, back to your labeling and the U.S. shift from militarization to military and immigration enforcement. It appears new but reflects older cycles of control, but really, to what extent is this really new, or is this sort of militarization scheme something we've already seen before by another country that is now just being closed as a U.S. policy?
I'm not an international scholar, so I'm afraid I actually don't know the answer to that, which I was told by somebody is a great, that was a great answer, right? I don't know. Let's go figure it out. I wrote that down. That was wonderful. Yeah, like I said, we've been inspired. Let's say that the immigration system has been inspired by the military for a very long time. I think it might be made. I'm forgetting the book that talks about this, but it might be Impossible Subjects, where we talk about the very early Border Patrol being pulled, where the early members of that team were pulled from the military, had military backgrounds. We were talking over lunch about how there can be IJs who have military backgrounds. That's been around for a long time, right? Just seeing somebody's having good relevant experience to come in but then they're taking over a new role as a civilian employee of a civilian agency doing work with civilians, as opposed to what we are seeing now, which is directly empowering the military to engage with civilians. So that I think is the big difference.
Thank you. Well, again, I appreciate all of y'all's time. I appreciate, just the level of knowledge and the detail that you were, giving my questions, and really just being very descriptive on your guys' responses with such a broad concept that involves two very vast areas of law that are constantly changing in front of our eyes today, but bringing them together and what that means. And so I just want to say thank you again so much for, your time and dedication to this topic and coming to our symposium. Is there anybody in the audience that has any specific questions that we talked about today? Yeah, absolutely.
Question, and something that's always kind of perplexed me. I don't know who wants to answer this. The establishment's constitutional right, and it says that the remedies offer post-eviction relief. In a lot of states, you cannot get post-eviction relief because there's a requirement you still be incarcerated. And often that's a limitation that's in state law. So what's perplexing is the Supreme Court decision interpreting the U.S. Constitution, but what's blocking it from being implemented is a state statute. So I don't know, am I missing something there? It doesn't make any sense.
No, you're not missing anything, but I will say so when Kentucky is one of these states where you have to be in custody to be able to file this sort of traditional post-conviction petition. But there is a second post-conviction avenue that is, basically the equivalent of sort of the writ quorum nobis. Every state sort of has some version of this that can be used sort of to deal with sort of kind of extreme circumstances where it's, where it's different. So if somebody pleads, so for hypothetically, somebody pleads guilty to a crime that is an aggravated felony only by virtue of it being a 1-year sentence, but it's a relatively minor crime, and they're out of custody before they realize what's going on with them. They could file that, it's called a 6002. They could file that rule. It's, it's basically based on Rule 60 in the federal system. And that would allow the court to review it. Now, the thing that hasn't been answered, and so cert petitions of the future, is if a state says, no, we're not going to do that for this thing, what happens? That hasn't been, there's no answer to that question. But there are, I think every jurisdiction probably has some procedure to kind of set a judgment aside when it's unfair to have prospective application. And that is the procedural vehicle by which you would go to try to deal with the situation if you're not able to do the post-conviction remedy that you would otherwise try. Right.
But that hasn't been litigated.
No, like I say, there's, it's not terribly common to find people in that situation, but so far I'm not aware of any state that has said, we just aren't going to consider it no matter what, that would trigger the need to litigate the question.
If the Supreme Court makes a decision and you can't really put it in effect.
Right. Part of the reason it gets avoided is because if these are short sentences and then you're dealing with an immigration problem after that short sentence, oftentimes the person is now out of the country by the time this all happens. And so you have this very, the systems are, in Kentucky at least, we don't have the problem of sort of pretrial immigration detention for criminal cases. What happens in Kentucky is the immigration authority will put a detainer on the person. As long as they stay in custody in state court, and Kentucky's terrible about bond, they will, then, they'll stay in the custody of the state system until they basically served out their sentence, and then they get discharged, and then immigration picks them up. But for that person, you have some awareness and some ability to try to figure out, I need to file this post-conviction action while I'm still in the custody of the state system. But for other jurisdictions, I think it's much different. They pick them up pretty quickly, and then they're dealing with it, and they don't, as we've talked about, you don't necessarily have to be convicted of a crime for the immigration process to do its work. And even if it's based on a conviction for a crime, immigration can move fairly quickly and thereby prevent the actual effective ability to litigate it.
I know we have another question. We are out of time. We have our keynote speaker next, but I just want to say thank you again for our panelists. You guys were incredible. It was amazing to work with you all. I appreciate your candor and your information, and just thank you so much again for joining us today. Thank you.
Thank you, everybody.
Thank you.
Yeah, and to your last point, right, really what happens is that right, yeah. Well, once you get, well, that's good.
Yes.
Carolina. Yeah. Judge Martin, can you hear me?
Yes.
Okay, perfect.
Alrighty, everyone, we are going to begin with our keynote speaker, and Caroline Shackleton is going to introduce her today. Thank you.
Good afternoon, everyone. Thank you for attending the final session of today's symposium, and thank you for coming to listen to our keynote speaker. I am pleased to welcome Honorable Dana Lee Marks. Judge Marks served on the trial court bench at the San Francisco Immigration Court from January of 1987 through December of 2021. While on the bench, she decided more than 24,000 cases, at times handling a docket of over 4,000 cases. She is currently President Emerita of the National Association of Immigration Judges, which was the recognized collective bargaining unit for more than 700-member National Immigration Judge Corps from 1979 until 2022. Previously, she served as the NIJ president for 14 years. Judge Marks is also serving on the advisory board of the Justice Connection, a newly formed nonprofit which provides various kinds of support to present present and former attorneys of the United States Department of Justice as they navigate these tumultuous times. Judge Marks has published numerous articles and testified to Congress regarding the urgent need to restructure our nation's immigration courts to safeguard due process and judicial independence, and regarding ways to improve the efficiency and fairness of the system. The campaign to establish an Article I immigration court has been her passion for decades. Judge Marks taught immigration law to law students at accredited schools for over a decade, including 8 years at USF Law School, and now focuses her teaching on continuing legal education for attorneys and judicial education for state court judges, explaining the intersection of immigration law with criminal, family, and civil law. She is acknowledged nationally as a subject matter expert on the immigration courts and speaks frequently to the media in English and Spanish regarding immigration court issues such as due process, implicit bias, secondary traumatic stress, and burnout suffered by immigration judges working in the current overburdened system. She has described her work in the court, citing asylum cases as doing death penalty cases in a traffic court setting, which demonstrates the gravity and dysfunction of the system. Prior to taking the bench, Judge Marks spent 10 years in the private practice of immigration law and served as the lead counsel who successfully argued the landmark case of INS versus Cardozo Fonseca, which established that asylum applicants need only satisfy a more generous reasonable possibility standard to qualify for relief. She was a California certified specialist in immigration and nationality law from 1989 to 1993 and served on the State Bar Board of Specialization Advisory Committee on that subject from 1994 to 1998. She served as chair of the committee during her final year. Please give a warm welcome to our keynote speaker, Honorable Dana Lee Marks.
Thank you very much. And I know it's been a very intense, long day. So I hope that the tone of my remarks are going to energize you and cap off what has been an outstanding seminar. I have to admit, I got up at 6 o'clock in the morning, California time, to be able to hear the first panel and have tuned in off and on since that time. You've just heard a little bit about my background, but I always think that it's important to understand where someone is coming from. So I came to immigration law basically after wanting to be a social worker and not really knowing anything about the field. I found a job close to school after my second year because I needed money and I wanted to do some practical experience with clerking. And it was so serendipitous for me because the actual day-to-day practice of immigration law was perfect for my personality and what I like to do. High volume is fine with me. I don't mind having a bunch of simple tasks and then having something that I can really sink my teeth into. And that's what private practice is all about, especially when I began, ouch, 50 years ago almost, when immigration law firms often did a combination of both business immigration law, family immigration law, and deportation defense and asylum relief. I felt like the world was coming to my courtroom and to my office. And I learned so much about those individuals. And that to me made the work very, very exciting. Immigration law also, as you found out, is extremely complicated and complex. And so that also fulfilled my academic desire to be a skilled attorney and to keep those skills sharp. But a lot of the time, what I was doing was just help people navigate a system which was impossibly complicated and opaque. And people, especially if English was not their first language, they needed help to get through that. And I found that very, very satisfying. At the end of my private practice, the last year, one of the cases that I presented to an immigration judge in an application for asylum ended up being litigated all the way up to the US Supreme Court. I presented the case in immigration court to a judge I considered liberal, but it was soon after the passage of the Refugee Act of 1980. And it was not clearly established what the words well-founded fear meant in the asylum standard. And so this was one of the first cases that went there. I lost at the trial court level. I lost at the Administrative Appeals, Board of Immigration Appeals. And then we went in and petitioned for review at the Ninth Circuit, which is a known liberal circuit. And we got a wonderful decision. And I'd like to think it was selected for publication at that time because the judges felt it was well prepared and addressed the issues in a way that they felt was the right way to analyze it. Of course, we didn't want the case to go to the Supreme Court because we'd won. And for our client, you wanted to stop there. But because I had been her attorney from the beginning, I was selected to do the oral argument, and a team of 4 of us worked on the Supreme Court brief. And that was one of the most rewarding experiences I had as a lawyer, because this team of my other 3 colleagues on the team was Bill Heng, a well-known law professor and one of the founders of the Immigrant Legal Resources Center, which is known nationwide for their community outreach and materials teaching both community members as well as attorneys about immigration law. The executive director of that organization, Sue Leiden, was part of the team, and one of my law partners, Kip Steinberg, was on the team as well. And we divided up the case into 4 areas, drew straws, and because I was getting to argue the case, I drew last and got the short straw, and I was assigned the 2,000 pages of legislative history of the Refugee Act of 1980. You know, the expression about watching sausage being made, you'll be a vegan for life. Well, it's kind of that way as well. I got an inside view of how much Congress didn't understand the nuances, how the various people testifying and making the congressional record would explain positions as if they were the gospel when I didn't think they were so clearly established, but whatever. We came up with our first drafts. It was 80 pages long, and it had to be pared down to 50 pages. And that was where I learned. We went concept by concept, paragraph by paragraph, ultimately line by line to tighten up our brief. And I am very proud of that Supreme Court brief because it ended up being the roadmap for the successful decision in INS versus Cardoso Fonseca. 480 U.S. 421, for those of you who might not have heard about it. And what it established was that well-founded fear meant just what it said. Fear is very subjective. Well-founded means it's not paranoid, it's not far-fetched. So all someone needed to show was good reason to fear in a context that objectively made sense for them to do that. Not what the government was advocating, which was a showing that it would be more likely than not for someone to be persecuted if they were denied asylum. Knock on wood, it is still good law today, and I hope it remains that way. Earlier in your presentations, there was reference to international law. One of the things I was thrilled about in the Supreme Court decision was how much focus was given to the international standards and how the intention in passing the Refugee Act of 1980 was to harmonize our domestic law with international law. We have not lived up to that promise, unfortunately, but it's still there in the Supreme Court decision and something that we need to continue to fight for. So the immigration courts, because I know we've got a mixed audience with how much people know about the structure, we are the trial level administrative courts where if DHS, the prosecutor, asserts that someone is not a citizen of the United States and is not in legal status, that person has the right to go to court, and the government has the burden of proof on those 2 issues, that you're not a citizen and that you don't have a legal status. After that's established, and frankly, in 95% of the cases, it was admitted, because if someone isn't born here, how are they going to rebut that presumption? Right? You rebut it by showing a U.S. birth certificate, which people didn't have. The focus And the main focus of our cases was, is there some kind of collateral relief available under the Immigration and Nationality Act that people can qualify for? And that is in essence a defense to deportability or removability as it's now known, and that could solve the problem. So we spent a lot of time doing that. When a non-immigration lawyer walks into an immigration court, I analogize it to going to a carnival funhouse and walking into the Hall of Mirrors, where everything is somewhat familiar but incredibly distorted, and you kind of feel a little nauseous because you're losing your bearings. No Miranda rights, despite the incredible stakes, death penalty cases for asylum seekers, but long-term exile for lawful permanent residents, because permanent residence is really a misnomer. It's not permanent. You can lose your status if you are commit a crime or become subject to the other almost 40 grounds of removability that exist to prevent someone from maintaining or retaining status. So the stakes are incredibly high, but there's no right to appointed counsel. And in fact, 60 to 80% of the people who come before immigration court, especially the high end are those who are detained, do not have legal representation. And that's despite the fact that immigration law is routinely compared to tax law in its complexity, although I say it's more complex because there's no TurboTax for immigration law. There are no binary choices when you try to strategize how you're going to proceed. And then the burden of proof to gain your status is on the respondent. 80 to 90% of the individuals who come before the court do not speak English well enough to proceed in English. They proceed through a foreign language interpreter, despite the fact that the forms that they must present to the court are in English with no translations available easily. And any documentation, any supporting documentation that's presented has to be translated into English. So imagine how many people don't have the facility to be able to do that. And then some of the concepts that were developed in general law really are challenged, I think, when you put them in the immigration court setting. Credibility is incredibly important, but the law on credibility has been often established in other areas by two witnesses to a car accident, one who has an unobstructed view and has 20/20 vision, and the other who has cataracts and a tree in front of them. And you get to decide who has a more accurate representation, right? That doesn't happen in immigration law. We have often one witness, the respondent themselves, testifying about something that happened to them in a foreign country, in a foreign language, where things that may seem a little unusual to an immigration judge, and therefore, when you get into plausibility, maybe a bit questionable, but that's because they're coming from a different culture. They're speaking a different language. They may have a third grade education, as was often the case with people coming to my court. And they've never been in court before, so they're incredibly nervous. And their credibility is assessed by the consistency with statements that they have given at the border after a horrific land transit to the United States, at least in California. That's how we see a lot of these people. They're often suffering from post-traumatic stress. Even if they weren't persecuted in their home country, the trip itself to the United States is trauma-inducing. So it's very, very different than the way the law has developed in other fields. And then you look at the high volume. The reason I compare immigration court to traffic court is the high volume of cases. You heard that at times I had a caseload of 4,000 cases that I am balancing. The rapid pace of presentation, which is expected. Hearings typically last from an hour and a half to maybe a maximum of 4 hours in the allotted time that management has decided would be adequate. So it's very difficult to present your case in that context. And I describe the judges as being like the guy behind the curtain in The Wizard of Oz, doing 10 things at once. They're monitoring the technology. They're making sure that the record is being recorded because there aren't court reporters. It's all technologically, digitally recorded. You've got to watch the parties and make sure that the microphone is picking up all of those people. You've got to watch the interpreter and make sure that the interpretation is coming through in a reasonable fashion. So the judges are juggling all of these things. And at the end of that hour-and-a-half or 2-hour hearing, the judges engage in what I like to call extemporaneous performance art. They had to render a decision which stated the salient facts, the applicable law, and then how they find the law interacting and yielding the conclusions that they reach. So it's very, very different from what most people expect to find. One of the passions that I have had that I was able to work on because of my union status, and let me digress a bit to kind of explain that. The statute says that immigration judges are attorneys appointed to serve as immigration judges. Every judge I know believes that once we are selected, we are judges, and we should meet those judicial standards. The Department of Justice, however, has long taken the position, we're just attorney employees. We're supposed to follow orders, or we can be insubordinate and be disciplined to the point of being fired for not following our supervisor's directives. But because we are attorney employees, the National Association of Immigration Judges was certified as a collective bargaining unit for 40 years. And it was only under Trump 1 that our certification was challenged, wrongly, I believe. And the union officials lost the ability, which had been provided previously under our collective bargaining agreement. The Department of Justice prohibits immigration judges from speaking to the public. You have to give them a script and get permission, and often that permission is denied. Even to talk to a middle school class about a career path. I've known judges who have been denied the opportunity to do that in their kids' cases or in their kids', presentations. So using the union label, I was able to speak to the press and to speak to Congress and to advocate that the immigration courts, both trial level and the appellate level, which is the Board of Immigration Appeals, that those be taken out of the Justice Department, because it's an uncomfortable fit for a neutral adjudicator, an adjudication system, to be housed in a law enforcement agency. And Congress has structured the law so that immigration judges are charged with being neutral, with developing a record, with even going farther than some judges are required to go in other settings. We're supposed to help develop the record and delve into areas that especially someone unrepresented may not think about. So we've got this dual role. And the reason I was president for 14 years was because I'm not good at shutting up. I will row with the boat if I'm outvoted, but I need to state my opinion before that, or otherwise I'm a rebel and can't follow those orders. So it was the hardest adjustment for me, frankly, going from private practice to being a judge, was not the tremendous moral burden of how you decide your cases. That wasn't the worst part for me. It was working for the Department of Justice and feeling like the department epitomized what often is described in organizations as a headquarters field office disconnect. There were decisions that management would make about how our dockets, often called our calendars, should be arranged, how many merits hearings we should have, how many master calendars, which are arraignment type hearings, how many continuances we should grant. I always felt that the quintessential skill of a successful judge is being able to handle your docket in a way where you maximize your time in court. And that means allowing me to push certain cases back when I don't feel they're ripe, and to bring forward cases that are ready to be heard. And I feel long term that is judicially economic, because you're not going to have a series of appeals because some benefit under the immigration law has matured a month after you've rendered your decision in the trial court. And that's because the way the immigration law is structured, certain benefits that people are entitled to, like if you marry a United States citizen, you come on a student visa, you marry a US citizen, it's the real deal, you're applying for permanent resident status, but you dropped below your normal caseload in school. So you violated the conditions of your student visa. You could be brought into immigration court as being removable. But the process of getting your lawful permanent resident status based on your marriage is a two-step process, with step one being called a visa petition that only Citizenship and Immigration Services has authority over. Immigration judges don't. So we have to wait until that processing happens. Why should I push your case to the front of the calendar when I know that that relief may ripen? Why should I push to the beginning of my calendar an asylum case where an attorney tells me we are working overtime to get documentation from the home country, but getting through the bureaucratic system to prove that this person had been incarcerated there is taking months, and that's the estimate that we're getting from all the experts as to how long it's going to take? Why push that case forward? And yet, that is what happens when you are in a law enforcement agency. So I have long advocated that a concept that first was floated in 1980 by the Bipartisan Select Committee, or Commission, I believe it was called, on immigration, which is to create an Article I immigration court. That basically means that we would no longer be within the Department of Justice. The Attorney General would not be our boss. We would not be subject to political policy choices, which the Attorney General, as part of the executive branch, is rightly concerned about. But we would be more like the tax court. And the history of the tax court is instructive as well, because initially the tax court was part of the Internal Revenue Service. So the prosecutors came from the Internal Revenue Service, and so did the judge in those situations. And the poor US citizen fighting their tax issue was kind of outnumbered. And it was pretty clear to me that the boss of the prosecutor should not be the boss of the judge. And there has always been an incredibly close connection between the enforcement arm of the executive branch, whether it was the INS, which was in DOJ and overshadowed the immigration courts, or whether it was when DHS was created. And frankly, one of the big accomplishments of the union was to keep the courts out of the Department of Homeland Security, because initially that was what the Department of Justice was pushing for. We fought to establish Article I at that time, but it was clear that it was not realistically achievable. And so we switched and said, okay, keep us in the Department of Justice. Let's hope that the Department of Justice lives up to its name and dispenses justice and does what is fair and is not unduly influenced by the enforcement arm. Unfortunately, that did not hold up. And The classic example that I use for that is in 1996, immigration judges were granted contempt authority by Congress, but it couldn't go into effect until there were implementing regulations. Because of the opposition by what was then INS and which is now DHS, they didn't want fellow government attorneys, yeah, us immigration judges, holding their trial attorneys, their prosecutors, in contempt. And so we've never, in over 30 years, had contempt authority because no one will promulgate a regulation. That to me says it all. So we've advocated for Article 1. We were successful in persuading Congresswoman Zoe Lofgren, who started her career as an immigration lawyer. So she really understands the nuances. She introduced the Real Courts Rule of Law Act in 2022. It passed committee, but it did not get a floor vote. And that would have established this Article 1 independent immigration court, which would free us from the political whipsaw that has undermined the immigration court and gotten us to the position we are in today, I believe, that's created this tremendous backlog, which is in part because the Department of Justice wouldn't go to bat to adequately fund the immigration courts. I found the statistic somewhere. In the current budget, the immigration courts get about 3% of the immigration enforcement compared to what immigration enforcement gets. And yet it's logical that cases are going to end up in immigration court. And this has been traditionally the problem. So we don't have someone advocating for our best interests for funding. We don't have someone protecting the decisional independence of the courts adequately, in my view. So we need Article 1, and you guys have to get it. You're the ones coming into the field. It just is common sense. I believe it's not a partisan issue because it's not going to affect what the substantive immigration law is. It's procedural adherence to the rule of law, to due process and fundamental fairness. And I've often said that it's important if America wants to prove to the world that we are a paragon of justice and we treat individuals fairly, we have to walk that walk in immigration court, because that is often the only face of American justice that these individuals are going to see. And I've found that even if you rule against someone, if you have the time to clearly explain to them what the law is and why they didn't meet the standard, and allow them to have their day in court so that they feel that they've explained to you what their problem is and that you've heard them, they'll accept it. They may not even appeal your decision, but even if they appeal and they lose, I feel like when they ultimately go back to their home country, these people will be allies of the United States, not enemies. And I think that is extremely important in the overall big picture of where immigration fits. You've heard other speakers talk about how the immigration laws are 30 years out of date. And that is because it has been such a political hot potato. It's often called the third rail, just like Social Security reform is the third rail of politics. Immigration law is right up there as well. And I feel that the American public has been sinfully misled about the realities of immigration and how much non-citizens contribute. For years, you have been told, go back and do it the right way. The right way barely exists anymore. You are told that non-citizens are filling up our welfare rolls. Not true. They don't qualify. They pay into Social Security often and never claim back the money that their employer withheld because they didn't have legal work authorization or they were using a phony number, but that money still went into our pot. Immigrants and these statistics that I'm debunking are proven by academic think tanks rather than by media outlets and propaganda. Non-citizens do not commit crimes at a higher rate than Americans. In fact, it is lower. And additionally, we're not being invaded by refugees or non-citizens. The historical rates are not out of whack to what they have been at high points in other times. So it's important that the American public understand and start pressuring Congress to reform the immigration laws, to modernize them, to recognize the realities. And I'm going to talk in a minute or two about how frustrating the Trump administration, both 1 and 2, but especially 2, has been to me in terms of what they're doing with immigration law. But I think the one silver lining is the fact that immigration law is impacting your average Joe citizen in a way it never has before. You know, when I never took an academic immigration law course because it was only offered every other year at my law school, which was, University of California School of Law in San Francisco, known as Hastings back then. I learned from practicing lawyers and monthly seminars that taught me the ins and outs, and I learned on the job. Other than having that kind of experience, most Americans don't understand the realities and are shocked when the wonderful young man who volunteers at the church to do the gardening because the parishioners are older and can no longer do it, when all of a sudden he disappears because he was undocumented. When the wonderful, compassionate caregiver for your grandma all of a sudden is put in deportation proceedings, removal proceedings, and there's no way for you to stand up and help her or sponsor her, despite the fact that she's been a devoted and essential employee for your family. Nothing you can do about that. And even people who legally have a category that they can qualify for to get lawful permanent resident status, those categories are subject to quota limitations. Do you expect an employer to sponsor somebody where the visa won't be available for them for 20 years? I am not exaggerating. There are some categories that are backlogged 20 years from the date of application because the numbers are so restrictive. So the silver lining, if there's any, is that hopefully the American public in a greater number will understand and rally Congress. And that certainly has shown itself to be true with the outcry that we see with the random arrests, with family separation, with some of the worst of the Trump tactics of bypassing the immigration laws completely, cynically misinterpreting terms of art that for years had established meanings, like entry without inspection. That used to mean that you were present in the United States without official restraint. Now they are conflating that to being an arriving alien, which in the old days meant literally you were at the border, and arriving aliens had less legal rights. No right to be free from detention, to bail out. They weren't allowed that right. Then the law changed and they were put in expedited removal proceedings, which means they don't appear before a judge. It's an immigration officer who decides what is happening. It happens in such a rapid fashion that people don't even have the right to consult counsel, even pro bono counsel. There is no written transcript that occurs at those proceedings. So even though a judge may review the proceedings, if someone is shown to have not demonstrated sufficient cause to be allowed to present an asylum application, there's no written transcript for the judge to review to see if the right questions were asked or if the right lines of inquiry were followed. The envelope has been pushed so far by the abuse, I believe, of executive orders to bypass Congress, by trying to foreclose the right to a hearing before an immigration judge, where at least you have the basic due process right to present your case and to hear the arguments against you, and if you're lucky enough to find an attorney to represent you. Instead, the focus has been on what is called an expedited removal proceeding, which gives people no time to gather evidence or not. The atrocity, in my mind, of, again, abusing well-established terms. A national security threat is an action or a situation which jeopardizes the safety, security, or well-being of the United States. Drug cartels are not challenging the national security of the United States. They should not be categorized in that way, which deprives them of incredible amounts of rights. Calling gang members terrorists. Again, that is defying the traditional definition of a terrorist as someone who employs the unlawful use of force or violence against person or property to intimidate or coerce the government or the civilian population. So are you telling me that the Tren de Aragua, even if they are here in massive numbers and engaging in criminal activity, that they are terrorists? I don't think it meets that definition. You've had discussions earlier on today about the Alien Enemies Act. That requires the government of a foreign nation to wage a predatory incursion. How does that fit? Not at all. The cynical use of anti-Semitism as a justification to chill the free speech of non-citizens and allege that therefore these individuals have violated their legal status. I'm Jewish. I'm pretty sensitive to anti-Semitism. It's being abused. It's being thrown around, I believe, cynically in order to achieve the end that the Trump administration and its supporters want, to cut off any immigration to the United States, especially if it's from brown or black people. The Trump administration has gone even further and terminated legal statuses abruptly so that people who have done the right thing, gone the right way, were paroled into the country to pursue asylum, all of a sudden have their parole document revoked, and then they're out of status. And then with this cockamamie interpretation about arriving alien, they're thrown into expedited removal proceedings. The cancellation of temporary protected status to so many of the individuals in that process. Many of you probably don't realize that as recently as October 30th, an interim regulation, an interim rule was published, which ended the automatic extension of work authorization for a large category of people who had previously been authorized to work. It used to be that you'd get an automatic extension. Initially, it was for 180 days. It was expanded to 560 days at one point because USCIS was so backlogged in just the processing of it. Well, I talked about the student who, if they work without authorization, their authorization may have expired and they continue working, or the authorized professional worker, someone who holds an H-1 visa, which you may have heard about for professionals. If their work authorization ends and needs to be renewed, they can go out of status because USCIS doesn't get to their extension, which they are fully entitled to, but doesn't make that decision in a timely fashion. And then these people have all these collateral consequences that dramatically undermine their ability to legalize their status in the United States. The disregard of court orders that is happening with the rapid removals. That's another horror that we've never seen before. The fact that people have to resort to habeas corpus. I was a pretty successful immigration practitioner for 10 years, got to the Supreme Court, but never did a single habeas. It wasn't needed. People were able to have a bond hearing before an immigration judge, and you appealed that to the Board of Immigration Appeals. And generally, if you had merit to your argument, you'd be released. You would not be detained indefinitely. And that is an artifact, I believe, of the private prison complex and like the military industrial complex back 20 years ago. I think it's the private prison industrial complex, which has fostered legislation to criminalize non-citizens in a way that requires mandatory detention so that they can make tons of money. And Stephen Miller, one of those big advocates of being hard on immigration law, has substantial holdings in private prison companies. Okay? You tell me that that's not part of the reality that is influencing the law. Even going down to the lack of transparency that Doge created and the use of the databases from Social Security or the IRS or even the post office, using that as a way to find individuals who may be out of status. Those, I think, are offenses against the rule of law that any red-blooded American who's read the Constitution should find disturbing, right? If we don't have laws, we have chaos. We don't know how to treat people. We don't know what's acceptable or not from a general social perspective. That's what law is supposed to help guide us with. And I am also heartbroken, frankly, about the decimation of the civil service. I spent many years of my career trying to recruit private practitioners to take a job with the government because there was a lot of hesitancy. When I started out and got my job in the mid-'80s, I was one of the first, if not the first person with a private practice background to be appointed as a judge, because it used to be a career path progression. If you were a good prosecutor for the INS, you'd be rewarded by a promotion to being a judge. And I felt like we needed a balance in the core in order to be fair. So I see you all in the audience, who I only can see figuratively. Your job is to defend the rule of law and to remember the fact that history has shown us that the most vulnerable are the first to be exploited and lose their rights. Those are the immigrants. And that very soon thereafter, if we allow their rights to be degraded, the rights of United States citizens and the rule of law will be irreparably damaged. So please do your part to keep America as a beacon of justice and as a compassionate nation towards refugees, because I think that is our history and that's our showing our better selves. So that's my unpaid political announcement. I'm ready for questions if there are any. And Ben, you may need to help repeat them for me because I'm not sure I'll be able to hear them from the audience otherwise.
Yes, ma'am. Can you hear me, Judge Marks?
I can hear you.
Okay, I think we have time for maybe one question, if anyone's got one. I have one quick one, Judge Marks, if that's all right.
Sure.
And then we'll probably have to move on to closing remarks, but there is a lot of data that's been collected regarding inconsistencies of asylum applications that are granted and denied in different immigration courts. And I was just curious if, based on your advocacy for making immigration courts Article 1 courts, do you think that would help stabilize some of those inconsistencies?
Those studies drive me somewhat crazy because no other group of judges has been analyzed. And so how do we know that it isn't just a function of being a judge? Asylum law is incredibly complicated. I counted once, there are like 7 or 8 points that you have to establish in order to qualify. So I believe the proper metric for deciding whether a judge is following the law properly or not is their reversal rate on appeal, right? There are so many various factors. Is the person represented? Are they detained so it was a rushed hearing? Is it a country that we are generally favorably inclined towards? Or is it a country that we criticize no matter what? You know, when you look at the statistics historically, the asylum grant rates are higher for countries that we have accused of being human rights violators. And when we have not made an official political finding of that, even if conditions in that country by experts are equally bad, you are not going to have that same high level of grants. So it really troubles me to look at it that way. But also the short answer is Article 1 is going to help that because you are going to attract a higher caliber of applicants for the job. The added prestige is going to make the job more attractive to people. It won't just be immigration law nerds like me who signed up and stayed there for 35 years. And I think that that will be a benefit to the system.
Thank you so much for your keynote this afternoon, Judge Marks. Let's give her a big hand.